All right, I think we can get started. Ms. Rivers, good morning. Are you able to hear us?
Good morning. Yes, I am.
Great. I don't think we're getting anything on the record right away. I just want to make sure you were connected with us.
Yes.
So we've got several calendars today. We have a plea and arraignment and a plea calendar at 9, and then final plea at 9:30. My thought is we knock out the plea and arraignments that we can, and then turn to the pleas. I don't know if Kimberly Cole is here. So position 1, if we're going through all the way down the plea and arraignment calendar, position 1 already there's a waiver. Is Ms. Nix coming?
She is. She was stuck waiting on a train, and she said that it didn't look like there were any trains going southbound. So
well, darn. Okay. You're the state for right now. Excellent. So Mr. Tank has waived arraignment. His lawyer and he were excused. Kimberly Cole is next. She's not excused. I don't see her here, but we'll go through this calendar one more time. Would that be your case, Ms. Rios, or yours, Ms. Wood?
Mine, Judge, and I did attempt to speak with her and did not get a return phone call, so.
All right.
subject to notice, and I know the court's going to call the calendar again, but the state will request a bench warrant.
All right. Thank you. Cordarius Sanders. He's here. Okay. Let me look something up while we are doing that. Let's see. Sorry to keep you standing there. Where's Mr. Sanders? Okay, I'm sorry to keep you waiting. Ms. Rios, good morning.
Good morning.
You're representing Mr. Sanders?
Yes, Judge.
Okay, Mr. Sanders, I'm Judge McBurney. I don't know that we've met before. Today is your arraignment day. Have you two spoken? Do you need to speak with him first?
No, we spoke on the phone
Great.
today.
So is Mr. Sanders waiving arraignment?
Yes, we can do. I'll file a waiver after court.
Okay. Do you have good contact information for Mr. Sanders?
Yes.
All right. It says in the system, I'm not particularly worried about it, that there are active warrants for Mr. Sanders.
Okay.
It looks like they're from 2015.
Mm-hmm.
So we should work to clear those up.
Yes. Do you know what they're from? I do have a note here that there's warrants.
When you say what they're from,
2015. So it wasn't on this case.
I hope not.
Yeah.
I'm going to look this one up in a minute, but it lists aggravated assault, possession of a firearm, robbery.
Okay.
All from May of 2015. And there's some from they're all juvenile court warrants.
Oh, okay.
They're open. I don't want that to trip Mr. Sanders up. Different judges have signed them. But they're all that. In fact, there's some from 2014 even. So if you would help Mr. Sanders look into those. I don't know that I'm happy to clear them out. But I don't know how that works with juvenile court.
Yes.
So it's in Odyssey, so you can look it up at the appropriate time.
Court warrants, can he clear them or?
I don't know, it's in the text message.
Okay.
Hey, Mr. Sanders, I want to make sure we're able to keep track of you. Do you live on Peoples Street? Is that a good address? That's what we've got in the system.
No, sir.
Okay. Pardon me?
I said I can be there.
Okay, well, actually, you're going to give it to Ms. Rios, and she's going to do a change of address form for you. So she'll do a waiver of arraignment, change of address. I'll do a scheduling order, and that will move the case along. Let me check one other thing here. Okay, nothing funky in your bond. So, Ms. Rios, if you'll just make sure you've got the good address for Mr. Sanders, we'll get that change of address form from you. You're waiving his arraignment. Do you need Mr. Sanders to stick around beyond that?
Just one second. I just want to talk to him for a little bit.
Okay.
Excuse me, Judge.
Yeah.
You can tell me about the warrant. If you were talking about,
Tell you about the warrants?
I got warrants.
Yeah, I don't know much about them other than there are about 10 of them in the system from when you were a kid. Not that you're real old now. They're just listed as active. I'm not taking you into custody, but we're going to want to clear those up because in theory, if do you drive? Okay. Well, if you jaywalked and an officer said, "Hey, what's your name, young man?" and you gave him his name, he might lock you up because of those warrants, and those warrants are 8,
How does he get the juvenile?
Yeah.
10 years old, 9, 10 years old. So Ms. Rios can help with that. I'm happy to help with it as well if we can figure out what if they got dealt with. So I don't know if you ever went to juvenile court way back in the day, but the warrants are still showing as active. And that just puts you at risk of being arrested when you don't need to be arrested. So what you want to do is stay in contact with Ms. Rios. So if you've got a good phone number, make sure she's got that. And then she can help you figure out, and like I said, if I need to get involved, I will, how to clear up those warrants. Because juvenile court doesn't have jurisdiction over you anymore anyway. And the statute of limitations is run on all that stuff. So we need to get that cleared up. Okay? Did you put a good address on there? All right, so sit tight. I'm going to be done with this calendar in a minute, and then Ms. Rios is going to talk with you.
Okay.
Anything else, Ms. Rios, on behalf of Mr. Sanders?
No, Your Honor.
All right, Ms. Willingham, anything you want to say about the case?
Nothing from the state.
Okay. All right. Carrie Arnold.
Judge, this will be my case. I do not have a good number for her, and I will note it was dismissed at prelims for no officer showing up. But she will be mine if she shows up.
Okay. All right. Cotter Wright. Mr. Wright. That'd be a Rios or a Wood case.
I spoke with him and he hired.
Is that I thought that was the one that a defense attorney filed in yesterday. Yes.
Oh, yeah.
already
Okay,
waived.
it says position 7, but it's position 5. Got it. So, Jonna Lee, is that a private attorney? I guess
Yes.
so. Okay, now I get it, because I couldn't find a position 7. So Mr. Wright's lawyer has waived. Let's see who this person is.
Yes, Jonna A. Lee. I've never worked with him, but
Yeah, me neither. That's one fewer case for Ms. Rios.
yes.
And a change of address. Very impressive. All right, so substitute counsel. Oh, that was you barging into the case. Okay, let's see.
Yeah, I did that before.
Yeah, no, as you should. If it was going to be a Miss Feely case, then it's yours. Yep, John O. Lee on Broad Street. Okay.
Just restart it, yes.
Yeah.
Oh, shit.
Wave and sketch. Okay, and then that gets us to Geneva Stevenson.
Yeah, Judge, I spoke with Miss Stevenson. I do expect her today.
Okay, we'll hold. Let me try one more time with Kimberly Cole. All right. What I will do is bench warrant for Ms. Cole and Ms. Arnold. If they show up during the course of one of these pleas, I can always undo that. And then we'll hold for a little bit for Ms. Stevenson, since you did have contact with her.
Thank you, Judge.
Sure. All right, so Ms. Rios, if you want to connect with Mr. Sanders now, we're gonna shift to, can we do Cozart or do we need Ms. Nix for that? I noticed one of the cases was yours.
I am aware of only the one, so I'm
Okay,
not really
the
sure.
big ones
how
are
it-
Ms. Nix. I know
Correct.
you were trying to do it yesterday and didn't
However,
work out.
Judge, I have something we can do.
Okay,
If the court will allow, Miss Quinchella Pitman is on the Zoom, I believe,
yeah, QP, I saw that.
and I will get you the case number. She was, my client who we were trying to plea on May the 2nd for that add-on calendar, and I didn't have good contact.
Okay, is she on a calendar today?
She's not, Judge.
She's a walk-in.
Walk-in.
That's all good. Okay, then we'll need to get everyone that case number.
Yes, so 23 SC 191694.
Okay,
I'm sorry, Lacey, can you say it one more time? 23.
SC 191694.
Okay.
Thank you.
Ms. Rios, while you're talking to Mr. Yes, Mr. Sanders, I'm getting word that the ADAs are the ones who clear juvenile warrants.
Okay.
So you may want to have your counterpart in juvenile court talk to ADAs who are active there to say, can we deal with?
That information.
Okay, great. Okay, you're a step ahead. Was Ms. Pittman's case, is that a Ms. Willingham case?
Yes.
Oh, we got everyone we need.
Yes.
Okay. And so you are offering up today this case for a plea.
Yes.
You ready for that?
Yes.
All right. Well, let's pivot a little bit. So good morning, pretrial.
Morning, Your Honor.
How are you doing?
Uh-oh, I'm good. I'm just getting my computer. Okay, there it goes.
That's okay. I'm just letting you know, we've got one that wasn't on any of your calendars. And so if you don't mind looking it up while we start the plea, that would be great.
Okay, is that for Miss Pitman?
Yeah, for Ms. Pittman, did you get that case number? Do you need other information to be able to look her up? Because we can give that to you now.
No, I got somebody looking for it and pulling it for me right now.
Fantastic. All right, thank you so much. Then let's do this. Well, I'm not sure. Is Ms. Pittman the iPhone that's on here or VQ?
I think she might be iPhone, Judge.
All right. Ms. Pittman, can you unmute your phone?
Good morning.
Good morning. I'm gonna spotlight you there and let's add your attorney. Oh, I gotta turn that camera on. That's weird.
Miss Nelson, I'm concerned. Yes, you're wrong over. Okay. Oh, you didn't hear from her before I called the victims because I didn't want he'll be on there tomorrow, right? So I have a couple.
What's on your screen, Ms. Wood? The big screen. It's not so big.
iPhone, the spotlight.
Okay. Odd. I can't start the video.
Do you need me at the podium?
I guess because I can't make that video go on. So that would be great. That way, Ms. Pitman can see you. I don't know that I'm gonna have any luck starting the prosecutor one either, but let's see.
I can go. Oh, well. Is that
Just
one
let me
on?
give it a try. I don't know. We're gonna have to get IT in here. Let's see.
Yes. Okay.
Yeah, that's not,
It's okay, Judge, if we don't have a camera over there.
you're in luck because it's not working right now.
Oh, so
Um,
sad.
Yep. So if you don't mind going up to the witness stand to do that. Great. All right. Ms. Pitman, can you hear us?
Yes.
Great. We're going to go on the record in your case. It's 23 SC 191694. My understanding is that you are prepared to enter a plea in the case. Is that right?
Yes.
Okay. You need to share with me that you are okay proceeding virtually. You're not here in court. You're where you need to be or want to be right now, which is okay as long as you tell me on the record that you're waiving your right to be here in open court. Is that correct?
Correct.
All right. You also have a right to have Ms. Wood right next to you so that if you've got a question, you could lean over and ask her that question, but she's here in court and you're not. Do you waive your right to have Ms. Wood by your side during this plea?
Yes.
Okay. If you have questions for her, let me know because she can step outside and give you a call on your phone and you guys can have a private conversation. I don't think you'll need to do that, but if you do, that's okay. You just need to tell me, hey, I need to talk to Ms. Wood for a moment. Will you do that?
Yes, sir.
Okay. In just a second, Ms. Willingham, who you can see on the screen, she is wearing the gray blazer. She's going to put you under oath. Once you're under oath, you need to answer all her questions truthfully and completely. All right?
Correct.
Okay. Ms. Willingham, when you're ready.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Please state your name, your age, and your date of birth.
One Shella Pitman, 310405 1993.
And for the record, Ms. Pitman, can you spell your name?
QUINSHELLIA.
Thank you. And Pitman is common spelling?
Yes. PITTMAN.
Are you now under the influence of any medicine, drugs, or alcohol?
No.
How far did you go in school?
10th grade.
Can you read and write in the English language?
Yes.
Have you had the opportunity to review the document that charges you in this case?
Yes.
Do you fully understand the nature of the charges pending against you?
Yes, I do.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Correct.
The negotiation in this case is that you would be entering a plea to the reduced charge in count 1 of battery family violence with 12 months probation, and count 2 would be null-priced. You would be required to complete the family violence intervention program, have no violent contact with the victim, complete 50 hours of community service, have no weapons, no drugs, or no alcohol. Is this what was explained to you by your attorney?
Yes.
You are pleading guilty today to battery family violence with a minimum of 1 day and a maximum of 12 months. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No.
You heard me tell the court what the negotiated plea in this case is, which is 12 months probation. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 12 months in custody?
Yes.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. Under the special conditions, as previously discussed, you would be required to have no violent contact with the victim, complete the family violence intervention program, complete 50 hours of community service, have no weapons, no drugs, or alcohol.
Yes.
Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No.
Are you satisfied with what your lawyer has done for you in this case?
Yes.
Do you have any more questions for your lawyer before we go on?
No.
Have you understood everything I have asked you so far?
Yes.
Understanding all of your rights, do you wish to enter a plea to this charge today?
Yes.
Is your decision to plead guilty made freely and voluntarily?
Yes.
Did you in fact commit the offense to which you are pleading guilty?
Yes.
Are you a United States citizen?
Yes.
If you wish to challenge this plea for legal error, you have one of 2 ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 12 months from the date the sentence is entered to file this petition. Do you understand these time limits?
Yes.
Your Honor, should the state proceed forward with this case, the state would prove beyond a reasonable doubt that on June 29, 2021, at 140 Pine Street, Atlanta, Georgia, here in Fulton County, at approximately 6:29 a.m., Officer Eric Wade of the Atlanta Police Department was dispatched to a domestic dispute at the location previously mentioned. The officer spoke with Johnny Stewart, the alleged victim, who stated that a female he shares a child with, identified as Quinshella Pitman, and himself were having a verbal dispute in the hotel room when she approached him with a knife and cut his hand as he was attempting to take the knife away. Officer Wade observed the injury to Johnny Stewart's hand and offered to go to Grady Hospital, but he denied the offer. Ms. Pitman denied using the knife and only admitted to throwing a speaker at him. She was then arrested for aggravated assault. Your Honor, I have had an opportunity to speak with Mr. Stewart. In speaking with him, he does state that the knife was present. Obviously, he did receive a cut. However, he stated that that his hand was actually cut as he was pulling away from the knife. And Ms. Pitman, as Your Honor recognizes, did acknowledge that she did at minimum throw the speaker. And Mr. Stewart has made it very clear that he also did not want to proceed forward. This is a case that Your Honor is aware we did attempt to get into adult diversion, as we thought that would be a better fit. But unfortunately, Ms. Pitman has used a first offender in the past, and for those reasons, diversion was unable to accept her.
Okay. And so family violence battery, you think, is a better fit?
Yes.
Okay, got it. Thank you so much. Ms. Hardy, did you or your team have enough time to look up criminal history for Ms. Pitman?
Yes, Your Honor. We're showing 2 arrest cycles in Georgia, felony conviction in 2015 for robbery where she received the first offender treatment and it was sealed in 2018. Nothing further to report.
Got it. Thank you so much. Ms. Wood.
Thank you, Judge. Ms. Pitman is eager to move on and put this behind her. I would ask, she shares a number of children with Mr. Stewart, so I would ask the court to consider waiving probation fees for the first few months, just to help her get on her way.
Okay. Ms. Pitman, I've got a couple questions for you, and then if you have any, it'll be the time to ask them. Do you and Mr. Stewart still interact because you've got kids together, or you guys still live together? Tell me what your connection remains with him.
Basically, we still together. We live in the same home, all that.
Got it. So you and he are the parents of how many kids?
4.
4. All right. And they all live with you guys?
Yes.
Okay. Are you working?
Not at the moment.
What's the age range of the kids?
Toddlers. They 2, 3, and finna be 5.
2, 3, 5. How old is the other one? You said 5 months.
I have a set of twins. They finna be 5.
Oh, got it. That adds up to 4 kids. Does Mr. Stewart work?
Yes, he does.
What does he do?
Security.
Okay. And you all aren't at the hotel at Pine Street anymore? Do you live in a different place?
Yes, we not on Pine Street no more. We at a different location.
Okay. Do you have any questions about any of the things we've discussed about your case?
No. If I do, I give my lawyer a call.
Great. That sounds like a good plan. Well, Ms. Pitman, I find that there is a factual basis for what you're pleading to, which is family violence battery, basically a physical fight between someone who is part of your family. That would be Mr. Stewart, the father of your kids. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea, and knowing means you've understood all the things we discussed. Do you agree with both those things?
Yes.
Okay. Ms. Wood, do you authorize someone on my chamber staff to sign the indictment?
Yes, Judge.
And for you, Ms. Willingham?
Yes, Judge.
Ms. Pitman, is it okay if we sign your name on the indictment indicating your plea to the misdemeanor?
Yes.
All right, we'll do that. So count 1 has been reduced to family violence battery. I'm sentencing you to 12 months. Those will be probated. The main conditions of your probation are: number 1, complete a family violence intervention program. That's a series of classes that should help you and Mr. Stewart figure out other ways to work through your disagreements. Number 2, you'll need to do 50 hours of community service. Although, if you end up getting a job and you can document that you are working at least 30 hours a week, then that'll be 20 hours of community service. So if you remain, I understand you're busy, you got 4 kids, but if you are not earning an income, then you'll need to take care of those community service hours. But if you do start earning an income, then you won't need to do as many of those hours. No violent contact with Mr. Stewart. That makes sense. You shouldn't want that from him. He doesn't want it from you. And finally, I will waive your probation supervision fees for the first 4 months of the 12 that you are on misdemeanor probation. Do you have any questions about any of that, Ms. Pitman?
No, I don't.
All right, Ms. Wood, anything else on behalf of Ms. Pitman?
No, Your Honor, thank you.
Have you and she talked about reporting to misdemeanor probation?
Yes, and I will confirm all of that after today.
Great. Misdemeanor probation is based about half a block from the courthouse. So if you know how to find the courthouse, you'll be able to find misdemeanor probation. Ms. Willingham, anything else for the state?
Nothing further.
All right, we're done. Good luck, Ms. Pitman.
All right, thank you.
Bye-bye. Well, Ms. Nix was here momentarily. Let me go back to our first calendar, see if anyone made it. Kimberly Cole. Carrie Arnold. And Geneva Stevenson. Ms. Stevenson is here. Ms. Wood said you'd be here. All right. Ms. Wood, what are we doing with Ms. Stevenson?
Judge, if we can come back to this one, I
Sure.
need to talk to the state.
All right. Ms. Stevenson, you should sit tight. Ms. Wood's going to talk with you and she's going to talk with the prosecutor. Do we know where Ms. Nix went?
She's still here because her phone is on the table, so
Okay.
she's not too far.
All right.
I think she may have went to like link up with the victims in Mr. Kozart's cases, I think.
Okay. Good morning. Sorry about your MARTA woes. We've got Mr. Kozart, and I heard Mayberry is going to be a plea. Is that accurate?
That is correct.
Okay. Is his lawyer coming here?
I
Can be
think
virtual?
He's going to log on Zoom at 11.
Oh, at 11. I see that on the calendar. So stop on Mayberry. Got it. Are we able to do Mr. Kozart's pleas right now, or do you need more time?
Just a few more minutes. I didn't get notice that he was gonna be here today and I was gonna let the victims know. So I just spoke with one of them. I'm gonna, about to call the other one.
Okay.
And just give them opportunity to speak if they want to.
Got it. I'm sorry for the confusion. I was told it got moved to today so you could get the victims here. So because it was supposed to be an Emerson thing yesterday, and it sounds like maybe the structure changed to non-negotiated. And because of that, you wanted victims here. And so then I was told, great, McBurney will deal with it today.
I think we weren't sure that it was gonna be moved to today.
Okay.
That was the issue. I was waiting to make sure so that the victims didn't, hang on the.
Yep.
on-
Are they able to join virtually?
The one that I just spoke to didn't care to, make a statement. I'm gonna speak with the other one in just a moment and I will let you know. They may not want to speak. I'm not sure.
Okay. Got it. And Ms. Wood.
just a caveat, yesterday when we were getting ready to plead there, it was going to be to only Ms. Nix's cases. I believe it's going to be to all 3 cases today.
Okay.
So I just need to give that update to Mr. Kozart really quickly.
Got it. Well, why don't you guys, so should we come back to it because you're trying to get someone else online, or should we get rolling because someone will get online?
Come back to it.
Okay.
And give me a chance to call one more person.
Okay. That is all good. Mayberry we're waiting on. How about Kevin Phillips? That may be Ms. Clark's case, and I know she is running a little late because she's less mobile.
And Judge, I believe, is this the gentleman that I think Ms. Feely had filed something on Friday? I need to look into.
Yeah, I think that's right. About clearing up a bench warrant, and I had said we need to all be in the same room for that one.
So I think he will be mine. I just need to speak to him. I was at the jail when those emails were exchanged on Friday. so
Okay.
She was filling in for me.
Why don't we hold on that then? Because we need Ms. Clark also, and I think she's gonna be here. She just it is gonna take her a minute. So why don't we turn to the final plea calendar? Of course, the first case is Ms. Clark's. Is Mr. McGriff here?
Good morning, Your Honor. David Schnipper for Mr. McGriff. He should be there. He was told to be here today. His mother did call and left a message or offer, said they would be running a little late.
Okay.
I was retained yesterday on this case, filed my entry of appearance, measure for discovery, also a leave of absence. I had knee surgery in late April and will be back available for in-court appearances on or about the 15th of June. I've asked for discovery to be forwarded. I also filed a motion to have defendant's ankle monitor removed. He's had it on for around 3 years. Miss
Right.
Nelson had shared with me yesterday, unbeknownst to me respectfully, I think there was a financial matter between the ankle monitor carrier and defendant. I did not know about that, but when I saw that he's had it on for about 3 years, I I figured it wouldn't be a bad move to file a motion to see if we could get it removed. And that's my announcement, respectfully.
Okay, well, one, he needs to show up, so I'll give you a chance to track him down. Two, we certainly should talk about the ankle monitor because he hit my radar. Not today was supposed to be final plea, and we'll work through that because you're new to the case. I don't know that I'm going to necessarily put the brakes on the case all that much. He is deciding to switch lawyers this late in the process, not anyone else. But we also need to accommodate your medical leave. So I think we're going to be okay given what trial calendar he's on. But this ankle monitor thing, we do need to fix. It's not a county funded one. It is one that Mr. McGriff was supposed to pay for, and he hasn't. So he's going to need to make right with the ankle monitor company. But it has also been on him for a long time. And so I want to hear from Ms. Clark. But she is going to be a little bit late in getting here. So I don't know if you can hang loose and well, you need to find Mr. McGriff, I guess, and give us an update on that because I can fix his ankle monitor problem if he doesn't come to court today.
I understand. I'm going to call him right now and his mother. They should be en route, but absolutely, Your Honor, I'll be happy to just hang out until he arrives.
Okay, great. We'll do that. Thank you, sir. And welcome aboard. Next is Quentrell Jewell. Hey, Ms. Rios. So this is, I should have made clear, we're shifting to a final plea calendar. And Mr. Jewell kind of got off track because he disappeared, but he's back.
Yes, he's in custody.
He is.
Yeah. I wanted to continue negotiation with Ms. Nix. We were discussing this case via email, and I don't think we came to a conclusion yet. I believe his father should be here. Let me give his father a call.
All right. Well, today is the final plea date. So at a minimum, I'll need to bring him out and Ms. Nix can say, here's the current best offer. And he can say, no, thank you. That's okay. It doesn't mean you guys still can't resolve it. It just will change his ability to withdraw his plea if he doesn't like the sentence he ultimately gets. But we don't need to do that right away. If you and Ms. Nix want to talk more today, yes, that's fine. Do you have any discovery concerns about the case?
I don't believe so.
Okay. All right. So it's not one where, you know, one reason why I can't tell whether it's a good offer or not is I don't have the body cam, and that's the issue.
No, I don't believe so. I don't
okay. All right. Well, we'll come back to Mr. Jewell. Edward McGillicuddy. Hello, sir.
So, Judge, I'm going to speak with Ms. Nix and see if we can resolve this one today. If not, I would let you know there's a co-defendant that's still in non-complex.
I was just going to say there's a co-defendant listed here who is not here. Interesting. We only got, so did Mr. McGillicuddy get transferred to us?
Yes, and it looks like there was an order in April for the co-defendant to come our way as well, and it just hasn't made it here yet.
Huh. Okay. But your office would not represent Ms. Morkey.
Correct. She's got a private attorney.
Okay. Thank you for that clarity. But why don't you and Ms. Nix talk some more? And Mr. McGillicuddy, Ms. Wood will be circling back with you today, as in please stay here, because it could be your case can be worked out today, maybe not, but we have to have a conversation about that before you leave. Okay, thank you. I've never had that happen before where only half the case gets here. So there's a Kawana McMichael who represents her. All right. Odd. Okay, we'll circle back. 4 through 6 have been transferred to another judge. Terry Cummings, position 7.
Judge, I do expect him, so.
Coming through the door. Hey, are you Terry Cummings? You made it just in time. All right, Ms. Wood?
This will be a plea today, Judge.
All right. Do you agree, Ms. Willingham?
Yes, Your Honor.
All right, when you guys are ready, let me know. You need to stick around. Myandris Sweeney? Where? Right there. Hey, Miss Sweeney.
This is another case that me and Ms. Nix were discussing. We just need his time to talk and see if it can be resolved today. I'm not sure if it can be.
Okay, so Ms. Sweeney, Ms. Rios is going to talk with you, and we're going to figure out what, if anything, we're going to do with your case today, okay? Give me 1 second before we do the next one. So Ms. Rios, Ms. Sweeney has a warrant, but it's for this case. So hopefully we can clear all that up.
Yes, Your Honor.
You knew that?
No, I did not know about
Okay.
the warrant.
Yeah, I just looked it up because someone whispered in my ear, there's a warrant for Ms. Sweeney.
Okay.
But it is for this case.
Yes.
So we ought to be able to sort that out, whether we resolve the case or not today, because it's the same thing, but just help me remember that.
Yeah.
Because that could trip Ms. Sweeney up.
Yeah.
Down the road.
Definitely, yes.
All right. Erica Ragland. Hello, Ms. Ragland.
Sydney Gibson for Ms. Ragland, Judge.
Hey, Ms. Gibson.
ADA Willingham and I can work out a plea today. I do need to head down to 1C for a calendar call, but I'll be right back up. But I think we can resolve that today.
Great. As long as where you're heading is in this building, I'm fine with that.
It is.
So Ms. Ragland, I'm gonna have you sit tight. Just stay in touch with Ms. Gibson. She may be able to tell you, hey, you have a half hour to go get a snack or something, but do stick around here because you and Ms. Gibson and Ms. Willingham and I will need to talk at least one more time, whether we're working the case out today or not. Because we need to get something on the record, either, yep, we're working it out, or this was the state's offer and you're saying, no, thank you. And here's what that means. So we will, so when you guys are ready with a plea, tell me and we'll take it. Okay.
Judge, thank you.
All right. Jermaine Stanley.
Judge, he's in custody and I expect a plea on this today.
All right. We have a busy day.
And that's me, Judge.
That's you also.
Yes.
Okay.
Position one showed up to
Well, let me rewind. Mr. McGriff? You're Mr. McGriff. All right, we'll come back to you when we get to the end of this calendar. Your lawyer is relieved that you're here. So Stanley will be a plea. Valeria Quarterman, that's the VQ who's on the phone on here. Okay.
Good morning, Your Honor. I'm Rachel St. Fleur. I'm the attorney for Ms. Quarterman, Your Honor.
Hey, how are you?
I'm good. Good seeing you.
Good seeing you. Ms. St. Fleur, what are we doing? Today's final plea. So this is a chance for, if you and Ms. Willingham have sorted something out, for Ms. Quarterman to enter a plea. If she's not interested in doing that, which is A-okay, I need to get some things on the record, what the state's offer is, explain to Ms. Quarterman how things will be different after today as we move this case towards trial. What have you and Ms. Willingham sorted out thus far?
Your Honor, I think we've been at a standstill. I did receive an email from her this morning at 8 o'clock in the morning, but I had to take my daughter to school. But Your Honor, we're ready to proceed with trial.
Okay.
If need be, if need be.
Well, it may be that it's something short of that, but have you, Ms. St. Fleur and Ms. Quarterman, had a chance to discuss the contents of Ms. Willingham's email?
Yes, Your Honor.
Okay.
Not this morning, but every other email, yes, because Ms. Willingham and I, we've been communicating for about over a month now about this matter.
And Judge, I'm sorry to interrupt, but I would ask that she actually have a in-depth conversation with her client about it, because it's actually the same thing as what we've previously discussed. It just is a different title.
Okay.
So the DV division now has a program called Families First, which is our domestic violence adult diversion program.
Oh.
Ms. Quarterman was not accepted to our regular diversion program. However, it is my understanding that if a diversion program was available, Ms. Quarterman would do that. And that is what Families First is. So I recognize that I sent it this morning, but
Sure.
it's because I had to get some clarification on Families First.
How long has Families First existed?
We've only had it for a few months. And
Okay.
when it was initially brought to us, we were told that it would result in a misdemeanor. But when I called this morning, we are now allowing that to also result in a dismissal.
Got it. If successfully completed,
Correct.
just like adult diversion.
Right. We now have 4 different options. And I didn't initially offer Families First because, quite frankly, it wasn't. If you have the option of adult diversion where you get a dismissal and Families First where you get a misdemeanor.
Right. Who's going to do that?
Correct.
Yeah.
So now that it has been given as an option for a dismissal, it now makes a little more sense. I do still need to speak with Mr. Walton again, because he is the victim, and it would actually require both parties to participate, because in Families First, there is a portion where they have to do family counseling.
Sure.
So I can't obligate him without actually speaking to him again. And I called him early this morning, but I just found out this morning, so I know it was rather early. I don't have a problem following back up with him. The way I was able to finally get in touch with him was actually through Ms. St. LaFleur. So in my email, I also asked if she could kind of pass word along that if he could call me back, then I can completely say okay to that.
Okay.
But that is where we are. So.
Got it. Okay, that's a helpful update for me. Ms. St. Fleur, that may not be any news to you. I've never heard of the Families First, so I'm glad I'm aware of it. And I'm particularly glad that they've developed enough tiers that it can actually be an actual counterpart to the adult diversion, but tailored to the nature of the allegations. It seems like a great fit if that's something that Ms. Quarterman is interested in. Do you want some time to talk with Ms. Quarterman right now, or how do you want us? I don't mean to keep you guys on much longer, but if this is something you all have been discussing for a while and it just only now has been more thoroughly clarified by Ms. Willingham, I don't want to pass on this opportunity if that's the way Ms. Quarterman has been interested in resolving the case.
Your Honor, if I may briefly, I have no problems with speaking with my client, and I know that you have a long day, so I really don't want to sit here just to wait on the Families First, Your Honor, but I would like to just add one piece to this, is that, Your Honor, I know how the court is about the DV cases, and the state and now we've been talking about this, but Your Honor, the alleged victim has been very uncooperative, because and I wanted to make a verbal motion today, and I didn't have a chance to draft a motion to, if we can amend my client's bond, because it's no contact with her husband, and Your Honor, they reconciled. And her husband is actually the person who got her out of jail and that whole 9, but needless to say, I have no problems with discussing this with my client, Your Honor. If we could circle back maybe on another day or something, because Your Honor, you do have a full calendar. But needless to say, I have no problems with passing on the message for Mr. Bolton to contact the state. But either way it go, we'll be willing to proceed with trial if this does not work for them. But the the husband has been very adamant that he did not want to pursue this matter. But again, I know the position of the state, but.
Right. He obviously doesn't control that. But Mr. Bolton, husband, those are the same people?
Yes, it's the same person, Your Honor, yes.
Okay. And currently, Ms. Quarterman has a bond that says no contact with Mr. Bolton.
Correct.
Got it. Okay.
And the state has no objection
to modifying that?
Correct. Judge.
Okay. All right. why don't we do this? I don't want to keep folks waiting, but you can help move this along, Ms. Sanfleur, and you, Ms. Quarterman, since you'll be able to have contact with Mr. Bolton once I sign this bond modification. He doesn't have an ability to make the case go away. He may think he does, but he doesn't. And so if he is willing to join you in the little bit of counseling that would be an element of the Families First program, then the state is offering a non-trial resolution that concludes with the dismissal of all the charges. And maybe that's not something you're interested in, and you and I don't need to have that conversation, but I want to make sure you hear me say that. Because that seems like a reasonable approach. Obviously, you and Ms. Sanfleur need to decide that's a reasonable approach for you. And it's not my decision. I'm moving your case to the trial calendar. It will be on our July trial calendar. If between now and then, Families First is something that you decide you want to do, then Ms. Sanfleur needs to let Ms. Willingham know that. She'll submit the appropriate paperwork. I'll sign it, and your case basically gets put on hold. You don't have to come to court, anything like that. You take care of the obligations of a participant of Families First. And once you've done that, and you've given a limited amount of time to do it, it's not a forever thing. Once you've done that, then the state tells me she satisfied the requirements and the case is dismissed, and you're done. But that may not be the right fit for you. Ms. Sanfleur, if you will send a proposed order in Word format to Ms. Nelson that modifies the bond by removing the no contact provision, I will sign that the day I get it. And then you'll know, Ms. Quarterman, that you won't be violating your bond if you and Mr. Bolton are talking in the same place, doing whatever it is the two of you are comfortable doing. Do you have any questions, Ms. Quarterman, about any of the things we've been talking about?
No, I do not.
Okay. You feel like you understand what your options are?
Yes.
Okay. Then I'll move the case to the trial calendar, and Ms. Willingham, you'll let Ms. Sanfleur know as soon. I guess you and Mr. Bolton need to connect. That's the missing piece. And so hopefully they can nudge him to reach out to you.
Yes, Judge.
Okay. Anything else from the state?
Nothing further from the state.
All right, Ms. Sanfleur, anything on behalf of your client?
No, Your Honor, I'm just trying to get Ms. Nelson's email address, and then I'm asking if we can be excused.
So I'm going to send it to you in the chat.
Thank you.
There you go. It's top secret.
Thank you, Judge.
All right.
We have no further business with the court. May we be excused?
Yep. So, Ms. Quarterman, I will see you for the July trial calendar if this is not sorted out before then, okay?
Understood.
All right. Thanks. You guys are free to go.
Thank you, Judge.
The last position on the morning final plea calendar is Bobby Bradley. And I think we were going to have a bond hearing on that, but you didn't have a happy face on that.
Well, Judge, I just need some clarity. So
I can probably help because I actually have spoken with Mr. Bradley's defense attorney. I don't know.
Oh, it's not Ms. Wood?
It is not. I don't know if they're going to be present today.
Oh, wait, this is Mr. Render has dived in. He's in trial in Clayton County.
That's what I was just going to say. But when I spoke with them this morning, someone was going to try and get here because it was going to potentially be a plea to this case.
Okay.
But I don't know where we are on that because I thought that was odd because they're in trial. So I know it's hard to get away from trial.
Yeah, because he was supposed to be down in front of Judge Emerson, but he has a case in front of Judge Mack.
It was a co-counsel that was going to try and get over to do a plea. I'm not sure where they landed with it, but they were trying the case together also. So I don't know how that was going to work.
Okay.
But I am prepared to take a plea if need be, and I will reach out to them to confirm whether or not they're going to come. I know
Okay,
Mr.
let's do
Bradley
that.
has
We'll
lots
keep
of
Mr.
plans.
Bradley here. And maybe it's a plea, maybe we talk about bond.
Mhm.
All right, thank you. And I've written render on there. Interestingly, just so you know, his appearance says for bond only.
That's,
Yes.
Yeah, I don't roll with that, but that's what it says. So we'll see.
what I needed clarity on, Judge.
Yeah, but for now, it's a render matter. And it may be based on what Ms. Willingham said, he entered for bond, but it's a plea. All right, let's circle back to Mr. McGriff because his lawyer is still on. And we have, I think, Ms. Clark, are you now on virtually?
I'm here, Your Honor.
Oh, you're here. Okay. Like you were here. I saw you and then you were here. Great. We're going to talk about Mr. McGriff. If you want to get comfortable as you can up there. How's your foot?
It's actually my ankle. It's okay.
How's your ankle? It's okay.
Yeah.
All right. You're at the podium. That's okay. It's just right there. Let me add you to the spotlight. All right. So here's where we are with Mr. McGriff. You recently brought on a new attorney. You can see him on the screen there, Mr. Schnipper. He was here on time. Let me know you were coming, so no one panicked. And we need to do a couple things. We need to sort out your ankle monitor situation. You have an ankle monitor on right now?
Yes, sir. Yes, sir.
So that is one that you have been paying for in theory, but you haven't been paying for it because I got an email from the bonding company saying we can't keep monitoring Mr. McGriff. He owes us a lot of money. You clearly got some money because you're hiring a private attorney. And so hold on, ma'am. Someone's going to need to make right with the ankle monitor company because the other fix is to say, well, why don't we just keep you where I know we can find you? And I'm guessing that's not what you want. But Mr. Schnipper also asked, couldn't we just take the ankle monitor off now? It's been a number of years and here you are in court. You're showing up when you need to show up. And so there may be a balance between you certainly need to pay what you owe, but maybe it's time for the ankle monitor to come off. The other thing we need to figure out is what's going on with your case next. You got a lawyer who is new to the case, an experienced trial lawyer, but he's new to the case. So he needs to climb a little bit of a learning curve, but you don't get to slow things down just because you bring a lawyer on at the last minute. So we're going to also map out what's next for your case. Ms. Clark, my thought is we keep Mr. McGriff's case on the July trial calendar. That's a month and a half away. Mr. Schnipper needs to get discovery, whether he's getting that from his predecessor or if it's easy enough for you, and you may have already started the process to get him a evidence.com link or who knows, we can sort that out. But he needs to get discovery soon because I intend to keep Mr. McGriff on that July trial calendar. It is a not so old indictment, but it's an older set of facts. And so I'm anxious to keep this moving along. But we've got the question of the ankle monitor. It's been on for a long time, and it seems like unless you have very recent concerns raised by the alleged victim or her family, that it might be time to take Mr. McGriff off it. The monitoring company is not interested in monitoring anymore since they're owed $4,000 or whatever the amount is. Tell me your thoughts.
So as far as the case, Your Honor, this is the case that was in judicial hold for a while. So there is still a buccal swab, verification swab that needs to be done. And my investigator is here with the search warrant for you to review when the court has opportunity. But also with as far as the ankle monitor, I know the last time I spoke with the victim, she would likely have issue with it. But if he's not paying it, then I mean I guess the state would not have an issue with the monitoring going forward to be by state expense until I guess because I would have to notify the victim about I think the bond motion was just filed this morning.
I don't know when the bond motion was filed, but it's a fair request regardless, just how long you been wearing the ankle monitor?
4 years.
How long?
4 years.
4 years.
Well, Mr. McGriff, Judge, let me chime in. I want to make clear to the court, according to that email, it did say May 19th, 2021. So my math says at or around 3 years, just so we can be all clear. But still, if he hasn't had any issues with about 3 years, with all due respect to the victim, his ankle monitor should respectfully be taken off today, Judge. And I don't know why the pre-bill, obviously it's my first time on the case. I just got retained yesterday, but why it wasn't requested initially that it be state funded. And and I haven't spoken with Ms. Clark yet. I just read an email she sent me this morning, and I understand she's busy. But whatever it is with the swab, I mean, I just got on this case. I'm going to respectfully have my client not do anything until I receive full discovery. And I'll be happy to communicate with Ms. Clark when she's available, but would ask respectfully the ankle monitor be removed today.
Okay, got it. Do you, Ms. Clark, have any information from the alleged victim that there been any, I understand the larger concern that there's a comfort factor if Mr. McGriff is wearing an ankle monitor. But I'm wondering if in your interactions with the alleged victim, she has said, yeah, because there's a strange car parked in front of my house all the time, or I'm still getting text messages, or if in fact she has enjoyed a complete lack of contact with Mr. McGriff over the last 3 years.
Well, the defendant has not contacted her.
Okay.
I know that she indicated that having that provision in place monitors him. However, I'm going to just defer to the court on that. I know that like if the counsel was just retained yesterday and he just filed the motion, the state is entitled to 10 days to prepare for it. So I would at least like the opportunity to notice the victim as far as if she wants to have a statement and be more than happy to reset it for 10 days. But just to file a motion this morning and then, the victim not even have a say, I think that would be, against her rights as far as the victim's rights are concerned.
Okay. Yeah, I don't see a bond. It's not in the docket yet. So certainly you can have a little time. Mr. McGriff's going to need some time anyway, because the ankle monitor is not coming off till he pays his bill. So we'll need to sort that out. But there was an order that amended the bond order. See what that said.
I filed the motion early this morning, so I don't think Odyssey's accepted it yet.
Right.
I would ask, Your Honor, and I know we're getting a little ahead, in Ms. Clark's email, it does say, I'm reading it now, that it's possible that some of the balance could be absorbed by the state. I don't know. Again, I just found out about this, that it wasn't paid. I can tell you that defendant cannot afford it. I was hired by a nice family member, but so I'll leave that up to the court. But I will say, like you had just stated previously about, victims or accusers don't have say. I think 3 years without any issues is more than reasonable time, regardless, in all due respect to the accuser in the situation. But 3 years is more than reasonable time where he has proven to the court that he is abiding by everything, and the ankle monitor should be removed, understanding that the victim should be notified. But that's just, my take on it. If it's 3 years isn't enough time, then I don't know then what is.
Okay. Just want to clear up one thing. I don't believe I said, and if I did, I should correct myself. I Don't believe I said that the alleged victim has no say in this. There are all sorts of rights that she enjoys under the law. And Ms. Clark is correctly invoking those rights and saying, well, it may well be, Judge, that you're going to remove the ankle monitor, but the state is entitled to an opportunity to consult with the alleged victim so that her perspective can be shared. Whether it controls or not is a different question. I have the discretion.
That's what I meant.
Okay, I have the discretion to handle it. Okay. Mr. McGriff, are you working?
Yes, sir.
What do you do?
Help put up fences part-time.
You do what?
Help put up fences part-time.
Okay. What does that mean? Like you work for a company that builds fences?
That's side.
Pardon me?
Side, sir.
On the side?
Yes, sir.
Like someone reaches out to you to say, hey, could you help put up a fence? How do people know to reach out to you to put up fences?
You could just say it's a friend of mine.
He's got a fence business?
Yes, sir.
And he brings you in to help out?
Yes, sir.
Okay. And what does part-time mean? Like you do that once a month, once a week?
You could say a couple of days out the week.
Well, I don't want to say, I want you to say.
Yes, a couple of days out the week.
Okay. Tell me, where are you staying these days?
I'm on, you want the address?
You don't need to give me the number, but what's the street name?
It's an apartment, sir. It's a Camilla Lane.
Okay, Camilla Lane in Lithonia?
Yes, sir.
Okay, all right. And who stays there with you?
Mama.
Your mom?
Mm-hmm.
Okay, who else?
My sister just moved out. A friend of ours.
A friend of yours or your mom's?
Friend of ours, both.
Both?
Yes, sir.
More your age or your mom's age?
Mom age.
Okay, so 3 of you in the apartment?
Yes.
All right. And how do you get to the fencing jobs when you are helping your friend 1 or 2 days a week?
I have Marta, and I also have my mom.
Okay. All right. So Mr. McGriff, I'm going to do a couple things. One, I'm going to ask you to sit tight in here for a little bit. Number 2, I'm going to keep your case on our July trial calendar. Ms. Clark, what's your sense as to how quickly you can get discovery to Mr. Schnipper?
Your Honor, I'll confer with my legal assistant by tomorrow, end of day.
Okay. Do you have a sense as to how voluminous the discovery is in this case?
It's a good bit, Your Honor.
Okay. It's a good bit because there are a lot of body cams or because there are forensic interviews or what?
There are a lot of interviews. I'm not looking at it right now, but
just off the top of your head.
Yeah. There are interviews and there are just a number of like photos. I think photos. I think there may be a crime scene that was done.
Okay.
On it. So,
but it's other than
it's not like insurmountable. I think that you could easily review it within 30 days.
Okay. Other than the potential buccal swab, any other missing investigative pieces?
No, Your Honor.
All right. What's your experience as to how quickly the GBI can turn that around if that's something that gets submitted to them in the next few days?
Upon expedited request, they've been turning around within 60 days.
Okay. So the July trial date may be too soon.
Yes, Your Honor.
Okay. We're going to keep it there. Old set of facts. And we need to keep moving it forward. Mr. McGriff, you and your mom should talk with the monitoring company and figure out how you can resolve the outstanding invoice. Because once I get contact from them that's been resolved, ankle monitor comes off. Most likely, need to hear from the victim, but my inclination is to have the ankle monitor come off, but not until the monitoring company is made whole. Your mom is going to come out of her seat if I don't call on her in a minute. Yes, ma'am.
I appreciate you talking with me. I was in contact and I was actually making payments until in arrears because of the situation with the incarceration. It got set behind, but I had an agreement and I was paying them actually on that $4,000 mark. now I wish up to 5,000, but they should have it documented and I know the lady over there personally.
Great. Well, if they end up sending an email through, they have some way to alert the court, because I got an email that said there's an issue with the McGriff ankle monitor.
It's recently, like, who's incarcerated, who's on the month. Way back in January, I had made the agreement with them and paid them so many $1,000s a week. And see, I'm helping my son, his case, I'm between lawyer.
Great.
And that's a lot. I'm supporting him in this.
No, I appreciate that. And he better be grateful and do what mom tells him.
And he lives with me.
Good.
He's gonna be there at night.
And do the dishes if you ask him to do the dishes. All right. Good. Excellent. So what I'm going to do is check in 2 weeks with the lawyers. So I will reach out to Mr. Schnipper and Ms. Clark to say, Ms. Clark, what did you hear from the alleged victim about the ankle monitor? And I'll see if Mr. Schnipper has an update from Mr. McGriff's mother about taking care of these invoices from the ankle monitoring company. If the ankle monitoring company says, we're good, there's a payment plan, and it looks like everything's going okay, I just want to make sure that they're satisfied. And then at that point, I may say, get me a proposed order, Mr. Schnipper, about removing the ankle monitor, and we'll do that. In the meantime, I'm keeping the case on the July trial calendar. I will preserve your final plea rights, which basically means you could enter a plea and withdraw the plea if you don't like the sentence you get. We can't do that today because your lawyer can't meaningfully give you advice as to what to do in the case. He is climbing a steep learning curve, which he will continue to rocket up over the coming weeks. I think that covers all the things, other than if you've got the paperwork that you just mentioned, I'd like to take a look at it.
Yes, Your Honor.
If you bring that up to me.
Your Honor, I got just one more thing. I'll be real succinct. Is there any way, again, I didn't really hear what Ms. McGriff, defendant's mother, said. She was kind of in the back, that if necessary, that the county could, based on Ms. Clark's email to me, that she mentioned that it's a possibility, I don't want to take words exact, I'm not reading it, that the state could absorb some of the outstanding costs of the ankle monitor?
That's not how it goes. Oh, this has already been signed. Got it. Okay. No, I don't. It was creative thinking by Ms. Clark, but she's not in a position to obligate the county in that way. And so this is something that Mr. McGriff's family is going to need to sort out. And I want to be clear, if what I hear from the ankle monitor company is that they're comfortable with the payment plan that Mr. McGriff's mother has entered into, I'm not going to require that it be paid off in toto before the ankle monitor comes off. I just need the thumbs up from the monitoring company saying we're comfortable with how this is going. And then if after I hear from Ms. Clark, after she's spoken with the alleged victim, I continue to believe that the monitor should come off, it will come off. In other words, the removal is not conditioned on full payment if the bonding company or the monitoring company says we're okay with this payment plan.
Yes, sir.
I have an executed search warrant. I'm going to ask you, Mr. McGriff, to go with this gentleman into my jury room. He's going to interact with you a little bit as he is authorized by another judge to do. And that will be it. Okay.
Am I going to get a copy of that from Ms. Clark, the search warrant?
Yep. I'm sure Ms. Clark will get that your way.
Thank you.
All right. I think that covers. Do you have any questions, Mr. McGriff? We talked about you a lot. Your lawyer is doing a good job of keeping all the bases covered. Do you have any questions? Okay. Ma'am, you have any questions? What would that be? So you're welcome if if your son's lawyer gets a copy to look at it, but it's not your search warrant, and it's actually not my search warrant. Another judge has signed it, and this gentleman is entitled to execute the search warrant, which I am going to let him do in a jury room with your son. You can talk with your son afterwards, but this isn't a mom thing. It's not a lawyer thing. This is a judge thing. Warrant, McGriff, investigator, jury room.
Yes, sir.
Thank you.
Yes, sir. His father.
Pardon me? Yeah, just go with him. It's just right. The jury room's right there. Pardon me? Oh, they're here. Okay, great. All right. Mr. Schnipper, you should start getting discovery, and then I will shoot an email to you and Ms. Clark in 10-ish days or so to say, what are we hearing about the ankle monitor? Your input will be, here's what Mr. McGriff's mother has sorted out with the monitoring company. Ms. Clark's input will be, here's what I heard from the alleged victim. And then we can tie that one off. You should let me know,
Yes,
Mr.
sir.
Schnipper, meaning let my litigation manager know if for some reason there is a hiccup in getting the discovery. Ms. Clark is going to try to fast track it to you. But if you feel like, hey, I'm not getting all of it, let us know so that not a lot of time is passing. Okay?
Yes, sir.
All right. Look forward to working with you. Ms. Clark, anything else on Mr. McGriff's case?
No, Your Honor.
All right. We're good.
Yes, sir. May I please be excused?
Yes, sir.
Yeah, have a good day. Bye-bye.
You too. All right. I need to swear someone in. While I'm doing that, can we get ready for Cozart and do Cozart?
Yes, sir.
Are there people in court for it, or they're going to be virtual, or in turn on the victim side?
The victim would prefer me to just tell you what she wants.
Okay. There are three cases, but aren't there victims in both?
The third case is Miss Willingham's.
Right, but they're two serious injury by vehicle or whatever they are.
Oh, yes, so one of his cases is fleeing and attempting to elude, the other is 2 counts of serious injury by vehicle.
Got it.
And I've just spoken with both of those.
Got it. Okay, so you've got all the pieces. I got to go get one thing, and we'll do the swearing in. Who's here for the swearing in? The whole row? Okay, so we'll do it in here rather than go back there. I got to just go get my magic. Do you have the paperwork?
Yes.
You got the paperwork. Oh, great. You got the clerk's office here. All right, I'll be back in 1 second.
Let me double check, but I'm pretty sure it was. Yes, I'm sorry.
We're good.
Yes, we're good.
Okay.
I'm sorry. I was about to take
I don't know
you
if you
back.
had a minute to tell me.
I will, because I was gonna tell her it's just the,
Yeah.
he's only clean to the misdemeanor. Okay. But we're wrapping, F it into your, conditions, because we won't have any probation by the time.
Okay.
But they're agreeing to
Yeah,
that.
that's fine. That's not like, this is really anonymous. Okay, really, it's not an issue. Thank you. You're okay?
That's fine. Like, I have to say her, like, when I'm leaving, whatever. So, you know, like, you have almost room kind of playing dates. When we go down the stairs, so she was coming out of her room. I was trying to go run down to get some snacks for her. And she like basically like, so our stairs and then like there's like a carpet, like a rug, whatever. And so going down, and she's like, oh yeah, tell me what's anywhere. And then I was like, oh, and like I just wasn't paying attention. I pretty much basically tumbled, but I caught the top of the railing. So my mom, of course, being the light that mothers are. I was like, yeah, I've never in my life entire life had a broken bone. Yeah. Even though I mean, I had sprains and I actually thought it was a sprain. And I actually had like, didn't think anything of it because I had you guys be able to walk better. So, and so, you know, and then I got, I think like last Wednesday, I think, started swelling. I just went to a urgent care in my neighborhood.
All right. I need the paperwork, please.
How you doing, Jen?
I'm doing well. How are you? So shiny. So do we say Gonzalez, Vilches?
Gonzalez.
Gonzalez, you're Mr. Gonzalez. All right, who do you have with you?
Rob Welch, we work together, 10 feet, and my wife, Danielle.
Great. And just some hangers on.
We're all from the clerk's office.
Excellent. All right, and you are working where?
With Adams and Reese.
Okay.
Yeah.
How long have you been there?
About a year now.
Okay, what did you do before that?
We were at another law firm, Ragland in Florida. Yes.
Here in Drew Echo, here in Atlanta.
Yes, sir.
How long have you been in it? That's a long time being in Atlanta and not as a Georgia lawyer.
Yes,
How-
8 years now.
Oh, okay. Well, why are you suddenly crossing the line to the bright side?
It took me a while to pass the bar.
But were you a paralegal or you have a license somewhere else?
Yes, I'm licensed in Venezuela.
Oh, that's right. I remember reading this. So you've got a foreign license.
Correct.
What does that authorize you to do? Are you a counselor that way, or, I mean, you're barred just in another country?
Yes, so I can deal with cases and matters related to Venezuela.
You don't probably do a whole lot of business with Venezuela these days?
Not
That
a lot.
can't keep you real busy.
Not a lot.
No, okay. I mean, that's sanctioned cities there. Interesting. And how long have you been in the US?
8 years now.
8 years? Okay, the whole time. And so almost all at Drew Echo, and then recently you switched over?
4 years in Drew Echo, 1 year at Adams.
Okay, great. Well, I'm excited for you. So did you have to do law school all over again, or
Just 1 year.
just 1 year?
Yeah.
Sort of like getting an LLM kind of thing?
Correct.
Where'd you do that?
UGA.
UGA? All right, well, good. Well, congratulations on passing.
Thank you, sir.
Now you can do non-Venezuelan things?
Yes, sir.
I can be busier. That's good. All right. Well, when you're ready, I'm happy to swear, and we can stand, if people want, I don't know if people want to take pictures of this, you don't have to stand behind there. You want to be there, or whatever you want to do. You're actually live on YouTube too, so don't mess up.
Okay. You tell me.
Well, actually, we'll let the photographer say, where would you like him standing? Because you'll be filming him, and I'll be standing across from him, and have his hand up. So, you want him over there? So just do what she says. Okay, so you stand over. Do you want to, where do you want him standing? He's not following your directions well.
Over there?
Sure, so put you back to
I
that.
can record from here.
There you go.
Thank you.
All right. You bet. No problem. You good?
Yeah.
All right, so move back a little bit. Raise your right hand. All right, and you're gonna repeat after me. The first thing I say is I, you'll say I. Then I'm gonna wait for you to say your name, because I'm not gonna say it. Then the rest will be in little bite-sized chunks. Okay, you ready? I swear that I will truly and honestly, justly and uprightly, conduct myself as a member of this learned profession, and in accordance with the Georgia rules of professional conduct, as an attorney and counsel, and that I will support and defend the Constitution of the United States and the Constitution of the State of Georgia. So help me God. Did it? Yes, sir. Congratulations. Great work. Want to do a little photo here? Do you want to be in a picture with him? I mean, yeah. I just want to ask you what other pictures. Okay. Should we then maybe get all? Sure. However you want to do it. Let's just get this. Okay. Why don't you be in the middle? You didn't want to ask the question.
Right here.
All right. And then you want to sit.
Sure.
Bill payers. All right. That's it. How are you? You doing well?
Thank you. Here. Okay, 1, 2, 3. Okay, now here.
Good.
All right. Now, we're not quite done. I gotta sign a couple things and you have to sign something.
You're welcome.
Get it. Sign here. So this is the official thing. You want to put that on your wall in a nice frame. This you need to sign. You're the applicant, so you sign right there.
That one looks good.
Okay, thanks. Excellent. All right. I'm going to return this and you to the good folks from the clerk's office, and they will take care of the rest. Yes. All right. You going to a nice lunch? So. All right. Good luck with everything. Congratulations. You bet.
I give this.
Congratulations. Should we do Cozart? We ready?
I just used speaker for like 3 minutes.
Oh, are they still doing that? Come on, what's a swab?
Yeah, what's going on?
Yeah, that's what they.
I just figured I was,
Swap.
that's why I was trying to wait.
You good? All right, thanks. All right. I think your mom is still out there somewhere. Okay. Okay.
And see if we can work it out today.
We got time to go talk for a while.
I'll be quick.
Yeah. She needs to talk, just so he knows about the third.
Judge McBurney, may I be excused? I have a case this afternoon, but this is the only.
Yeah, was this the only AM one?
Yes.
We'll see you back after lunch.
All right, thank you.
Bye.
Thank you, Judge.
You bet. Go expedite that.
Yes, sir. We'll get on it, sir.
Okay, well, the first one I want to talk to you about was Mr. Mr. Jewell, who's in custody. So I spoke with his mom. His dad said he could come live with him. And that he would help monitor his mental health. His mom said this just has been, he has PTSD for some stuff that happened. She said that as long as he's on his medication, she's fine. And they are both willing to make sure he's on his medication. And if we could put it in a condition that he take his medication and get evaluation through misdemeanor probation, maybe can we do misdemeanor?
Probably fine with that. I just want to like a little bit because misdemeanor probation is not fun. Then,
but with his dad said he would be able to. What happened was he was waiting on a job interview to call him in for a really long time to call him this morning. So he can't miss that job interview because if he's going to be living with him, he's saying he's going to be paying for it. So he said he can't miss this opportunity. So that's the only reason he's not here. But he's available via phone if you want to call him. But yeah, I've spoken to everyone. So and I also have my social work on it, looking for some place for him to go during the day. It was just she hasn't been able to get it yet. But if we could make it, I don't know, some type of condition that he get mental health, I guess, evaluations or whatever through here, then my social worker will still stay on it.
yeah, all that's fine. I just want like the specific program that he's gonna be going to in the.
But we don't have
Yeah,
a place
so
yet.
I mean, we can push this off until you can get that. I mean, how long do you think it'll be till you get that?
I'm not sure. I've texted my social worker. I just know he's ready to like leave today and wants to get out. I can see if it will be another week and see. I'm gonna go talk to him. See if he would be okay with that, because this you're just not willing to resolve it today.
I just don't wanna say, oh, just go get mental health treatment. Like, I want like something specific so that if, another thing happens, we can like say, this is what we told you to do.
Yeah.
And like, not just, go get mental treatment. Like, that's not concrete enough.
Okay, let me talk to him. Great. And see if do they usually just like do like a 2-week reset, 1 or 2 week reset?
Probably what I'll do is put it on the next thing, which is the trial calendar, and then just whenever we get something, we can bring it back in.
Earlier than the trial calendar. So if we found a program in like a week or two, we just ask to be added on to account. Okay, got it.
Am I back?
I need to speak with Crestwell. Huh? Money?
You didn't know how it worked in this courtroom. It's pay to play.
Judge, I haven't had this many cases on the calendar in a long time.
Yeah, I was like, woo, Willingham everywhere.
It's like my days when I first got to DV.
Yep. Well, then you cleaned everything out. Now they're back.
Yes.
Let's go, Mr. Cozart. When you ask in your plea colloquy, ask people how old they are, not their date of birth, if you don't mind.
And I asked both. I'll just leave out.
Yeah, but they say the date of birth. I'm like, that's complicated math. Just tell me how old you are.
Okay.
That's what I want to know. Hey, we're ready for Cozart.
I'm sorry. It's my breakfast.
So, do you want to do the flash basis one? Yes. No.
Pardon me? Podium. Yep. Thank you. All right, Ms. Rivers, you ready?
Yes, I'm ready.
Great. We're going on the record in 3 cases, all involving Mr. Cozart. It's positions 1 through 3 on our plea calendar for this morning. Mr. Cozart is here in court with his lawyer, Ms. Wood. Ms. Nix is in the position for the prosecutor, but one of Mr. Cozart's cases is a Willingham case. Are we handling all 3 today, Ms. Wood?
Yes, sir.
And Ms. Nix, have you been deputized by Ms. Willingham to handle all 3, or will we be tag teaming?
I guess tag team, Ms. Willingham will read the factual basis for her case, but I'll do everything else.
Okay, you'll be the primary. Got it. Mr. Cozart, good morning.
Good morning.
You've got 3 cases. 2 of them involve you allegedly driving in a reckless way, and then 1 is a family situation. And Ms. Wood tells me that you are prepared to enter pleas in those cases. Is that correct?
Yes, sir.
Okay. In a moment, Ms. Nix is going to put you under oath, You'll need to answer all of her questions and mine truthfully and completely. I need to answer any questions you've got. So it's important that if someone says something that confuses you or is different from what you and Ms. Wood have been talking about, that you speak up. You say, wait a minute, I don't get that, or I thought this or that. And it may be that you and your lawyer speak privately, or it may be it's something I answer, but will you let me know if you've got any questions?
Yes, sir.
Okay. Then we're going to move forward in that way. Ms. Nix, are you ready?
Yes, sir. Mr. Cozart, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your true, correct, and legal name.
Jerry Cozart.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am, I am.
You can put your hand down now.
Is there a medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you?
I'm 35.
How far have you gone in school?
I graduated, ma'am.
From high school?
High school, yes, ma'am.
Is English your native or dominant language?
Yes, ma'am.
Do you understand that you've been charged with the following offenses in 23 SC 186-104, counts 1 and 2, serious injury by vehicle? And Judge, I can read all of them, but the counts 3 through 14 are actually time barred through the statute of limitations.
Oh, then we don't need to worry about those others. The state won't be moving forward. Okay, so on the indictment ending in 104, Mr. Cozart, the only 2 charges the state's going forward on are the serious injury by vehicle. There are a whole number of misdemeanors and driving violations that, because that incident is so old, the state is not going forward on those. So just 2 counts for the indictment ending in 104. You understand?
Okay.
Okay.
And in 23 SC 189-483, count 1, speeding, count 2, driving while license suspended or revoked, count 3, fleeing and attempting to elude law enforcement, count 4, failure to signal or while lane change or turn, count 5, reckless driving, count 6, hit and run, count 7, reckless conduct, count 8, possession of open container, and count 9, failure to signal for lane change or turn. And, sorry, computer's going slowly.
And an indictment ending in 7978. Count 1 is a false imprisonment. That count will be null pros. And count 2, battery, family violence. It is my understanding the defendant will be entering a plea of guilty to that count along with his other cases.
Okay, so, and is that a misdemeanor for Mr. Cozart?
Yes.
So it's a misdemeanor plea to the indictment ending in 978, and then felony pleas. I mean, there are some misdemeanors in there, but it's a felony convictions for Ms. Nix's 2 cases.
Yes, Judge. And for the record, as a part of this negotiation, I do understand that once the defendant has completed any sentence that the court may give him in custody, it is more than likely that we will not have any probation balance left on the misdemeanor. But because of that, defense has agreed that it is okay to include the family violence intervention program on the back end of the serious injury cases. And that is part of our negotiated plea.
Got it. Okay, thank you for flagging that. Back to you, Ms. Nix.
Mr. Cozart, do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
You understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had the opportunity to review your rights with your attorney?
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes, ma'am.
Do you need more time to discuss the cases with your lawyer, Ms. Wood?
A couple seconds, please.
Sure. I mean, right there, or you need to go back?
Please go back real fast, please. Okay.
take it. Okay. Take the recommendation. I'm just gonna talk to her. Okay. She's gonna handle it. That's real.
Understood.
You know what I'm
Yeah,
saying?
yeah.
We're good, Judge.
Okay, Mr. Cozart, we took a quick break so you and Ms. Wood could talk something over. Are you ready to move forward?
Yes, sir. Thank you.
Great, you're welcome. That's exactly how to do it if you need to do it. Ms. Nix?
Mr. Cozart, are you satisfied with Ms. Wood's services?
Yes, I am.
Ms. Wood, do you waive a formal reading of the indictment for purposes of the plea?
We do.
And do you waive any and all defects in the indictment for purposes of the plea?
We do. And just for clarification, did we go ahead and put on the record?
I was about to.
Oh, okay, go ahead.
So, Judge, for the record, in 23 SC 186104, counts 1 and 2, serious injury by vehicle. The victims in that case are both minors, which makes the statute of limitations longer than normal, and we would still be within the statute of limitations. The ages of those victims are listed elsewhere in the indictment, but just for clarity's sake, I was going to re-indict the case to include their ages in that count. But since the defendant is pleading, I did not do that. So I'm just putting on the record that those 2 counts are not time barred due to the age of the victim. And it was not as clear as it could have been in the indictment what their ages were to make those 2 not time barred.
So it's something that you and Ms. Wood discussed, and I'm looking at the okay, that they were under 4 because they're 2 counts that are time barred concerning EC and MS, but at the time they were under 4,
Yes,
they were under 6. And in theory, you could apply that to counts 1 and 2, but regardless, instead of re-indicting and delaying things more for Mr. Cozart, Ms. Wood is waiving that potential issue because it is eminently fixable simply by re-indicting. It's not a legal impossibility to fix it. It's just a technical fix.
Yes, sir.
Okay, got it.
So that potential issue is waived by the defense?
Yes.
Mr. Cozart, do you remember having been arrested on these charges?
Ma'am, I'm sorry.
Do you remember having been arrested on these charges?
Not really, ma'am. I was in a coma for a while after.
Can you confirm that you were arrested on all 3 of these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, ma'am.
Do you understand that today you are entering a plea of guilty, which is called non-negotiated, and the state may recommend a sentence to the court even without you having agreed to it in advance?
Yes, ma'am.
Are you aware that the state's offer is a 15-year sentence that you serve 5 years with the balance on probation?
Yes, ma'am.
Have you discussed this offer with your attorney?
15 years. So.
That's her offer, and then we get to ask for what we're gonna ask for after when it's my court to speak.
Okay.
Okay.
Okay. Ma'am, I'm sorry.
Have you discussed this offer with your attorney?
Yes, ma'am.
You understand that the court can impose any sentence authorized by law, including a higher sentence than that which was recommended by the state, up to the maximum sentence on each charge?
Yes, ma'am.
You understand that since if you enter a non-negotiated plea, you do not have the right to withdraw your plea once the court enters its sentence?
Yes, ma'am.
You understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Are you currently on probation or parole anywhere?
No, ma'am.
You understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that while you're on probation, you must follow all the special conditions of your probation?
Yes, I do. Yes, ma'am.
You understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, I am.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes, ma'am.
You understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years.
Yes, ma'am.
You understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future.
Yes, ma'am.
You understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime.
Yes, ma'am.
You understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses.
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charges of 2 counts of serious injury by vehicle in 23 SC 186104?
Guilty.
And how do you plead to the charge of fleeing and attempting to elude in indictment number 23 SC 189483?
Guilty.
Sorry, my computer's running slowly. And how do you plead to the charge of battery, family violence in indictment number 23 SC 187978?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition? For the felonies, you have 4 years from today to do so, and for the misdemeanor, you have 12 months from today to do so.
Okay. Yes, ma'am.
I'll start in 23 SC 189483. Had this case gone to trial, the state would expect the evidence to show that on February 26th, 2022, Corporal Munoz of the Georgia State Patrol observed a white Toyota Camry traveling at speeds estimated to be between 80 and 85 miles per hour in a 65 mile per hour zone. Corporal Munoz got behind the vehicle and paced it at 85 miles per hour. He also observed it changing lanes rapidly without signaling. Corporal Munoz activated his blue lights and the driver initiated a pursuit. The driver drove in speeds excess of 120 miles per hour, driving recklessly while fleeing from Trooper Munoz. Other troopers joined the pursuit, including Trooper Youngblood. Trooper Youngblood attempted to channel the vehicle to prevent it from striking other vehicles, and the driver, who was later identified as Jerry Cozart, turned sharply to strike Trooper Youngblood's vehicle, which caused disabling damage to it. The driver of the Camry, Mr. Cozart, drove through a Wendy's parking lot, cutting off several motorists, and then re-entered I-85 South, swerving rapidly and dangerously. The driver took an exit from the interstate, lost control of the vehicle, struck numerous trees, and finally came to a stop. The driver, Mr. Cozart, exited the vehicle and fled on foot. Trooper Ennis located Mr. Cozart in the woods and took him into custody. He appeared intoxicated and had a contusion on his forehead, and open containers of alcohol were found in his car. This occurred in Fulton County. In 23 SC 186104, had that case gone to trial, the state would expect the evidence to show that on or about June 22nd of 2018, a Trooper Tennant with the Georgia Department of Public Safety, State Trooper, was traveling southbound on I-75 and observed a passenger vehicle pass him in the HOV lane at a high rate of speed.
The vehicle was traveling approximately 80 miles per hour in a 55-mile-per-hour zone. Trooper Tennant also observed the vehicle failed to maintain lane. Trooper Tennant activated his blue lights to initiate a traffic stop, but the driver of the passenger vehicle failed to stop. The driver of the vehicle, who was later ID'd as Jerry Cozart, passed the vehicle in front of him on the freeway shoulder and accelerated away from the officer, initiating a pursuit along I-75, I-85, and entered onto I-20, and then exited I-20 onto MLK Junior Drive. The vehicle traveled along Martin Luther King Jr. Drive at a high rate of speed on the wrong side of the road, making a number of dangerous driving maneuvers, and struck another vehicle head-on, causing this vehicle to spin from the impact. During the course of the spinning impact, Mr. Cozart's vehicle struck another vehicle and finally came to a rest. Trooper Tennant approached the vehicle and observed smoke coming from the vehicle. He also observed children crying and a female passenger, adult female passenger, who had been thrown from the back seat into the front seat. Trooper Tennant got a fire extinguisher from his car, from his patrol unit, and took put the flames out that were emanating from the vehicle, and with the help of other troopers and other officers, removed the small children from the vehicle. Those children were Elena Cozart and Mararia Steele Austin, who were both 2 years old at the time of the incident. I'm sorry, 3 years old at the time of the incident, and both suffered broken legs from the accident. Mr. Cozart was taken into custody and charged with several offenses, including the serious injury by vehicle to the two 3-year-old children.
And if indictment ending in 7-9-7-8 was to proceed to trial, the state would show beyond a reasonable doubt that on February 12th, 2021, Catamdra Jones, CA''TAMDRA Jones, common spelling, walked into the College Park Police Precinct to report that her boyfriend, the defendant, Jerry Cozart, had assaulted her a few days prior. On February 8th, 2021, Catamdra was in the Best American Inn and got into a verbal altercation with Mr. Cozart that turned physical when Mr. Cozart hit Ms. Jones in the face multiple times with a closed fist. Mr. Cozart then physically disabled Ms. Jones's phone, preventing her from leaving the motel room or using the room's phone. Ms. Jones waited for Mr. Cozart to fall asleep before leaving and flagged down a vehicle in the middle of the road. The driver took her home and she attempted to contact her home police department, who told her to contact College Park Police Department. Ms. Jones still had a black eye from the incident, and other injuries were recorded by photograph, and she was advised to file a TPO against Mr. Cozart at the time she reported the incident.
The defendant has 3 prior felonies, a robbery in DeKalb County in 2018, and a carjacking and armed robbery from 2007 in Miami-Dade, Florida, as well as a grand theft in Miami-Dade, Florida from 2010. The custodian of Miss Elena Cozart, I'm not sure if I'm saying her name right, expressed to me that she felt the defendant needed to be held accountable for this incident because it was absolutely senseless, were her words. There's no reason for him to put those children at risk of receiving injuries worse than what they did, which was just broken legs. They could have been killed. And Elena has had to have several surgeries to accommodate the rod in her leg as she grows. The custodian of Mararia said that that she is 9 years old and is doing well despite this incident.
The custodian for the Cozart child, is the Cozart child Mr. Cozart's biological child, or that would have been uncle, or what do you know about that?
I believe it's his biological child, and the custodian is her aunt.
Okay.
The sister of Alina's mother.
Okay. And then Steele Austin, also a child of Mr. Cozart's, or just happened to be unluckily on board that car?
I wasn't able to confirm.
Okay.
Whether.
Got it. Thank you. Ms. Hardy, do you have any other criminal history information on Mr. Cozart?
Nothing other than what was given.
Okay, thank you. Well, the robbery out of DeKalb, is that an open case, or what is your, I don't know if your system says?
I'm showing it as a conviction.
Okay, but meaning is he on active probation for that now? Or I guess that's a question for Ms. Tucson later.
Yeah, I don't have any information on that one.
Okay, thank you. Ms. Wood.
Thank you, Judge.
Oh, I'm sorry, before you go, it was your turn. The plea in the 483 case, which is the more recent high-speed chase where fortunately it was just Mr. Cozart, didn't have little kids on board. Is that to all counts or to just some counts?
Just the fleeing and attempting to elude. There was a aggravated assault against a police officer, which was not put in a grand jury, and the other charges are.
So count 3 is the one you're going forward on?
Yes.
Okay, and what's the range for count 3?
The sentencing range for fleeing and attempting to elude is 1 to 10 years and up to a $5,000 fine.
Okay. And then what's the sentencing range for the serious injury by vehicle?
Serious injury by vehicle, the sentencing range is 1 to 15 years.
Got it. So 2 counts in the 104 indictment, 1 count in the 483 indictment, and 1 count in 978. Ms. Wood, I'm sorry I interrupted you.
No worries, Judge. I just wanted to start off by acknowledging that Mr. Cozart understands the gravity of the situation. That is part of the reason he's here accepting responsibility today. He's very fortunate that even though the children were seriously injured, that it wasn't much worse. Both interstates and both incidents were full of cars. And I'll leave it at that. Judge, we're asking for a total sentence of 10 to serve 3 in confinement. He has been in custody for right around, if you total up all of the booking numbers, it's 176 days, and I will get that breakdown to Ms. Nelson. Judge, he's originally from South Florida. He's been here in the Atlanta area for about 10 years. He's 35 years old. He's a high school graduate. He was working at a distribution center as a forklift operator prior to the arrest. We are hopeful that he can avail himself of some programs in the Department of Corrections and learn ways that he can be productive in society upon his release. And I believe that is all we have to add for now, Judge.
All right.
Oh, and he wanted me to let you know that he is eager once he is out to get back to his children.
How many kids do you have, Mr. Cozart?
7, sir.
17?
7.
7.
Yes, sir.
7 kids.
4 in my household.
Pardon me?
4 in my household.
4 in your household and 3 elsewhere.
Yes, ma'am.
There were 2 little girls in your car way back. I appreciate it was 6 years ago, way back in 2018. One is clearly your daughter. Was the other your daughter also?
Yes, sir.
Okay. There was an adult in the car with you as well. Who was that person to you?
Elena's mother.
Elena's mother. Okay. Not Maroria. I may not be saying the name.
Miaria.
Miaria, not her mother.
No, sir.
Okay. And you have 5 other kids beyond those 2.
Yes, sir.
Okay. How old is the oldest?
Out of
all your kids, you got 7. How old is the oldest?
The oldest is 13.
And how young is the youngest?
The youngest is 1.
1. Okay. And you said 4 of them are in your household. That's the household you have with are you still with the person who was in the car in 2018 or?
I wasn't with her then. We were taking the kids out.
Got it.
I'm with someone else, and I have a 7-year-old, a 5-year-old, a 2-year-old, and a 1-year-old.
Okay. And what is that person's name?
Nia Hicks.
Miss Hicks. Does Miss Hicks work?
Yes, she does.
What does she do?
She's on Georgia Tech. She does in the kitchen, something in the kitchen at Georgia Tech.
Okay. And is she the biological mother of any of those kids?
Of all 4. Yeah.
Of all 4. All right. Anything you want to add?
What's it called? I did a couple programs after the fact, and I was messed up mentally. You know what I'm saying? Going into a lot of things. I straightened up after then. Haven't been anything. I'm good for my kids. I take care of them. I do everything. You know what I'm saying? It was a mistake. You know?
When you say after that, are you referring to the 2018 situation or the 2022 situation?
The after the 2018 situation.
You took some classes.
Yeah, I took a couple classes. Well, it was kind of mandatory. You know what I'm saying? Yeah.
And what would an example be of a class that you took?
I took motivation for change, and I took a re-entry program just to get my head right. You know what I'm saying? I went through a TC program. And I was good. I was on a lot of medications also. I broke my kidney, and a lot of stuff was wrong with me. So
okay, when you say medication, meaning you were on prescription medication?
Yes, sir. Prescribed.
Are you taking any medication right now?
Not at the jail, no, sir.
Okay, should you be taking medication?
Yes, sir.
For what?
For back pains. I got a rod in my leg, and I have I was supposed to be taking for blood clots.
Okay. Do you have a rod in your leg because of the 2018 accident?
Yes, I do.
Just like your daughter.
I lost a kidney.
And you lost a kidney.
Split my liver in 2. Yes,
okay. So you're not getting that medication right now, but that's not mental health medication or anything like that. It's
I suffer head trauma also.
Okay.
Yeah.
Got it.
I get headaches. I just basically at the jail, they don't give you much. So I just take whatever pain medication I can get at a time.
I hear you. When you were not in jail, so let's rewind, like 6 months ago, you were not in jail. Were you taking medication? For what?
Just pain period.
Just pain period, pain management.
Yes, sir.
Okay. Anything else or just that?
No, just that. I left. They would give me Percocet at first, but they wasn't agreeing with me. The Percocet wasn't agreeing with me. Okay. You know so I stopped the Percocet and I just went to taking Tramadol. It was lighter for me. I could move around and still work on the Tramadol. Percocet set me down too much.
Okay. All right. Anything else?
No, sir.
All right. Well, Mr. Cozart, I find there's a factual basis for each of your 3 pleas, and that your pleas today are knowing and voluntary. Voluntary means no one's forcing you to do this. I know you're not excited about being here, but of course, you set all this in motion. And knowing means you've understood the things we talked about. And when you didn't, you took a time out like you did already today, and you and your lawyer talked about things. Do you have any questions about anything we've discussed?
No, sir.
No? Okay, good. And do you agree with me that this is a voluntary plea? No one's forcing you to do that?
I do.
Okay. Mr. Cozart, part of your sentence will be on probation. I'm sentencing you pursuant to the Probation Options Management Act. What that means is that while you're on probation, if you have I hope you have no violations at all, but if you have a minor violation, you and probation will work through that. You don't have to come to court. But if it's more significant, you are driving a vehicle, because one of the conditions is going to be you don't drive.
Okay.
But you get arrested for anything, that comes back to me and we'll work through what the consequences are. Ms. Wood, can I have someone from my team sign the 3 indictments on your behalf?
Yes, Judge.
And Ms. Nix, on your 2 indictments, can we sign for you?
Yes, sir.
Ms. Willingham?
Yes, Your Honor.
All right. And Mr. Cozart, instead of handing lots of papers around, we now electronically sign a lot of things. Is it okay if we put your signature on the 3 indictments indicating your guilty plea?
Yes, sir.
Okay, we'll do that. All right. Mr. Cozart, I am glad that you are recognizing the mistakes that you made. I am particularly glad that the two little girls who were in your car when you were driving as fast and as recklessly as you were survived. It sounds like for Eliana, it is a continued struggle. Like you, she's got a rod in her leg. Unlike you, her leg is still growing, which makes it real complicated. I'm also relieved that no one else was hurt. It would have been real easy for a pedestrian who was not expecting someone going 40 miles an hour on the wrong way on MLK to step out in the street and you spray them all over the street. And then we'd be talking about something different. So you sort of have, I don't know about 9 lives because things caught up with you, but you had multiple lives. You survived the June 2018 situation, despite inflicting harm on a lot of folks. And then fast forward less than 4 years and you're doing it again. Fortunately, the trooper wasn't hurt when you outmaneuvered him. And then fortunately, you weren't too badly hurt when you crashed into a tree because it would have been real easy for things to hit you the wrong way. And it sounds like you only had half a liver by then anyway to really mess things up. I don't get it why this keeps happening, but that's going to be something you need to work through. My goal is to do what I can to keep you from being behind the wheel of a car. And there's a limit to that because once you're done serving the custodial part of your sentence, it's not like you're going to have a bodyguard walking around with you, preventing you from getting behind the wheel. But know this, if you are back in front of me because you got any kind of moving violation at all, you ran a stop sign, you didn't even signal when you changed lanes, I will revoke as much of your probation as I can because you will have gotten back behind the wheel.
Yes, sir.
And that's going to leave a mark. I mean, you'll get out and your kids will all be grown up.
Yes, sir.
And I'm guessing they want you around. They may not want you driving them around, but they want you being around. So you've got some changes to make when you get out. All right, I will start with 23 SC 186104. That's your oldest set of facts. That's the June 2018 madcap driving you did that injured the two little girls. Counts 1 and 2 are the only remaining counts. And on both of those, I am sentencing you to 15 years to serve 5 with the balance on probation. You will get credit for the time you have served, and Ms. Wood will get those dates to Ms. Nelson. These are also parolable offenses, so Ms. Wood can talk to you about how that will work. But if you are not paroled, the most you'd serve will be 5 years. Those 2 counts will run concurrently with each other. Special condition number 1, no driving. You may not operate a motor vehicle on the roads of Georgia while you are on probation. Number 2, no drugs that you don't have a prescription for, and no alcohol. You will be subject to at least 3 random drug and alcohol screens a month for the first year of your probation. We'll dial it back to 1 a month after that. And you will need to complete what's called the Family Violence Intervention Program. It's a series of classes that will help you interact with family members in a way that is different from what happened in your second case that I'm about to sentence you for, when you struck the mother, Ms. Jones, the mother of at least one of your kids, in the face multiple times. I will waive your probation supervision fees for the first 3 months as you figure out how to get back to work. In your second case, 23 SC 187978, the family violence battery matter. Count 1 is dismissed. Count 2 is 12 months to serve. That will run concurrently with your sentence in the case ending in 104. And finally, 23 SC 189483, which is your most recent high-speed chase, where it sounds like other than vehicles getting hurt, only you got hurt with a bump on your head. The state is proceeding only with count 3. All the other counts are being dismissed. And your sentence in that case is 5 years to serve. That will run concurrently with your sentences in the other 2 cases. So overall, 15 to serve 5, balance probated. You heard what the conditions of probation are. Ms. Wood, anything else on behalf of Mr. Cozart?
No, Your Honor.
Ms. Nix, anything else?
Yes, sir.
Ms. Willingham?
Nothing further.
Ms. Tucson, I don't think we need to give Mr. Cozart reporting instructions because he won't be reporting for a little while. Is that correct? Or is there something you need to share with him?
That is correct. All the reporting instructions will be given when he's in custody, when he's getting ready to report. They'll let him know which office to report to.
All right. And just to repeat, when you get out, again, it is 3 random drug and alcohol screens a month for that first year. After the first year, it's down to 2 a month, and probation may decide to lower it even more. If you're clean all the time, we don't need to waste your time or their time for you doing screens, but we need to make sure that you are in a healthy place on that front when you get out. Okay? Thank you.
Thank you, Judge.
Thank you, Judge.
Mr. Mondelli?
Yes, Judge, good morning.
Good morning.
Here from Mr. Mayberry's plea, I just need to speak with him briefly to.
Great. If you just let that deputy know right there, when you are ready, we can do the plea.
Good morning, Your Honor.
Hey.
Mayberry here on behalf of Mr. Bobby Bradley.
You are with Mr. Render.
Yes, that is correct, Your Honor.
Great. Tell me what we'll do. I heard, thank you for being here. You two are both in trial, I think.
Yes, that's correct.
Which I guess is good. We're frustrated because he was supposed to be in trial down with Judge Emerson on the first floor. But he had a conflict. You're in trial in Clayton. But we had him on our consolidated calendar. Because we actually got Mr. Regis in the same courtroom at the same time. That's hard to do. So I had heard Mr. Bradley might be a plea. Otherwise, we might talk about bond. And that's Ms. Willingham. What are we doing?
So I did speak with Mr. Bradley. We are gonna withdraw the motion for bond, and he does want to accept the plea.
Okay.
I got the offer yesterday. I know on our entry, it was limited purposes for bond. I don't know if we can handle the plea.
You can.
Okay.
Yep.
We'll do it.
So we'll do that. Do you need to talk with Mr. Bradley first, or you already went back there?
I will make this one.
Okay, so you're ready on that?
Yes.
Great. And Ms. Gibson?
Judge, I am back and we are ready for a plea with Ms. Ragland.
Okay. And is Ms. Ragland not in custody?
She's not, she's.
Great. Let's do that. And then how long do we have you? I know you need to be back in Clayton.
Yes, I mean, it's getting close to lunchtime, so
Okay.
I'm going out before lunch.
So we'll do it before lunch. So what we'll do Ragland, and then I want to make sure we do Mr. Mondelli's plea and your plea. So we'll knock all those out before we break for lunch, and then we'll see what else we're doing, okay? But we can do Ragland right now. So let's do that. Ms. Ragland, will you come on up, please?
She said, I'm with them since this case, so yeah, because I said, I thought I had a job for it. So like he rejected it, never went through, and he's like, make sure you stand on this side against the microphone. Which one? I think so, yeah. Okay. I feel like she already did that. Yeah, I didn't see it. Okay. Well, then I guess it's. He does. She's gonna reduce her misdemeanor because she wants him to have plates.
Is this to all the counts? Are you reducing anything?
Count 1 is reduced to battery family violence.
So it's a misdemeanor plea.
Yes, 16-5-20. Oh, Miss Nelson, I can't remember it now.
I'll look it up. That's okay. We're not on the record yet. I just.
I know, but I know she listens for it. So.
I'll get it to her. I'll get it to her. Okay.
And the other 2 counts are actually being non-processed.
Arch. Okay. So plea to count 1 misdemeanor.
Yes.
Got it. Ms. Gibson, are you guys ready?
Yeah, ready.
All right, then let's get on the record. This is position 9 on our final plea calendar, 24 SC 000489. Ms. Ragland is here in court with her lawyer, Ms. Gibson. Ms. Willingham is here for the state. And Ms. Ragland, what Ms. Willingham just shared with me is that you are pleading guilty to 1 count that's being reduced to a misdemeanor. Is that your understanding?
Yes, sir.
Okay. In a moment, Ms. Willingham's going to put you under oath. You'll need to answer her questions and mine. If you have questions at any point for your lawyer or me, will you let either of us know?
Yes, sir.
Great. Let's go, Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
You can put your hand down. Please state your name and your age.
Erica Ragland, I'm 35.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
How far did you go in school?
I completed high school.
Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the document that charges you in this case?
Yes, ma'am.
Do you fully understand the nature of the charges pending against you?
Yes.
By pleading guilty today, you are giving up certain rights: the right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, ma'am.
The recommendation in this case is that count 1 would be reduced to battery family violence, the misdemeanor, and counts 2 and 3 would be null pros. It would be a period of 12-month probation, complete family violence intervention program, have no violent contact with the victim, complete 60 hours of community service, have no weapons, no drugs, or alcohol. Is this what was explained to you?
How many hours of community service did you just say?
60.
But we agreed, I thought, to a reduced 25.
You're correct. 25 hours of community service. And Judge, I did want to flag that it is my anticipation that the defendant will be asking to use first offender. I have reviewed her criminal history, and I'm bringing this up now so that maybe pretrial can kind of look into it. There is a prior conviction on her history. However, it is my understanding that Ms. Ragland has a twin brother, and that is actually his conviction. I have not had an opportunity to confirm that. I have spoken with defense and let them know that in the event the court needs us to wait and do this at another time so we can, I'm fine with that. But I wanted to see if maybe while we're getting through it, pretrial can maybe figure it out.
Okay. Did you hear that, Ms. Hardy?
Yes, sir. Yes, Your Honor.
Okay. We'll await your report at the appropriate time. Thank you.
No problem.
You're pleading guilty today to battery family violence with a minimum of 1 day and a maximum of 12 months. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No, ma'am.
You heard me tell the court what the negotiation is in this case, which is 12 months probation. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 12 months in custody?
Yes, ma'am.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. Under the special conditions, you are to complete family violence intervention program, have no violent contact with the victim, complete 25 hours of community service, have no weapons, no drugs, or alcohol. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, ma'am.
Are you entering your plea of guilty with an understanding of everything we just talked about?
The family, you said family convention?
Family violence intervention program.
Intervention program. What's like, is that it's with the probation?
It's a 24-week program. I do believe there's a cost for it. But it is a 24 classes. I don't know how they structure it, whether or not you have to go once a week, but it is actually a statutory requirement of family violence charges. But that is a program for just you. This is not the one that was discussed regarding you having to go with the victim.
Because I'm not set up financially to pay for a class.
Well, there are a number of organizations that offer it, and some of them are needs adjusted. So if you happen to be working at a bank with a big salary, you pay full fare. But if you are in a situation, either because you work part-time or you're home with kids or a loved one or whatnot, they can adjust that. So I wouldn't worry about that being an obstacle. The commitment is you go into the classes. And so as long as you understand that you've got that obligation, generally probation can help you find one that would be adjusted to your ability to pay.
Okay.
Did you have any more questions?
No, ma'am.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, ma'am.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes, ma'am.
Do you have any more questions for your lawyer before we go on?
No, ma'am.
Have you understood everything I have asked you so far?
Yes.
Understanding all of your rights, do you wish to enter a plea to these charges today? Or
Yes,
to
ma'am.
this charge today?
Yes, ma'am.
Is your decision to plead guilty made freely and voluntarily?
Yes, ma'am.
Did you in fact commit the offense to which you are pleading guilty?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 12 months from the date the sentence is entered to file this petition. Do you understand these time limits?
Yes, ma'am.
It is my understanding you're requesting from the court to be treated as a first offender. There are benefits and risks to requesting this status. Benefits are that if you do what the court orders you to do and do not violate the terms and conditions of your probation, you will not have a conviction for this offense. The risks are that if you violate this sentence or your probation, commit a new offense, etc., we will ask that you be brought back into court and ask that you be adjudicated guilty, meaning you will have a conviction. And then the court can re-sentence you up to the maximum sentence we discussed earlier, which is 12 months in custody. Knowing all of this, do you still want to be treated as a first offender?
Yes, ma'am.
Have you ever been convicted of a felony before?
No, ma'am.
Have you ever used first offender in any other case or any other place?
No, ma'am.
Your Honor, if the state were to proceed with this case, the state would prove beyond a reasonable doubt that on May 5th, 2022, officers were dispatched to 1121 Custer Avenue Southeast in reference to a domestic dispute. Upon arrival, officers made contact with Erica Ragland and Nicholas Andrews. Ragland and her children were sitting in her vehicle in the driveway and the door to the residence was open. Ragland and Andrews have been together for 4 years and got married in April 2022. They also have 4 children together. Both parties told officers they had been arguing all day. It started when Ragland was on FaceTime with Andrews, and during the call, her phone died. Andrews got upset thinking that Ragland hung up on him. They argued during the day, but at some point they separated. Later that afternoon, Ragland picked Andrews up and they both went home. At home, they continued to argue. Ragland told officers that she was trying to put their children, M&M, to sleep in the front bedroom when Andrews asked her why she wasn't going to sleep on the couch. They both usually sleep together in the living room, but on separate couches. This caused them to argue. Ragland stated she got up from the bed and confronted Andrew. She admitted to kicking Andrews, pushing him out of the bedroom doorway, and throwing a baby bottle at him. Andrews advised the altercation continued to the living room where Ragland slapped him in the face, threw bleach on him, and pulled him around by the collar of his shirt. Officers observed a hole around the collar of Andrews' t-shirt and bleach stains on his pants. Officers could also smell a strong odor of bleach emanating from his person. When Andrews attempted to get away from Ragland, she grabbed a pair of scissors with a blue handle and began to strike him with it. Officers observed open lacerations on Andrews' left shoulder and right forearm. Andrews told officers he used his right arm when he attempted to block her strikes. The lacerations officers observed were consistent with defensive wounds. Andrews also stated that the scissors were small and may have belonged to one of the children. Ragland never indicated that Andrews threatened her with a weapon or with words, and no visible injuries were observed on Ragland, as she never mentioned any injuries. However, she told officers that she believed her husband is mentally ill because he told her that the people were following him all day. Their youngest children, M and M, were in the front bedroom that leads to the living room where the altercation occurred. Ragland was taken into custody and transported to Fulton County Jail. Your Honor, I have had an opportunity to speak with Mr. Andrews multiple times, and I ultimately made this offer after speaking with him in our last conversation. Mr. Andrews and I spoke initially, and he was okay with the state's offer. He called back and was very upset and did not want the state to proceed at all. I'm sure, as Your Honor is aware, that is not uncommon in domestic violence cases. But Mr. Andrews had grave concerns about what the state pursuing this case would mean for his livelihood.
For his livelihood?
Yes. He stated that he is dependent on the defendant. And in speaking with the defense attorney, I know there are questions there. As Your Honor has also heard me read, that there may be some mental health issues. But for all of those reasons, I think that this was the best resolution for Mr. Andrews, especially, who I think was going to have a really hard time if the state moved forward beyond a negotiated resolution.
Okay. Well, thank you for sharing all that. Ms. Hardy, did you have a chance to do any research on Ms. Ragland's history?
Yes, Your Honor. I was able to see that Ms. Ragland has 3 arrest cycles, no felony convictions, probation violations, or anything else.
Okay. Any misdemeanor convictions?
There was no, it was dead docketed.
Okay. Well, all right. Then we don't need to parse out what was going on with her twin brother. Thank you for that. Ms. Gibson.
Yes, Judge. Miss Ragland is 35 years old, and in the past few months that I've gotten to know her, she is a dedicated mother. She is the sole provider to her 4 children, 2 of those being twin babies. As ADA Willingham stated, the alleged victim in this case does have a lot of mental health issues. His story goes back and forth a lot, and he often seems a bit confused with what is existing in reality. Miss Ragland is a good mother. She has had, as you heard, no convictions of any kind, and I expect her to do amazingly on first offender probation, and that this will soon be behind her. So we would ask that you follow the recommended sentence.
Ms. Ragland, do you work outside the home?
I do.
What do you do?
I drive school buses for Fulton County.
All right. And they know you have this case pending?
No.
They don't. Okay. I'm not going to tell them. Just curious. Well, certainly first offender will help keep that off their radar. How long have you been a bus driver for Fulton County?
For 2 years.
What did you do before that?
I worked at Wells Fargo.
And you and Mr. Andrews are now legally married?
Yeah.
Okay. Does he work?
I don't know.
How are you legally married and you don't know if he works?
Because we've been separated since the incident.
Oh, okay. Well, before the incident, was he working?
No.
How long have you known Mr. Andrews?
I have been knowing Mr. Andrews for like 15 years.
Have you ever known him to have a job?
Off and on.
Off and on? What kind of work?
Like warehouse work.
Okay. You two have been apart since this incident because that was a condition of your bond, or you decided it's just not smart for us to be in the same place?
Oh, it's not smart because of the situation.
Okay. You have how many kids?
4.
Is he the biological father of any of them?
Yes, sir.
Of all of them?
All 4.
All 4. But he is not helping take care of them?
Not at all.
Okay. What are their ages?
10, 8, and 2-year-olds.
Those are the twins, 2 by 2.
Yes, sir.
Where are they? Like 10 and 8 are in school. Where?
Right. They're with my mom.
With your mom, she's able to help out some?
Yes, sir.
What does a school bus driver do during the summer?
I'm working in summer school during the summer.
Driving a bus in the summer?
Yes, sir.
Year-round bus driving. Okay, good. So as far as you're concerned, Mr. Andrews is out of your life. If he's the biological father, he has a right to be with the kids. Does he ever reach out to say, I want to see the kids, or he's just disappeared?
I don't think he cares.
Okay. All right. Well, that's too bad for them. Do you have any questions about anything we talked about?
No, sir.
First offender is primarily a benefit if you successfully complete your sentence, and I have a sneaking suspicion you will. If you successfully complete your sentence, then, well, first of all, you don't leave with a conviction. I'm going to give you a sentence, but you're under sentence, but you're what's called a first offender probationer. So if anyone asks you for work or you want to go to school or anything, if you've ever been convicted, answer no. This is not a conviction. And if you successfully complete your probation, then it can all be expunged. And that is often valuable as you're looking for other work or trying to maintain your work.
That's one of the questions I had.
Yeah. There's a risk if you 2 months from now, 3 months from now, get arrested because Mr. Andrews came back and you poured bleach on him or hit him with scissors or whatever. Even if he was fighting with you, if you get arrested and have new charges, I can revoke your first offender status. And without a trial, you'd have a hearing, but no jury. I could say, you know what? I just read you the wrong way. And here you are mixing up with Mr. Andrews. And this time you stuck him in the eye with the scissors. I could revoke all your probation and it would become a misdemeanor conviction. So that's the downside. If you're pretty sure you are going to stay out of trouble, even though you got 4 kids, then first offender makes a lot of sense. Do you feel like you understand the benefit and the risk?
Yes, sir, I do.
Do you want to be sentenced as a first offender?
Yes, sir.
Okay. Well, Ms. Ragland, I find that there is a factual basis for your plea, that your plea is knowing and voluntary. I will sentence you as a first offender. I will sentence you to 10 months probation. It will be a special condition of your probation that you complete the family violence intervention program. You're going to want to get started on that because that's a bunch of sessions, as you heard. And you'll need to complete 25 hours of community service. No violent contact with Mr. Andrews. If he resurfaces, like I said, he's got a right to be with the kids. You just need to figure out how to navigate that with him where you and he aren't sparring again.
Okay.
I'm going to waive your probation supervision fees for the first 4 months as you figure out how you're going to balance all this stuff. And we'll see how that goes. Ms. Gibson, can someone from my office sign the indictment on your behalf?
Yes, Judge.
Ms. Willingham?
Yes, Judge.
And Ms. Ragland, is it okay if we electronically sign your name to count 1, which is being reduced to family violence battery, 16-5-23.1F, as a first offender plea?
Yes, sir.
Okay, and counts 2 and 3 are being dismissed by the state. So it's 1 plea, count 1, misdemeanor. Anything else, Ms. Willingham?
Nothing further.
Ms. Ragland, do you have any questions now that we've gotten through all this?
No, sir.
Ms. Gibson, have you talked with Ms. Ragland about how and where she reports to misdemeanor probation, or do you need information on that?
I do need information on that, Judge.
Ms. Nelson, how are we going to navigate that?
Judge, I will get a form to her.
Okay, I think Ms. Nelson said she's going to get a form to you, Ms. Gibson, because she's got your contact information. You in turn will get it to Ms. Ragland.
Yes.
Ms. Ragland, I think you have to show up the first time in person. Their office is about a block from here. But beyond that, it may well be telephonic reporting. I don't get the sense you're going to be a high maintenance client for them. And so they would rather focus on the folks who are being difficult. But don't take my word for that. They're going to let you know how that process works. But Ms. Gibson will get you the paperwork, and maybe you can simply call the very first time and say, hey, I'm Erica Ragland. What do I need to do? But they may want you to come down. Their office is right there on Mitchell Street. Okay,
Thank you, Judge.
all right, good luck with everything.
Thank you, Judge, and that concludes my business. May I be excused?
Yes, ma'am. Mr. Mondelli, are you ready?
We're waiting on Mr. Mayor.
Let's do it. Thank you. Well, that was fast. Let's see if someone can catch her.
What's her name?
Gibson, Miss Gibson. Hey, you. Right here. Got the form for you now.
Perfect.
Thank you, Ms. Nelson.
Thank you.
All right, Ms. Willingham, you ready?
Yes.
This is position 4 on our plea calendar this morning, State versus Willie Mayberry. Mr. Mayberry is out in court with his lawyer, Mr. Mondelli. And Mr. Mayberry, your lawyer has told me you are prepared to enter a plea. Is that correct?
Yes, sir.
Okay, we're going to do that in a moment. Ms. Willingham is going to put you under oath. Once you're under oath, she's going to ask you a bunch of questions, which you need to answer. But you should let me or Mr. Mondelli know if you've got any questions. I need to be comfortable that you're understanding all the stuff we're talking about. There shouldn't be any surprises, but if something comes up that's not making sense to you, will you let your lawyer or me know?
Yes, sir.
Great. That's the plan. Ms. Willingham, when you're ready.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Please state your name and your age.
Willie Mayberry, I'm 25.
Are you now under the influence of any medicine, drugs, or alcohol?
No.
How far did you go in school?
Some college.
Can you read and write in the English language?
Yes.
Have you had the opportunity to review the document that charges you in this case?
Yes.
Do you fully understand the nature of the charges pending against you?
Yes.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, ma'am.
The negotiation in this case is that count 1 would be null pros, and you would be entering a plea to counts 2, 3, and 5 for an overall sentence of 8 years to serve 6 months with the balance probated. As to count 2, the sentence would be 3 years to serve 6 months. As to count 3, the sentence would be 3 years to serve 6 months, and that would be concurrent to count 2. And as to count 5, it would be a 5-year probation sentence consecutive to count 2. You would be required to have no contact with the victim, complete family violence intervention program, complete a substance abuse evaluation and follow the recommendations, complete a mental health evaluation and follow the recommendations, and complete 60 hours of community service. Is this what was explained to you by your attorney?
Yes, ma'am.
You are pleading guilty today to aggravated assault, family violence with a minimum of 3 years and a maximum of 20, criminal damage to property in the first degree with a minimum of 1 year and a maximum of 10. Thank you. Don't
Understood.
need that one much. And count 4, possession of a firearm during the commission of a felony with a mandatory 5-year consecutive sentence. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No.
You heard me tell the court what the negotiation is in this case, which is 8 years to serve 6 months. Do you understand the court is not required to follow the recommendation, but can sentence you up to the maximum sentence permitted by law?
Yes, ma'am.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. Under the general conditions, you will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. Under the special conditions, as previously discussed, you would be required to have no contact with the victim, complete family violence intervention program, complete a substance abuse evaluation and follow recommendations, complete a mental health evaluation and follow recommendations, and complete 60 hours of community service. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, ma'am.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, ma'am.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes, ma'am.
Do you have any more questions for your lawyer before we go on?
No, ma'am.
Have you understood everything I have asked you so far?
Yes.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes.
Is your decision to plead guilty made freely and voluntarily?
Yes.
Did you in fact commit the offenses to which you are pleading guilty?
Yes.
Are you a United States citizen?
Yes.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 4 years from the date the sentence is entered to file this petition. Do you understand these time limits?
Yes, ma'am.
Do you understand that you are not allowed to possess firearms during the course of your probation?
Yes, ma'am.
Do you understand if you are found in possession of a firearm, you could be charged with another felony, which carries up to 10 years in confinement?
Yes, ma'am.
Your Honor, should the state proceed with this case, the state would prove beyond a reasonable doubt that on September 17th, 2023, Mayberry
Mayberry. Yes, ma'am.
and Foster were in a dating relationship and lived in the same apartment complex, but in different units. At the time of the incident, Foster was pregnant with the defendant's child. On the night of the incident, the defendant agreed to walk Foster's dog for her, but he did not. When Foster got home, she noticed her dogs had not been walked and her spare key to her apartment was missing. Foster walked her dogs and then went over to the defendant's unit. Foster demanded that he return her key, but he refused. He was intoxicated and a verbal argument ensued between the two. Eventually, Foster stated, "See, that's why I don't want to have your child, because this is how you act." He then threw Foster's keys at her, pulled out a handgun, and shot one time into the air. Foster started walking home and called 911 on her way to make a report. When Foster made it home, she turned off all of her lights and locked all of her doors. Approximately 5 minutes later, the defendant came to her apartment and started banging on her door. He demanded to be let in, and Foster refused. The two argued through the door briefly. Foster knew the defendant had a gun, so she was trying to convince him to go home. Suddenly, the defendant shot one round through Foster's glass sliding door. Once the door had shattered, the defendant pushed Foster's blinds aside and entered her apartment. She was screaming for the defendant to leave, but he continued into the house and partially up her stairs. She told the defendant that the police were on their way. He then fled the location. Foster had ring camera and interior cameras that captured the incident. The defendant can be heard banging loudly on both Foster's doors and yells, "Go home," a few moments later. He shoots through the sliding door and the glass shattered over the floor. He then walks into the apartment as Foster continues screaming. A few moments later, he's seen leaving before he returns through the front door. He can be heard pleading. She can be heard pleading. Foster can be heard pleading, "Please leave." Eventually, the defendant fled the location. Your Honor, I've had an opportunity to speak with Ms. Foster in this case. First, I will start with the reason for the non-processing of the home invasion. Although we do recognize the defendant shot into the home, one of the elements of the home invasion is that there has to be a felony that ensues inside. And we recognize from the facts and speaking with Ms. Foster, we were trying to find a way to get there, but we did not think we would be able to quite make it to that.
Because the allegation is he entered to commit the aggravated assault, but it sounds like he didn't point a gun at her. She may have been scared, but she said, "Scram, I've called the police." And in fact, he left.
Correct. And that is what her and I talked about at great length. So that is the reason for the non-processing of that charge in particular.
Got it.
As to the rest of the indictment, in speaking with her, her bigger concern was that she felt the defendant needed mental health treatment, that he needed substance abuse, and that she did not really want to proceed forward in prosecuting him when she thought that there were other issues at play. I explained to her that my position changed on the case solely because we were not able to move forward on the home invasion.
Right, not about the seriousness of what happened.
Correct.
Okay.
But based on that, that is the reason for the state's offer at this time.
Okay, and Ms. Foster is aware of it, and this is a no contact provision, not a no violent contact.
Correct.
She's
She
going
still does
her
not
way.
want contact with him.
Okay,
Yes.
got it. Has she, I guess mathematically she has to have, she's given birth to the kid.
No, Judge.
No.
No, she must have been barely pregnant then.
She unfortunately did not carry to term.
Oh, no. Okay.
And she has since moved from the location also, so she's not really worried about the defendant.
Okay, and they don't have that connection of the child. Okay, that is tragic, but also simplifies things for Mr. Mayberry.
Correct.
All right, thank you for that unfortunate update. And there's no suggestion that the trauma of September 17th resulted in the miscarriage?
No.
Okay, all right. Thank you for sharing that. Ms. Hardy, do you have any criminal history information on Mr. Mayberry?
Your Honor, this defendant has 2 arrest cycles, 1 arrest out of Georgia and 1 arrest out of Texas. No felony convictions, probation violations, or FTAs.
The police didn't come for.
What was the arrest in Texas for and when?
Like I can tell that.
Yeah.
I'm sorry.
1 moment, let me pull that back up. That arrest in Texas was wrongful use of a Schedule 1, 2, or 3 drug, and there's no disposition listed.
What was the date of the arrest?
December 11th, 2020.
Thank you so much. Mr. Mondelli.
When you're when?
When I was in the military.
Yes, Judge.
I didn't mean to interrupt you too, if you need, okay.
So Judge, we would ask you to accept the plea as negotiated. We had requested first offender treatment as part of our discussions, and we put that onto our paperwork there, Judge. As you heard, he has no felony convictions. The matter out of Texas related to his time in the military, which is why I don't think you're going to see a disposition.
Okay, I wasn't concerned more, it was just curiosity. If it was recent, I'd want to understand the Texas connection, if Mr. Mayberry is going to be staying here for supervision, but that was 3.5 years ago, and it wasn't an aggravated assault arrest, so I just wanted the full info.
So Judge, as you heard, there is no further connection with Ms. Foster, for better or worse. And my client intends to keep it that way. This was ultimately a toxic situation that spun out. And while I think there should be some benefit, especially from just a substance abuse evaluation, I know this gentleman to be an intelligent and articulate individual who had a full understanding in talking to me about the case, about what happened, his willingness to accept responsibility from the outset. And so we are here today for that purpose. So Judge, we would just ask you to accept the plea. I understand given the recommendation is a split sentence, there can't be an official bid date, but I would ask that the court consider a point where the probation can become non-reporting.
Okay. Tell me, just sort of summary, what did happen? I don't mean, no, this is, he didn't shoot through this door, he shot through that door, but what was Mr. Mayberry, he had too much to drink? Like, how did something like this end up happening? Because it doesn't sound like it didn't happen.
1 second, Judge.
Yeah.
Like it was just, I guess, mental health. It wasn't really drug related.
Judge, my client, and he can address you directly if you wish. It says this was mental health more than anything else. It was not drug related.
Okay.
In any way, shape, or form.
Got it. Well, let me ask Mr. Mayberry, what have you done since then to address you? I guess you've been in custody.
I entered a voluntary program. It's called Chris 180.
Yeah.
And they've been kind of helping me with with basically with life as is, like, and kind of sitting and doing my time has been kind of like showing me, like I was able to sit back, take a step back, take a breath, and understand that I have to receive mental health. I can't just keep putting it off. You know what I mean? And that's just one thing that.
And have you received a formal diagnosis that it's depression or it's bipolar or it's this or it's that?
No, sir, I haven't. Not an official diagnosis.
Okay. All right. Well, that will be part of your sentence. So you know what it is that you need to treat. Do you have any questions about anything?
No, sir.
And just to be clear, the Chris 180 group that he referenced has also reached out to me voluntarily to make sure that they were abreast of what's been going on with the court proceedings and seem to be willing to, assist him also upon release to help provide resources and things like that.
Good. Okay. They're a great resource. I hope you avail yourself of that. I'll tell you what happens too often is that once someone gets out, that someone says, it's all good, I'll deal with it later. It's easy to focus on you and what you need to do when you're in custody. Right. When you get out, there are distractions, there's a lack of interest, and I hope for your sake that you stay plugged in with that. First offender, Mr. Mondelli talked to you about the risks and the benefit of first offender?
Yes, sir.
Why do you want it?
I just want to erase everything off of my record officially. Because it doesn't describe or define me as a person. You know?
Okay, well, that's a reason to want it. It carries with it a risk. If, let's fast forward a year, you're not taking care of yourself and there's another incident like this with another person, it may well be that you are able to explain to me, hey, Judge, this really wasn't me. I wasn't taking my medication, or I just didn't take Chris 180 seriously. That will explain it. It won't justify it. And if you have shot a gun not at a firing range, I will tell you that's going to cause all this to blow up. You'll have new charges. And without a trial, you'd have a hearing, and Mr. Mondelli might be the lawyer who helps you at that hearing. But with a pretty low burden of proof, if the state demonstrated that you did some new bad thing to someone, I could revoke all this and resentence you. And your lawyer did the math for you. It's up to 35 years. I'm not saying it would be 35 years. What I am saying is if you're back in front of me in the next year and you pull the gun on someone, it will be a bunch of years that I revoke. Right. You'll have the new charges, but I will revoke these years. And so I just need to make sure you've thought through, is Mr. Mayberry ready for first offender? Because you've described the reason why you'd want it. But I want to make sure you thought about the risks that come with it as well.
Yes, sir.
Okay. And you want to be sentenced as a first offender?
Yes, sir.
Okay. I will do that. I find there's a factual basis for your plea. I also find that your plea is knowing and voluntary. No one's forcing you to enter this plea. In fact, you could go to trial next week. You're on that calendar for next week. And it's also knowing, meaning you've understood that what we've been talking about. Do you agree with that?
Yes, sir.
Okay. I'm sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation, which will be the bulk of your sentence, if you have a small issue, you and probation can work through that. But if it's more serious, it comes back to me. I will sentence you as a first offender. Ms. Willingham, do you authorize someone from my office to sign the indictment on your behalf?
Yes, Judge.
Mr. Mondelli, can we sign the indictment for you?
Yes, sir.
And Mr. Mondelli, you explained this plea of guilty form to your client where he initialed on many, many lines, and you've signed it on the 5th and final page.
Yes, Judge.
Mr. Mayberry, can we sign the indictment on your behalf indicating your first offender plea?
Yes, sir.
All right. And you had this plea of guilty form explained to you by Mr. Mondelli, and you signed it on page 4.
Yes, sir.
All right. Mr. Mayberry, I am going to sentence you. Count 1 is dismissed. Count 2 is going to be 8 years to serve 1 year with the balance probated. Count 2 will be 1 year to serve. Let me do that again because I forgot about the mandatory 5. Count 2 is 3 years to serve 1 year, 3 years to serve 1 year, balance probated. Count 2 is 1 year to serve, and count 3 is 1 year to serve, and count 4 has to be 5 years, has to be consecutive to count 2, and I will probate those. So that is a sentence of 8 years to serve 1 year with the balance probated. Before I give you the conditions, let me tell you some math. You've actually already done 8 months. You've done 240 days. I think, given how serious this was, that a little more time in custody is appropriate. That's my call to make. It's not your lawyer having not negotiated well for you. But I think this was serious enough that you need to spend a little more time in custody, thinking about what is best for you.
Let me just talk to him about that then, Judge, because the negotiation was expressed to reduce it to time served in some capacity, which is why the state's recommendation was for the 6 months as they referenced it.
Okay, so Mr. Mayberry's on a trial calendar. He doesn't have his final plea rights, so he doesn't get to, unless I'm misremembering.
Unfortunately, Judge, yes, because at the last final plea calendar, Ms. Willingham was unaware that this case was assigned to her, as you may recall. So we reset this and kept the final plea rights open through May 30th, which is the next official date.
Yep.
So that is why we have it that way, Judge.
All right, well, let me finish pronouncing the sentence, and then you certainly should talk about it. That's exactly what you should do. The special conditions of probation are all the same. No contact with Ms. Foster. You will submit to a mental health evaluation, and then whatever that doctor recommends, whether it's counseling or medication or both, that'll be part of your probation, that treatment. You'll also have a drug and alcohol abuse evaluation, and if there's any treatment recommended, that'll be part of your sentence. You'll complete a family violence intervention program, but you have plenty of time to do that, and you'll do 60 hours of community service. So all those things you and your lawyer have already talked about. What you two should talk about is the fact that I'm extending your custodial sentence by 4 months. You're parole eligible. I don't know that you'll do any of those 4 months, but I think it's a 1 year to serve, not a 6 months, which is really 8 months to serve. But you can say no, thank you. You still have your final plea rights. You should know that if you say no, thank you, then next week you're going to trial and a jury will hear from Ms. Foster about what happened, and a different judge, not me, will decide what sentence should be imposed if you are found guilty. Of course, you could be found not guilty. That's always a possibility as well. But the train is moving fast for you right now. And I just want you to know all those things while you're talking with Mr. Mondelli about whether you want to go forward with this plea, with a sentence that is different from what was negotiated. I acknowledge that. Or if you instead want to say no, thank you, and then potentially as early as next Monday, you're in front of Judge Emerson for a trial of this case. All right, you two talk and let me know what the plan is. You're welcome. Let's get Mr. Bradley going because I have a 12:30 meeting and I know Mr. Render's colleague is trying to get back to Clayton County. That's you, Ms. Willingham, as well. Dang. All right. Thank you.
The court back there.
Bobby Bradley, just one.
What happened? Oh, she doesn't have one. But wait, there's a plug right there. But since he's not here, there's plugs to share. I need to get more sockets right there. And Mr. Bradley is pleading to all the counts. What?
Count 1 and 4, Your Honor.
5.
1 and 5?
Aggravated assault and firearm by a felon?
Yes. Oh, yeah.
All right. Everything else is no prost?
Yes.
Can I have your name again, please?
No problem, Judge. Last name is V as in Victor, E-R-E-E-N.
Vereen, like Ben.
Yes.
Got it, Ms. Vereen.
Yes.
Thank you. And are you and Mr. Render in the same firm, or you
Yes.
got your own firm?
No, we are the same firm.
Great.
Same firm, yeah.
Are they able to bring Bradley out, or are there not enough people to have the lawyer back there? Okay, all right. Okay, excellent. What kind of trial is it in Clayton?
Murder.
Okay. Thank you.
You sign this for me. You finish high school, right?
Yes.
Yeah, sign this right now.
You ready for the trial? You ready for the trial, if that's where it goes? Okay. Sounds like you got one key witness.
Yeah.
All right. Let's pivot to position 12 on our final plea calendar. It is State versus Bobby Bradley. Hello, Mr. Bradley.
Hey, how you doing?
All right, how are you doing?
I'm okay.
Mr. Bradley, Ms. Vereen, who is an associate of partner with Mr. Render, who recently filed an entry in your case, tells me that you're prepared to enter a plea, it sounds like, to 2 of the counts of the indictment, and the rest of the indictment will be dismissed. Is that correct?
Yes, sir.
That's what we're going to do. Ms. Willingham is the prosecutor on the case. She will swear you in a minute, and we'll be underway. If at any point you've got a question or a concern about what we're discussing, let Ms. Vereen or me know so we can work through that, all right?
Yes, sir.
Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand out. Please state your name and your age.
Bobby Bradley, I'm 40 years old.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
How far did you go in school?
I graduated, 12th grade.
Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the document that charges you in this case?
Yes, ma'am.
Do you fully understand the nature of the charges pending against you?
Yes, ma'am.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, ma'am.
The recommendation in this case is that counts 2, 3, 4, and 6 would be null prossed. You would be entering a plea of guilty to counts 1 and 5, each with a 5-year probation sentence, and those counts would run concurrent or together. So it would be a total of 5 years probation. You would have to you would have no violent contact with the victim, complete family violence intervention program, complete a substance abuse evaluation and follow the recommendations, complete 60 hours of community service, have no weapons, no drugs, and no alcohol. Is this what was explained to you by your attorney?
Yes, ma'am.
You are pleading guilty today to aggravated assault with a deadly weapon, family violence, with a minimum of 3 years and a maximum of 20, and possession of a firearm by a convicted felon with a minimum of 5 years and a maximum of 10.
Yes, ma'am.
Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No, ma'am.
You heard me tell the court what the negotiation is in this case, which is 5 years probation. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 30 years?
Yes, ma'am.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. Under the special conditions, you are to have no violent contact with the victim, complete family violence intervention program, complete a substance abuse evaluation and follow the recommendations, complete 60 hours of community service, have no weapons, no drugs, and no alcohol. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, ma'am.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, ma'am.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes, ma'am.
Do you have any more questions for your lawyer before we go on?
No, ma'am.
Have you understood everything I have asked you so far?
Yes, ma'am.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes, ma'am.
Is your decision to plead guilty made freely and voluntarily?
Yes, ma'am.
Did you in fact commit the offenses to which you are pleading guilty?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 4 years from the date the sentence is entered to file this petition. Do you understand these time limits?
Yes, ma'am.
Do you understand that you are not allowed to possess firearms during the course of your probation?
Yes, ma'am.
Do you understand if you are found in possession of a firearm, you could be charged with another felony, which carries up to 10 years in confinement?
Yes, ma'am.
Your Honor, if this case were to proceed to trial, the evidence would show that on September 30th, 2020, around 11:30 p.m., Officer T. Bryan was dispatched to a dispute involving a handgun at 3000 Continental Colonial Parkway, apartment E101. Upon arrival, he was flagged down by the caller, who stated he is running. Officer Bryan approached the breezeway where he saw the defendant, Bobby Bradley, run away with the firearm in his hand and then went to the left of the rear of the building. The officer stopped in the middle of the breezeway and waited for the other unit to go around the back due to him having a firearm and being unable to see him. After another unit arrived and approached the rear, Bobby Bradley ran back towards Bryan, who pulled his department-issued firearm and gave verbal commands for the male to get on the ground. The suspect did not comply with orders and slowly began to walk toward the officer. The officers gave multiple verbal commands for him to lay on the ground flat and to keep his hands where he could see them. Bobby Bradley then got on the ground face down. As they were attempting to handcuff him, Bobby Bradley began to resist, and it took both units to detain the male. The male was then detained and frisked for firearm that he had when fled. The magazine to the firearm was in his pocket after a search before being placed in the patrol car. Bobby Bradley stated he did not have a firearm and does not know what we were talking about. The firearm was in the bushes on the left of the breezeway where he ran through. I spoke to the victim, Jacqueline Bradley, who stated she and Mr. Bradley got into a verbal altercation that escalated to him pulling out a handgun and pointing it at her face, pulling the slide back and telling her, "I will kill you." The children, Jay Bradley, Jay Parker, and Kay Griffin, were present during the incident, telling the officers they were scared and that Bobby Bradley pulled the gun out on her and said he was going to shoot her after he pulled the slide of the weapon back. The weapon was checked on ACIC and came back not stolen. The firearm was a black and brown Taurus PT 9mm. Bobby Bradley was taken to Grady detention due to him stating his mental health needed to be checked out and that he had suicidal thoughts. The 3 children stated they were not physically injured during the altercation. The other female in the apartment, who officers were unable to identify due to her not wanting to speak to police, did not make a statement. Your Honor, I've had an opportunity to speak, well, first in reviewing the body cam. I unfortunately do not have statements from the children on the body cam. And in speaking with Miss Jacqueline Bradley, this incident happened in 2020, and that is what she told me, and that she does not recall this incident. The other woman who was in the home is actually Mr. Bradley's wife, who I believe is present in the courtroom today. And outside of speaking with them, well, I did also reach out to her because I believe I spoke with her before I actually got to her mother. And they don't recall what happened that day.
So the listed victim in the indictment is a Jacqueline Griffin.
Yes, I'm sorry, Jacqueline Griffin. And that is his mother-in-law. That is his wife's mom, who they were all living in the home together.
Okay. And who is it that Mr. Bradley allegedly pointed the gun at and said, "I'm gonna get you"? Ms. Griffin,
Yes.
his mother-in-law.
Yes.
Okay,
And I have spoken with her, but she has stated that she does not recall.
doesn't remember. Okay, and you've also spoken with Ms. Bradley, Mr. Bradley's wife.
Who does not recall this day.
Okay. All right. There we are.
And I wanted to make sure that I noted that to the court, that it was a not recall factor, because as I did explain to defense, in this case, the defendant actually has a very lengthy criminal history. And he has a pending unindicted case. I believe Ms. Rockwell represents him on that. And that is a serious injury, I think, by vehicle. But our current case is one that I recognize I would have a hard time, as I would have to do quite a bit of impeaching. And that doesn't always fare well with a jury.
Right. Okay. Well, I appreciate your strategic decision. Ms. Hardy, how many cycles does Mr. Bradley have?
There's a total of 25.
All right. And how many felony convictions did you count up? I know there's one from Pennsylvania.
I was not able to pull the Pennsylvania history. I don't see any, and this one is showing Georgia and Massachusetts.
Okay. But are there Georgia felony convictions?
No, Your Honor.
Okay. All right. Thank you so much.
You're welcome.
Ms. Vereen.
Yes, Your Honor. As stated on the record, Mr. Bradley is 40 years old. He does suffer from schizophrenia and depression. Since being in custody on the 4th of February, I believe, he has been taking Risperdal, Effexor, and Benadryl to help with sleeping. He also sees Dr. Wooten at Grady. So a lot of the history, the cycles, this whole entire incident kind of stems from that. We're comfortable with the recommendation, but I would like to ask for a waiver of probation fees. At the time of his arrest, well, for first few months, at the time of his arrest, he was working at O'Reilly's Distribution. So since being in custody, he has, has to regain gainful employment. So if we could get some assistance there, that'd be great. And then I would also like to ask for a 3-year bid date as well. As mentioned, I know he has quite a bit of arrest history, but again, it's due to mental illness, which I do feel like he has under control now, and will further follow any protocols, procedures necessary to keep his mind balanced.
Okay. Thank you for sharing that. Mr. Bradley, when you get out, where is home?
I'm with my wife.
Okay. And does your mother-in-law still live with you as well?
No, sir.
Okay. Do you and your wife still live at the Continental Colonial Parkway Apartments, or have you moved?
We moved.
Okay. Were you, before you got rearrested on this case, taking any medication to help with the diagnosis you have?
Basically, yes.
What does basically mean? Sometimes you were, sometimes you weren't?
Yes.
Okay. All right. Do you have any questions about anything we discussed?
No, sir.
All right. Mr. Bradley, I find there's a factual basis for your plea, but this case happened almost 4 years ago, and it sounds like some folks may not remember it so well, and that's why we are ending it this way instead of some other possible way. I find that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this plea. You've decided after speaking with Ms. Vereen that this is the right way forward for you. Is that correct?
Yes, sir.
Okay, and knowing means you've understood all the things we talked about.
Yes, sir.
All right, I'm sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation, if you have a technical violation, you and probation will take that up. But if it's substantive, you get arrested again, something like that, that comes back to me. Ms. Vereen, can we sign your name on the indictment electronically on behalf of your client?
Yes, sir. You may.
Ms. Willingham?
Yes, Your Honor.
And Mr. Bradley, is it okay if we sign your name on the indictment showing the guilty plea to counts 1 and 5?
Yes, sir.
We'll do that. I'm going to sentence you on count 1 to 4 years to serve 6 months with the balance probated. By my math, you've done 200 days, a little bit more in custody. You were in custody for about 100 days when you were first arrested way back in September of 2020. You'll get credit for that time. You've been in custody for another 100 days most recently. 6 months is less than 200 days. So it's 4 years to serve 6 months with a balance probated. So that's 3.5 years probation. No bid date. We're just shortening the probationary window. Special condition number 1 is no violent contact with Jacqueline Griffin, your mother-in-law. Doesn't mean you can't be around her, but don't point a gun at her. You'll need to complete a family violence intervention program. You're going to submit to 2 different evaluations. One is a mental health evaluation. So you go back to maybe the doctor you're already seeing so that probation can know what's a good course of treatment for you, whether it's seeing that doctor regularly or taking medication, maybe both. But whatever that doctor recommends, that's part of your probation. So if that doctor says you take these little brown pills, it's not optional. If you're not taking them, probation's going to say you're not complying with probation, and we'll need to figure out what's going on. You will need to complete 60 hours of community service. And I'm going to ask probation to assign a mental health probation officer if they have that capacity. And that's just someone who is attuned to the needs you might have. So if you are going to Grady for counseling every once in a while, you're taking medication, this is a probation officer who knows after you take the meds, you may be a little fuzzy, and they're not going to worry, oh, he's been drinking again. No, it's not at all. It's because he took his medication. So that'll be a helpful thing if they've got those resources. I think I covered all of the conditions. No violent contact, family violence intervention, 2 different evaluations, drug and alcohol, as well as mental health, follow any treatment. Your sentence on count 5 is the same. It is 4 years to serve 6 months with the balance probated. They'll run concurrently with each other. And as I mentioned, you're going to get credit for both your stints in jail. Ms. Vereen, anything else on behalf of Mr. Bradley?
Just about.
I'm going to waive. Yes, sorry. I wrote it here just really small. I ran out of space. The first 4 months of probation, you don't have to pay the supervision fees because you're going to be getting back on your feet, hopefully getting back to work. But that may take a little bit. So that'll be a little expense your household won't have.
Yes, sir. Yes, sir.
Ms. Willingham, anything else for the state?
Nothing from the state.
Mr. Bradley, any questions about any of the stuff we talked about?
No, sir.
All right. Ms. Tucson, do you have reporting instructions for Mr. Bradley?
How much longer will Mr. Bradley be in custody?
A day, maybe. It's effectively a time served sentence.
Okay. Where do you live, Mr. Bradley?
1041, Landrum Drive, Atlanta, Georgia, 30311, apartment 10B.
I'm going to repeat that back. 1041 Landrum Drive. Is that Landrum?
It's LANDRUM Drive,
Okay.
Atlanta,
and you
Georgia.
said apartment 10B. And is there
Yes,
a phone
ma'am.
number? And what's your wife's name?
404-931-8605.
404-931-8605. And what's her name?
Miss Griffin, Jasmine Bradley Griffin.
341? 3041 is the apartment? Okay, the unit is 3041. 3041.
Yes.
Okay, I'm confused. Okay, I got.
You know what? I gotta stop. We gotta take a quick time out because I gotta get on this call and I need to know what we're doing, Mr. Mayberry. I'm gonna let you guys figure out the address to your heart's content.
I can email it to.
Okay, but we're pausing. We're on pause for a second. Mr. Mondelli, what did Mr. Mayberry decide? I'll get it on the record in a second, but this is taking too long with this address. Okay, can we get Mr. Mayberry right to the door and we'll get that on the record? Hey, Mr. Mayberry, I understand you are not thrilled with the way this played out, but you can be not thrilled with me. It has nothing to do with your lawyer's advocacy skills. I just think you need a little more time, especially if you're going to do well on the first offender. I just want you to just sink all that in so that when you're out, first offender is a good thing for you. But you have freedom of choice here. Do you want to go forward with your plea, knowing that it'll be a little more in custody, or do you want to withdraw your plea and have your case go to trial? With a plea? Okay, we'll do that. I've pronounced the sentence. You are good to go. I just need to get that on the record. Mr. Mondelli, thank you for your time. All right. So I got to step away. We're going to have Ms. Vereen clear up with probation the right address, and we'll get probation reporting instructions to Mr. Bradley, and we'll pick this back up at 1:30. People enjoy your lunch break. I will take direction from the lawyers as to what we're doing next.
Thank you, Your Honor.
At least one, possibly two. What about you?
Maybe. I don't know.
What's your email address? Easier. MD?
Oh, that's no, I heard this morning. He was like, I'm kind of trying to figure out what's
sure because I'm talking to Stanley and it's not sure. So I was like, I don't know what's happening. I'm just gonna link you guys up because it's easier that way. Alrighty, yeah, she's and she'll be like super responsive. You're welcome.
All right, thank you.
It's supposed to go with the aggravated assault and the bus. Amber is 12 months to open management facility. So this is good. So this whole time is a call trying to hurt you.
I think there might be maybe one bench warrant. Not yours. No, I think all your people showed up and, well, did you come in at Stevenson?
Okay, he got on, doesn't have money.
Lacey asked me about her, so
Okay, yeah, because I think Stevenson ended up coming in later, so no, I know they waived.
What's he doing?
Just arguing.
This is gonna be, Rios.
I did, he's thinking about it, I gotta go back there. and look.
Defendant was here.
So we'll have an update at one.
And this one was.
Sorry, go ahead.
Yep.
Yeah, he was saying something.
Technically, yes, but we don't come back to 1:30.
Oh, because that's something crazy. Okay.
I have a, there's an it's up to you. Okay. Okay. If I need you though, yeah, I know how to get in touch with you.
Yes. After anger management.
I guess we'll come back at 1.
That's, and he said one thing. But I know it's 12:30, so.
The calendar says 1.
Yeah, I know. That's why I'm gonna probably still be back at 1. I'm just gonna take drop some of this stuff off in my office so I can get
What's being said here?
Yeah.
Like if she's like eager to like.
and maybe go grab some chips from
She's
somewhere.
just sure. And she's expecting if she gets to affect her child, she's also suing.
No, it's not. That's why I said I'm just gonna run and take a few things back, but I'm not even gonna bother taking my computer back because I literally, by the time I get it open and get anything started,
For that to the civil.
time out back, so.
Just like this little part, I was like, if you want to guarantee.
It's just in
that
case
you
victims
don't
show up, I
end
wanna make sure.
And I was like, I don't think Brittany would do the time, because she has no history. I was like, I don't, but
It's not violent.
yeah. And so I was like, but if you want to guarantee all that, you should take a plea.
Right.
You're willing to risk it because you're adamant. I was like, this for the trial. And so she's out there talking.
Oh, wow. Yeah, like that's the only thing, because the trial, like, that's the risk. Like juries come up with all sorts of ideas. So like, that would be the argument. Like, you can't hear what's being said here, so like.
Yeah. There's a man at 5 o'clock in the morning in ski mask.
Right. Yeah. Scary.
Yeah.
So I don't know if it can go either way. That's the thing. You never know what kind of jury you're gonna get.
Yeah, let's see what she talked about.
I think all I have left with you, Megan, is Edward, right?
Yeah,
Jermaine, Stanley's, Jasmine. Oh, and Stevenson, do you think you'll have an answer today on this or not? Okay, so.
Because even if I think that she is qualified, I still have to get with the deputy.
Got it. Okay. Okay. I might just request that he keep the final plea rates reserved.
On Stevenson?
Yeah.
She's for P&A.
Oh my God, ignore me. Okay, perfect. And I can kind of do. I'm so sorry. Got too much going on today. That changes things because yeah, she's like trying to get out the door to get her kid from school. So
Yeah, we can,
I'll do the waiver. Yeah. Thanks for telling me that.
Do you know Prairie Sanders Way? That's the names.
That is an excellent question.
She puts with this here.
I'll find out and I'll remind her that we have to file waivers.
Do you have anything this afternoon or something?
I don't think so. I think all I have is something with Julian. It's the door lock.
Yes. But you come, you better go up.
I'm just gonna open it and see if she's in the hallway.
What are you doing?
The girl, she's
She has a civil case going on against Marta. She's just trying to talk to her civil lawyer to see what she can do. If she can take a plea, this would affect her civil case. So she's going to that might be a plea.
Is the Darius Sanders Way arraignment?
I'll have to do a waiver for him, but he came. Were you not here? Oh yeah.
The MARTA, I found out that they canceled like 3 southbound trains.
Oh, okay,
And
yes.
the reason I thought I looked at their Twitter.
Yeah.
You know, like I don't know if y'all ride the train much, but it only shows like the top, like the next arrival.
Oh.
And then it's got all these like bus cancellations. And I'm like,
oh my gosh.
So it did not, I didn't look at it for the response because it just said bus cancellations.
Yeah.
I don't think that it said maybe that's train cancellations.
Yeah.
So I was sitting there. For like,
Where do you live?
Midtown.
Oh.
I was sitting there for like 7 or 8 minutes. I was like, bus. You should be here by now. And so
Yeah. Oh.
I looked at the MARTA app and it didn't even have any southbound trains on.
Oh my
And I
God.
was like,
That's
something's wrong. So that's when I emailed Nelson and one of my colleagues. I was like, I don't know what is happening. It's not.
Yeah.
On trains coming and there are a lot of.
Crazy. He appeared and I was gonna sit in a waiver, but yeah, he was here.
Okay. I just had this still in my. Never went to.
Okay.
This is one tomorrow. Wait, this might be Christine. Sorry, not my memos here.
Did he give you what he put on your? What did he give you?
What makes I think the process is the same in non-complex as it is here. These ex parte felons.
Oh, yeah.
Okay. Just making sure.
Is this on YouTube right now?
I think you're muted.
Is someone just watching it on YouTube?
But yeah, it is. Let's see. Hold on. He usually puts up a lunch break sign. Oh, he didn't, but you're not in the camera view, so it's
Okay.
me scrolling.
How do you get on the YouTube
What do you mean?
to look at it?
You just on his page. I usually just type in McBurney, Judge McBurney YouTube,
really?
and it pops
On
up.
the you just
I think we're muted. They're probably gonna comment if not that I'm in the YouTube.
I don't think you are because the box that says.
Oh,
the box
because
that says someone is talking keeps lighting up.
okay, well, I'm gonna watch this little chat over here because I'm sure they will let me know if they hear me talking. That was too soon.
you put May 14th. Is this the part?
Oh, you might be on, go over here to your, like, chat, and then go to restricted mode. I don't know why it does this, and then turn it off, then it'll show up the live. I don't know why it does that. It drives me crazy.
And how do you know which one's live?
Oh wait, go click on his name. And then right there, and just make sure it's muted. I think it, like, yeah, I usually just click that just to be safe.
Fucking say.
I don't think she realizes she's gonna be.
Okay, so Stephanie, fall downstairs. Now, Stephanie's gonna move later. I just know that. I don't know. You get ready to call. So the fall downstairs. They just declared her downstairs. But if you go that hall, if we go that hall, right? Yeah. No, seriously, we go the hall downstairs. Okay.
Did y'all rate this looking different than this?
Yeah, use the one. I don't know if I sent one to you.
It wasn't in the, what you sent yesterday.
Here, I'll send it because it's got like specific, just, he likes it a certain way.
Yeah, I realized because I filed something. And
Yeah.
it was like, you need to put this in there. And I was like,
Yes, here's the waiver, and then I'll put a substitution in there too. There you go.
Thank you.
Yeah.
Ragland told me out.
I don't.
Hello. What's up?
Hey, Miller.
Yeah. Hold on 1 second. That is Jack's teacher. Hello? Yes, it is. Hey. No, it's no bother. Did Maitland give you the bag?
So we are muted. Ms. Tucson.
Oh, now she hears.
She might have the.
I just emailed her.
I just texted her.
Oh, good.
Somebody needs to say volume up.
Sorry.
Okay, I'm gonna walk to the clerk's office. Do you need anything?
No.
Okay.
Megan, the Siani Carter case is a mess. Did you read through all that stuff? Mm. Yeah, and on that, we would probably, I'm trying to see if we'll have the immunity motion, but even depending on the outcome of that, like, she did not need to take a felony on that case. The lady went to her house trying to kill them. The witnesses are like, yeah, she wanted guns. She didn't have enough bullets. And she's like, never mind. These other two guys are coming and they're going to bring guns for you to use. And she went looking for grandma's, then her, I guess, I think that was her godmother with her own kids in the car. She went to shoot up a place with her own kid in the car.
So they did go there.
Yeah.
But it wasn't just them that were doing the threatening. Siani was threatening them.
Did she go to their location?
She told them, come here, because I can't drive or something like that.
Okay, even if that's the case, I haven't looked through everything. They willingly went there with guns. I think that's a clear self-defense. If some people are coming to your place and whips out guns, you're not just going to sit there and not do the. And they beat up her mom with her kid in the car. They opened the door. They committed aggravated assault by hitting her mom's car. Totaled it, by the way. She has proof of that, but that's in the police report. And then opens the mom's door and starts beating on her with the 2-year-old in the background. Client's pregnant, by the way. I'm not sure when she found out if it was the before or after, but she was pregnant. She has a 2-year-old now, another 2-year-old. So they committed aggravated assault against the mom. Then they have guns and they're fighting them. This is not a case that is great for you guys either. Well, not even, I don't think it's bad for us. I think that if anyone, a jury will hear, someone came to my house with guns, beat up my mother, hit her car.
It's not her house, though.
But it's her godmother's house. They came to where she was.
It's everybody that they were fighting over's cousin's house.
She said it was her godmother. That's why her mom and her kid were there. So
I'm trying to get all of this figured out.
yeah,
like,
no, I have to do a
all of
timeline
the-
because it is a lot.
Because I mean, I've already got like 8 pages of notes
Yeah,
on everything, and I don't think that there's a consistent story going through.
yeah.
So I think there's only one person who says that the victim had a gun, if memory serves.
So what it was the friend that she initially got to take her there from the police report.
I mean, not that she had a gun on that day, but that she had a gun when she got out of the car.
Yeah. So she had a gun, and then she also, there's the 2 guys that they brought also had guns. They all came with, it was like 2 guys and like a few girls, and the guy for sure had guns that were drawn.
I'm pretty sure the baby daddy that they were arguing about. So.
I mean, it's a mess. I think the offer should be disorderly conduct, because also I did the criminal history check. Your victim has a history and my client doesn't. So your victim is not even supposed to have a gun.
I'm still looking at it.
Okay.
But
just know, I think short of a misdemeanor, this would go to trial. Are we on? Can they hear us?
I assume yes, because the yellow thing.
Oh no.
Um,
They will stop talking about Casey. Oh no, it's y'all are not muted. Okay. Does the trial happen like every month, or how often does he have trials?
There's 2 this month because at least there's 2 fall calendars. Because I don't think that we've got another one in June. I think the next one after the 30th is in July.
Oh, okay. Wait, there's no trial calendar in June?
Well, the calendar call that is on the 30th, the trials are happening in June.
Oh,
There's
okay.
not a separate call.
I'm still trying to understand how this works.
Cummings, I'm gonna look back at the GCI. But I'm pretty sure Cummings will get me a look at it.
Okay.
Right, they should stay court. And that's why I reduced it, because technically, it should have never been a felony level. But I'm about to look at his GCIC too, just to double check, but I'm pretty sure he was the one I reduced it from. I'm like, well,
Okay.
this is actually just like a misdemeanor. So, but if not, then we can do the.
Perfect.
So either route will work, but I'm
Yes.
pretty sure that's why I did it, was because it's actually a regular battery misdemeanor anyway.
How are you?
How's everything going?
I didn't have a conversation last week, so I'm gonna through there to see.
Okay.
Is that your only case? Well, like,
Okay, cool.
but I'll let you know.
I appreciate it. Thank you so much.
Do you know if there's a deputy back there?
I do not.
You'll be a person that will be completely satisfied.
Oh, yeah.
Second Corinthians 5:21, one of my favorite scriptures.
The bay, I see is unlocked. Then ain't back yet. Yeah. Yeah, he outside. Lean gone. I'm looking at him outside. Yeah. Nev was in court.
See, I think they just sent out the last thing, so it's okay.
He messing with my thing. Thank you.
It's either Caitlin or
Okay? We can eat. Go in there and sit down. Well, went out there and lock yourself out. He wouldn't have been able to come back in. I wasn't here. Can't see him yet. They just try. I took my first.
I didn't use the mom, but.
I got it on my computer. It's bigger. I heard her say, she said, they can hear us? I said, we're not even muted. They were just talking about something about a misdemeanor for somebody. But I see about 12 people on it, but they all got it muted right now. You can't see.
Very interesting.
Go down the line, it's on your name.
Yes, that would be really amazing.
This, co-director?
Yes.
Okay, it's nice to meet you in person.
Yeah, Lacey, it was a simple battery, family violence. But because it's simple battery, it's a different code section. So I've always been of the opinion that that doesn't elevate you because the way it reads is it has to be a battery family violence, a subsequent battery family.
That's what I'm here. The courtroom is not muted.
Huh?
The courtroom is not muted.
Okay.
Anyways, because you're trying.
Yeah, because I think it's still.
And I don't know, they're not back, I guess, because he's at 1:30, but I will explain all this to him.
Muted.
Let me see if anything went over.
Okay. Is that your reading? Would you all consider a reading of the statute that a simple battery family violence wouldn't necessarily be the basis for a subsequent battery family violence because it's still two separate code sections, is my understanding of it.
I think it has to be a previous conviction.
Battery family violence specifically, not simple battery, right? Okay, that was my thought.
I could be wrong, but I think that's what because it always in the GTS they say it's second or subsequent battery family violence.
Yeah, and they're actually two separate code sections as well, and it's not mentioned in the simple battery code section, but it is in the battery family violence. So.
Can't go pee-pee? Come on and go pee-pee. You know, went out there and locked himself out the house. He went out the door. And then messing with the thing, and then I heard it lock. Yeah. Hey, see, I got back. Got me along with the court.
I guess I can pull it up too, just to make sure, but I'm pretty sure that's.
You know, get me water still. You can get on your tablet. I kind of like little tablet now. I take it in the bathroom. You already know. Look at it. You know, folks, you know what? I just happened to just walk down probably. And then I went back upstairs to get the because I thought she was outside. And I came down the wrong appointment.
Oh, well, I was talking about the wrong court. Apparently.
Oh, okay. Well, you know, I mean.
Do you know
who was who in there. It's still Frank technically, but it's Cassie. It's basically, you will not have a template, you will have nothing to work with.
It's okay. It's all right. Understood. Understood.
This being really easy.
Yeah, the only thing I was worried about was whether there were any bond motions filed previously.
That's not gonna go in the jury room. This is being live streamed.
Oh, well, we were just talking about charges.
I know, they have comments on.
Oh my goodness.
Just thought I'd let you know.
Thank you.
Thank you.
You're welcome.
Come on, let's go to the bathroom. They ain't got started yet. See, I heard the lady say, the courtroom is not new, they just talking about stuff. I'm coming. But the pants are wet too. Okay, well, I'll go up there and look. I'll go up there and look, it might be a pair, something that, I remember seeing a little, something in that drawer. You have to start immediately. Stand outside what comes first. I like to have a good day today, right? Yeah, okay. Yesterday, we out there, I think we talking. And then I asked him. Good things over here.
Come on. His shirt wet too?
Thing on the 20th or 30th.
So I was looking at the 20th, I should have anything. The gratitude Kirkman Day and a lot of the interviews.
It looks like I'm curious when they do come.
His client was got shots and I was like, it's crap.
That's great.
Okay.
What agency?
APN. That's 16. Complaining that he just picked up. Which was pickups.
Is it one of those things where you just need to catch you have to go away, or do you feel like it's gonna just
He said he got a stomach virus too. Call me now.
That's fine.
So I called him because I needed the mileage on that kill. Because I got a message from State Farm for my discount. See where the mileage is now. I told him yesterday he got it. So I called him. I'm not gonna pull on that shadow because when I pull, aggravates.
When did the screen go black?
Couldn't drink that also long. Drink a cool sip on cool water too. That kind of then if you're dehydrated, you'll be nauseated. So you know what? I got to do this. I'm trying to get at home. I want to my I don't even know what I can try to eat. Maybe I can try a small bowl of oatmeal, you think? So, maybe just wait a little longer. I see mail. Look at the mail. Yeah, but he said he just scared that it might be more if you don't take it. The plea deal is saying you're guilty. But he just like his lawyer saying she can really sink him. She can really sink him if she want to. So that was it. The money they're gonna have her on too, because sometimes her words can change things. But that probation thing, what's that? Somebody just said something. Oh, she's on it too. Right.
Just asked me to cover your head on Monday.
That'll be fun.
Open. That one's gonna resolve today, so we're just gonna final plea hearing. Thank you.
I appreciate it.
And just to give you a heads up, this was
in here.
But if you look at the pages of really the one and I see how they do it, but when I call the victim's mom, the primary victim is actually the way that someone's doing it choked the mom. But when I talked to the mom, she said, and I'll do it and send it to you. I meant to do it before I went to New Orleans for conference, but I just forgot.
Okay. I appreciate you letting me know. That happens a lot.
Yes. And I'll CC you when I send the transfer memo, so that you'll be on the loop on it. And I'll go ahead and just have
Robert to discovery because he was the big one sending it.
Thank you. One time, McGriff told me, deputies are sending me a message. They're like, Ricky Lewis is there. I was like, what? And it's like, no, it's one of your cases. And I was like, never have heard this one thing. Sure enough, it was like a criminal.
Wow. Okay.
Everything was
Okay.
I'm not your daddy. All right. Mr. Jordan's here. Oh, and Deputy Gordon's here. Jordan and Gordon. It's my lucky day. We're sorting out ankle monitor woes, and more people are filing orders purporting to have come from judges when they didn't. We're trying to fix that too. Does it make sense to call the final plea calendar, or I guess we should clean up what we didn't finish from this morning? Let's do that, especially if they're folks who've been sitting here. So let me review this morning's calendars and we'll see what's still out there. From our plea and arraignment, Ms. Stevenson was the one.
Yes.
What happened with that?
Judge, we're still working on that one. I went ahead and did a waiver and in her plea of not guilty. And I got permission from Ms. Nelson to have her excuse. I didn't realize that she had a childcare issue. And so we're gonna keep working on that one. It
Great.
won't resolve today.
Very much the right thing to do. Thank you for doing that. So waive and schedule. But as usual, if you and Ms. Nix sort something out, don't wait for our final plea. Let's get Ms. Stevenson in here. But she is taken care of, and that ends that calendar. From the plea calendar, Cozart and Mayberry were pleas. And then we had Kevin Phillips. That was a Ms. Clark matter. I think she's coming back, or maybe she's on virtually.
She's on virtually.
She's on virtually. And you're taking that over from Ms. Feely?
Yes.
Is that generally, if it says Feely, it's now Wood, or there's no general? If it says Feely, it's usually Rios, except when it's not?
Yes.
Okay, that'll be easy to figure out.
This should have been mine to begin with. Ms. Feely was just doing me a favor.
Oh, okay.
I've spoken to him and I've spoken to Ms. Clark, and we're working on working this one out. We're just not there yet.
Okay. Today, you might get there later today, or?
Yes,
okay, great. Keep working. He's not going anywhere. Then from the final plea calendar, Mr. Jewell.
Yes, Your Honor. Mr. Jewell, this is a case that we're going to need a reset for. I think we are pretty close. My social worker is looking for a program, an outpatient program for him to address some of his mental health issues. Can we bring him out? I'm not sure if we. Yeah.
No, we certainly can bring him out. I just want to know what we're doing before I bring him out.
It's probably going to be a reset. Your Honor.
Okay, so he was on a trial calendar long ago and then got knocked off cycle because he became hard to find. Won't be hard to find anymore till we sort it out. Should we not move it to a trial calendar but preserve his final plea rights? Or is your preference that, what I don't like doing is moving another final plea, then another final plea, because there's less pressure to then get it resolved.
Yeah.
Whereas if we move it to a trial calendar, if A, we haven't sorted it out, great, we'll have a jury sort it out. Caveat, if Mr. Jewell is working through some of the things you said, trial isn't the right thing for him. It's getting him a program or support or whatnot.
Yeah.
But I'm less interested in resetting than saying, let's get it to a trial calendar, maybe a little ways out, if you think that gives you enough time to do what you need to do. And yes, I'll tell him all that.
On a trial calendar.
Okay.
I did want to address, I think you've already addressed his FTA. Would you be inclined to address that again?
What will we be talking about a second time?
To set it aside.
Okay. I think we already talked about that.
Okay.
But we can bring him out in a sec. We'll do that. How about Mr. McGillicott? He's here. He's been around. Ms. Wood, update on him.
Judge, we can just do the final plea hearing for him.
Okay.
When the court's ready.
Great. We'll do that in just a second. Mr. Cummings, Terry Cummings. Okay, great. We'll do that. Myandra Swinney. She's here.
Yes, Your Honor. I need to talk to Miss Sweeney. It's possibly a plea, but also possible trial. So I have to talk to her.
You need to talk to her more? Okay. Jermaine Stanley.
This will be a plea, Judge. I just need to speak with him once more.
Okay. And that ends that calendar. So why don't we, we'll just work our way in numerical order. If we can bring Mr. Jewell to the door. Hey, Mr. Jewell, how are you? Good. I just wanted to give you an update as to what we're doing in your situation. So let me copy this one thing here. I'm trying to get something to work. There we go. Your lawyer, Ms. Rios, and the prosecutor, Ms. Nix, it sounds like are real close to sorting things out. Ms. Rios wants to make sure that when you get out, you're going to get out. There's a good program for you to connect with. So we don't just repeat a cycle and then I see you again with the nice orange flip-flops and the blue jumpsuit. So Ms. Rios is asking for a little bit more time. She also asked for me to let you out now, but I said, no, I'm going to keep you where you are until we either get you a trial or Ms. Rios and her team are able to find a program that can support you once you get out. So I'm going to move your case to a trial calendar so we don't forget about you. And either when I see you next, it'll be time for a trial, or you and Ms. Rios have agreed with the state in a way to work your case out short of a trial. Does that make sense?
I'm going to a program on the outside, 10-part place.
So that's part of the program. 10-part place isn't so much a program as it is a piece of the support. That's where you can get counseling and maybe medication, a prescription. 10-part place is 100% part of what needs to happen. I think Ms. Rios wanted to find a little bit more. I don't mean to speak for her. She's going to keep talking with you, and she may have someone on her team come talk to you before we finalize how this is going to work. But I'm not going to keep you waiting long. I'm going to put you on the next available trial calendar. And so, like I said, we'll get you back here either before that trial or worst case scenario, June-ish, get you in here and like, hey, if we can't work it out, let's have a jury here about what the case is about. Does that make sense? Okay, any questions for me? Ms. Rios, was there anything else you wanted to cover?
No, Your Honor, thank you.
Okay, so what should Mr. Jewell be expecting, that you'd see him soon, or would it be Ms. Ross?
Ms. Ross will be seeing him very soon.
Okay, Ms. Ross is a close colleague of Ms. Rios's, and she's the one to talk to you more about programs and 10-part place, okay? Ms. Nix, anything else from the state on Mr. Jewell's case?
Yes, sir.
I will preserve his final plea rights. I don't know that that will even need to come into play, but if you do arrange a plea, he'll still have his final plea rights to say, no, thank you, if for whatever reason I differ from what you all have negotiated.
Thank you, Your Honor.
Okay. All right, Mr. Jewell, we'll see you soon. Mr. McGillicuddy, you should come on up to the podium, please, with Ms. Wood.
Sure.
Just leave it right there. It'll be safe.
Just do it.
All right. Ms. Rivers, are you back with us?
Yes, I am, guys. I'm ready.
Great. Let's get on the record in position 3 from this morning's final plea calendar. It's 23 SC 189972, State versus Edward McGillicuddy. And sir, you are charged with possession of methamphetamine with intent to distribute and a misdemeanor related to you allegedly having drug-related objects, like a scale or a pipe or who knows what. Ms. Wood looked like was trying to see if you could work your case out today. It's not required that you work it out today. But because you haven't, I need the state to get on the record what its offer is. So you can tell me, you know what, Judge, I'm not interested in that, or I am interested, and we're going to go from there. Ms. Nix, if Mr. McGillicuddy decided he wanted to plead guilty today to the 2 counts that I see, he seemed confused when I mentioned the second count, and we'll clear all that up. I'll get the indictment up in a minute. Regardless, if he wanted to enter a plea today, what would the state be recommending?
Judge, the state was first recommending that the defendant apply for drug court. In lieu of that, the state's recommendation is a 10-year sentence that the defendant serve 1 year with the balance on probation. The defendant also has a pending probation revocation that we would handle along with this case.
Oh, okay. There's not a warrant for that revocation?
He was arrested on it, and it was, I guess, not recalled, but kind of held off until we could handle this case. And so he was released from custody.
Okay, lucky him. Ms. Wood, what do you want to add to that to include an explanation as to why Mr. McGillicuddy's not interested in drug court?
Judge, he maintains his innocence. This is the case that has the co-defendant.
It does.
Needs to be transferred to this courtroom to track along with that.
Okay. And it may be that Ms. Merkey needs drug court, according to Mr. McGillicuddy.
Yes, Judge.
Okay, got it. Mr. McGillicuddy, you understand that if you were to enter a plea today, which you don't have to do, the state would be recommending that sentence of 10 to serve 1, or in the alternative, it would be a plea to a term of probation, the primary condition of which would be that you enter into and complete drug court. Those are sort of the 2 competing recommendations from the state. And you don't have to be interested in either of them. And if that's the case right now, that you would rather have this case go to the trial calendar, that's what I'll do. You're on our July trial calendar. We just get you back by then at the latest to say, let's do the trial. In between now and then, we're going to get your co-defendant over here, and I'm going to start sorting out what's going on with her case. Excuse me, it sounds like you're not interested in either of those offers from the state. Is that?
May I speak freely?
Well, freely enough, your lawyer may put her hand over the microphone and say, stop saying these things, because of course the prosecutor's sitting right here. Okay. And so if you say, I'm making this up, but if you say something like, only half the drugs were mine, that's not going to serve you real well.
I just want to.
Well, I will just preface that I think I know what he's going to share with the court, and it would be appropriate to share that with the prosecutor, which I've already done. It's not up to the judge.
Okay. Also, the 2 charges. Did you say possession with content and possession?
So here what I'm going to do. I'm going to pull up your indictment right now so I don't misspeak. I was looking at the calendar, which generally flows from the indictment, but here is your indictment. You are charged with, come on, indictment. You are charged with counts 1 and 3. Number 1 is possession of methamphetamine with intent to distribute. Way back on December 29th, 2021, you supposedly, you and this young lady, possessed methamphetamine with intent to distribute. The young lady is also charged with having a gun. You aren't. And then count 3, the 2 of you are charged with having a scale and allegedly a meth pipe. And then count 4 is just the young lady. Apparently she was driving because she ran a stop sign. That's it. I don't want you to talk about the facts of the case because that's not going to help you right now. You know what the allegations are, and they may be ridiculous allegations. They may have nothing. You may not even been in the car. You may have been in the car handcuffed and she had a gun to your head saying, you have to roll with me. But don't tell me about that. You tell your lawyer, she'll tell Ms. Nix about it. What I'm gathering from you is you are not interested in pleading guilty and getting a year in prison, nor are you interested in pleading guilty.
No, sir,
and
no,
going to
I've
drug
changed
court.
my life and I'm not guilty for none of the things that you just mentioned.
Okay. Then what I'm going to do is move your case to a trial calendar. I'm also going to see if we can get your co-defendant's case sent over here soon. And hopefully she is a findable person. And we'll see what's happening with that. I'll move your case to the trial calendar. You understand that after today, you can always enter a plea. You could change your mind and say, I'm going to enter a plea. The state offers, so you know what, I'll take this. I want to make the case go away. What'll change after today is you don't get to withdraw your plea if I give you a sentence you don't like. Understand that?
Understand. I understand.
Good. Then we're all set. I'm sorry you had to stay here so long. This morning got a little congested. We had some longer pleas. Do you need anything else, Ms. Wood, from your client?
No, Your Honor.
You have good contact info for him?
We do.
No discovery issues?
No, Judge.
Ms. Nix, anything else from the state?
No, sir.
All right. I will see you at the latest, Mr. McGillicott, when we call our trial calendar for July. Because you'll have to
date, right?
She'll get you all that. Well, you should also get something in the mail.
I think I got one date right here. Is it July 2nd?
Yeah.
Okay.
You're golden.
Thank you.
All right, you're pretty good.
Moving right along, Terry Cummings. Come on up, Mr. Cummings. And Ms. Willingham, I may be able to make that camera go on. Things got better. The jury, actually, if you want to stay right there, as long as the microphone works, because the angle we have now gets everyone.
Okay.
So,
Because our screen's black over here now.
well, that's not an improvement.
And Judge.
How you doing? Good.
The code section technically remains the same on this, but I did want to specify that this is actually going to be a misdemeanor battery family violence.
Okay, but I think it's still F.
Yes, it's F, and it's still, even when we send it in as subsection 1, it still is subsection 2 for clerk's purposes. So I just wanted to make sure that I specified it's going to be the misdemeanor.
Was it indicted as a felony? Huh, okay. All right. Ms. Wood, are you good to go?
We're ready, Judge.
All right, going on the record, this is 24 SC 000483, State versus Terry Cummings. Mr. Cummings is in court with Ms. Wood. Ms. Willingham is here for the state. Mr. Cummings, you're charged with family violence battery in this indictment. It was charged as a felony. Ms. Willingham is telling me that you're pleading to it as a misdemeanor. Is that your understanding?
Yes, sir.
Great. Ms. Willingham will put you under oath and then ask you a bunch of questions. You've had to sit through a few pleas today, so you know how this is going to work. You need to let me know if you've got any questions, okay?
Okay.
All right, let's do it.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yeah, ma'am.
You can put your hand down. Please state your name and your age.
Terry Cummings, 27.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
How far did you go in school?
12th grade.
Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the document that charges you in this case?
Yes.
Do you fully understand the nature of the charges pending against you?
Yes.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes.
The negotiation in this case is that the single count of this indictment, battery, family violence, felony, would be reduced to battery, family violence, misdemeanor. And you would have a 12-month probation, have no contact with the victim, complete family violence intervention program, complete 40 hours of community service, have no weapons, no drugs, or alcohol. Is this what was explained to you by your attorney?
Yes.
You're pleading guilty today to battery, family violence, misdemeanor with a minimum of 1 day and a maximum of 12 months. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No.
You heard me tell the court what the negotiation is in this case, which is 12 months probation. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 12 months in custody?
Yes.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. Under the special conditions, as previously discussed, you would be required to have no contact with the victim, complete family violence intervention program, complete 40 hours of community service, have no weapons, no drugs, and no alcohol. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes.
Has anyone used any force, threats, or promises which cause you to plead guilty against your will?
No.
Are you satisfied with what your lawyer has done for you in this case?
Yes.
Do you have any more questions for your lawyer before we go on?
No.
Have you understood everything I have asked you so far?
Yes.
Understanding all of your rights, do you wish to enter a plea to this charge today?
Yes.
Is your decision to plead guilty made freely and voluntarily?
No.
I'm sorry?
Do you say yes or no?
I say yes.
Yes.
Did you in fact commit the offense to which you are pleading guilty?
Yes.
Are you a United States citizen?
Yes.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 12 months from the date the sentence is entered to file this petition. Do you understand these time limits?
Yes.
If the state were to proceed with this case, the state would prove beyond a reasonable doubt that on January 23rd, 2022, Officer Sample Britton of the Atlanta Police Department responded to a domestic dispute call at 1994 Bent Creek Way Southwest. There he met Shakevius Richardson, the alleged victim. She reported her child's father, Mr. Terry Cummings, assaulted her. Richardson stated the altercation started as a verbal dispute that became violent when Mr. Cummings threw an unknown object at her. After Cummings threw the object, Richardson pushed him. In response to the push, Mr. Cummings punched Ms. Richardson in the face. Officer Sample Britton observed swelling on Ms. Richardson's head. The officer detained Mr. Cummings and asked him what happened. Cummings replied that Ms. Richardson threw objects at him and then hit herself in the head. The officer did not observe any visible injuries to Cummings. Mr. Cummings was then taken into custody. And Your Honor, I recognize that it might be odd to see this go from a battery family violence felony to a battery family violence misdemeanor. I would direct your attention to the way the case was indicted is actually charged with the prior conviction being a cruelty to children second. So I then did some digging to see if at minimum Mr. Cummings had a previous battery family violence, which is the charge that actually would have been needed.
Right.
And I would have reindicted it for that reason. However, in review of his criminal history, he has a prior simple battery family violence, but per the code section, that does not get us to a felony. So in reality, this case probably should have always been charged as a battery family violence.
Okay.
So.
All right. It's interesting because it sounds like he did some pretty bad stuff to his kid. I'm looking at the 18 SC case to which he pled guilty, which is the basis. It would be the predicate that really can't legally be the predicate for the felony family violence battery. But Skylar Cummings got pretty badly mistreated by Mr. Cummings Sr. here, to which he pled guilty. And I guess he wasn't still on probation in that case when this happened, although he was on probation for a bunch of other cases when he pled in front of Judge Newkirk to what happened to Skylar. So it's not a super track record, but we'll hear more about it. Ms. Hardy, are you back? You are back with us. Can you share with me criminal history information for Mr. Cummings?
This defendant has 8 arrest cycles in Georgia, felony conviction in 2019 for cruelty to children, and 2018 aggravated assault. There was 1 probation violation, nothing further to report.
Okay, thank you. That's interesting because his sentence in the 18 SC case lists 3 convictions, a 19 SC, which is bizarre. I guess he pled to that at the same time. And then he was being revoked in a 15 SC and a 17 SC. But either way, that's helpful information. Thank you. Ms. Wood.
Thank you, Judge. Mr. Cummings actually served 116 days for this case. So we would ask for that credit. It was January 23rd, 2022 until May 18th, 2022. Judge, he's been eager to resolve this case since I met him. He is no longer romantically involved with Ms. Richardson, so I don't think there will be any issues moving forward with them. Hopefully, Judge, we would just ask that you accept the state's recommendation.
All right, Mr. Cummings, you and Ms. Richardson have kids or don't have kids?
We got kids. We got 3.
3? How many kids total do you have?
Yeah, there's 3.
3, and all with Ms. Richardson?
No, they were my grandma.
Oh, I didn't ask that well. But the mother of your 3 kids.
She's the mother of the kids.
She's the mother, but your kids are with your grandma.
Mm-hmm.
Her grandma or yours? Okay. And is Skylar one of them?
Mm-hmm.
Okay. How old are the 3 kids?
8, 7, and 6.
And they live, like, each night when they go to bed, they're going to bed at your grandma's.
Mm-hmm.
Do you stay there?
I go there because I stay with my mom.
You stay with your mom?
Yeah.
Okay. And Ms. Richardson is out of your life directly, but she is still active in her kid's life?
She see them once a while, but they don't have contact with her like that.
Why is that? That's her choice?
Yeah. That's
You haven't said you cannot see the kids.
Oh, no.
Does Ms. Richardson have other kids?
Uh-huh. Let's see. She's got a baby.
Okay.
Another baby.
All right. But these 3, she doesn't spend a lot of time with. No? Okay. All right. Do you have any questions about anything we talked about?
Oh, no.
No? All right. Well, Mr. Cummings, I find there is a factual basis for your plea. A couple years ago, you and Ms. Richardson got into it. It sounds like they could have almost flipped a coin. They're going to arrest Ms. Richardson, arrest you. But you're the one who got arrested. You've been charged with this. It's a misdemeanor. I find that your plea is knowing and voluntary. No one's forcing you into this plea. You agree?
Yeah.
This is a decision you're making.
Yes.
No one's threatened you to make you enter the plea.
Oh, no, sir.
No. Okay. You told me you don't have any other questions. Ms. Wood, do you authorize someone from my office to sign the indictment?
Yes, Judge.
Ms. Willingham?
Yes, Judge.
And Mr. Cummings, is it okay if we sign the indictment for you indicating your guilty plea?
Yes.
All right. I will sentence you to 12 months to serve 2 with the balance probated. You've already served more than 2 months, so you're not going back into custody. You have 10 months of probation. Are you working?
Yes, sir.
What do you do?
Wiz inventory, like travel.
I don't know what that means.
The inventory, we go count Walmart stores.
Oh, you like will go in and see how many boxes of cornflakes do they have?
Mm-hmm.
And is that a actual Walmart job or it's a
Dollar General and Family Dollar store.
Okay, so it's an independent company that Walmart or Dollar General pays to do the inventory.
Yes, sir.
How many days a week is that?
Like 5 days, Monday through Friday.
Do you travel a lot?
Uh-huh. like to Tennessee and stuff.
How do you get there?
Van, they pay for the hotel.
Really? They ship you there and then you go count the merchandise?
Yeah.
Okay. 12 months to serve, 2, balance probated, special conditions, number 1, complete a family violence intervention program, number 2, 40 hours of community service, and number 3, did you say no contact with Ms. Richardson or should be no violent contact?
Judge, so I said no contact because Ms. Richardson has not communicated with our office. We do know that we have good contact information for her. I believe in one instance she answered and hung up, but in a few of the others, we just haven't been able to get her back on the phone once she realized who we were.
Okay.
So I was not able to actually.
Got it. I'm going to do no violent contact because they have kids. If we need to modify that because Ms. Richardson reaches out and has concerns, let me know. But that way, if you and Ms. Richardson you don't have to run away. If you're at your grandma's house and she shows up to see the kids, you're not violating your probation because you're there. But just keep your distance. Don't get in an argument with her as best you can. Ms. Wood, anything else in Mr. Cummings' case?
Judge, will you consider waiving probation fees for the first few months just so he can get started on the FFIP?
Yes, because that's not free. Sure, I'll waive your probation supervision fees for the first 2 months of your 10 months of probation. I think I covered everything. Ms. Willingham, anything else? She's gone. Mr. Jordan, anything else? All right, Supervisor Jordan says we're good to go. Did you just give him probation reporting information or that's just your autograph?
No, Judge, but I have his good information and I will send that over to probation and they'll contact him.
Okay, so you may get a call from, you're not going to recognize the number, you need to take it. It's misdemeanor probation. Their office is very near here, but you need to make sure you report that very first time so they can get to know you. Otherwise, they take out a warrant. We'll just do this all over again. So if it's been a week and you haven't heard anything, reach out to Ms. Wood saying, I'm not hearing from probation, okay?
Okay.
Any questions?
No, sir.
All right.
Thank you, Judge.
Ms. Sweeney? Did she step outside? She's here. She keeps moving around. I look over there and all right, come on up.
We're ready on a negotiated plea.
Great. Ms. Nix, are you ready?
Yes, sir.
All right. And is this a plea to the indictment as charged?
No, sir, we are going to reduce it to disorderly conduct.
D.O. All right. Ms. Sweeney, we're going to get on the record in your case. 24 SC 000486. You are charged with aggravated assault. The state is reducing it to the misdemeanor of disorderly conduct. Is that your understanding?
Yes.
Okay. In a moment, Ms. Nix will put you under oath and then ask you a whole bunch of questions. You've heard them before today. When you're answering them, make sure you answer loudly. You have a quiet voice, but our court reporter is doing her best to hear things, but she hears through the microphone. So belt it out like you're on a bus telling people to sit down in the back of the bus, okay? Or whatever you do for MARTA. I'm going to hear about that in a little bit. All right, when you're ready, Ms. Nix.
Thank you, Judge. Ms. Sweeney, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please state and spell your true, correct, and legal name.
Meandra Sweeney, MEYON, D as in David, RAUS, and Sweeney, SWINNEY.
You can put your hand, you did it. Great, thanks.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there a medication that you normally take that you have not taken or been given today?
No.
How old are you?
46.
How far have you gone in school?
From college.
Is English your native or dominant language?
Yes.
Do you understand that you've been charged, count 1 as aggravated assault?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to this charge?
Yes.
Do
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes,
Have you had the opportunity to review your rights with your attorney?
yes,
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
yes,
Do you need more time to discuss the case with your lawyer, Ms. Rios?
no,
Are you satisfied with her services?
yes,
Ms. Rios, do you waive a formal reading of the indictment for purposes of the plea?
Yes.
And do you waive any and all defects in the indictment for purposes of the plea?
I'm unaware of any defects, but I do waive for the purposes of the plea.
Ms. Sweeney, do you remember having been arrested on this charge?
yes,
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
yes,
Do I understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? The state will reduce count 1 aggravated assault to disorderly conduct under OCGA 16-11-39 and recommend a sentence of 12 months probation. Special conditions are that she complete anger management and have no contact with the victim, Christopher Howard. A behavioral incentive can be that when she completes anger management, the remaining balance of probation can be suspended.
Okay.
Ms. Sweeney, do you understand that the court is not required to accept the state's recommended sentence?
yes,
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
yes,
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you're expecting today, you have the right to withdraw your plea of guilty?
yes,
Are you currently on probation or parole anywhere?
no,
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
yes,
Do you understand that while you're on probation, you must follow all the special conditions of your probation?
yes,
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
yes,
Do you understand that you are not allowed to possess or use a firearm while on probation?
yes,
Are you a United States citizen?
yes,
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, I do want to, for record to show this is going to be a no-low plea.
Okay.
yes, no, no,
Okay, do you understand that you're waiving any and all defenses, including any mental health defenses?
yes,
Do you understand you are giving up the following rights? The right to a trial by jury, to remain silent, to confront witnesses against you,
yes,
to the assistance of counsel,
yes,
to the presumption of innocence,
yes,
and the right to appeal if convicted of these charges at trial?
yes,
Is it your decision to waive these rights and enter a no-low plea today?
yes,
Has anyone forced, threatened, or promised you anything to get you to enter a no-low plea?
no,
Are you aware that even if you do not admit guilt, well, that's for Alfred. Is there anything specific Your Honor would like to read as far as for a no-low plea?
No, I haven't had a no-low plea before, but here's Ms. Rios introducing us to something new with one of her first pleas. I'm not opposed to it. I'll need to hear a little more from Ms. Rios and her client as to why it's no-low. Typically, it would be Alfred, but that's different from no-low. Because it's a misdemeanor, I'm not particularly concerned about how we finesse the wording. So as long as you're comfortable with that, you've covered the critical, the Boykin-related things. So I'm not worried about that. I don't know if your colloquy guidelines that you've got say something about no-low, but
They don't.
okay.
So I'll just continue.
Okay.
Ms. Sweeney, how do you plead to the charge of disorderly conduct in indictment number 24 SC 000486?
no, no,
Is this no-low plea freely and voluntarily given with full knowledge of the charges against you?
yes,
Do you understand that you have only a limited right to appeal this no-low plea?
yes,
Do you understand that if you wish to challenge the voluntariness of your no-low plea, you must do so by filing a habeas corpus petition? And since this is a misdemeanor, you have only 12 months from today to do so.
yes,
Judge, had this case gone to trial, the state would expect the evidence to show that on October 28th of 2022, in the early hours of the morning, Miss Sweeney was a MARTA bus driver. Christopher Howard got onto the bus and requested to ride without paying a fare. She said no, and he, for a few minutes, tried to convince her to let him on the bus. Did not get off the bus for 3 or 4 minutes. While this was happening, there was some words being exchanged, and the video you can see Miss Sweeney acting in a way that put Mr. Howard in concern for life or limb. That's the way the statute reads. And that occurred in Fulton County.
Okay. I'm starting to better understand the NOLO plea. Let's hear from Ms. Hardy. Do you have any criminal history information at all for Ms. Sweeney?
There's 5 arrest cycles, but no felony convictions.
When tell me the last couple of cycles.
Okay. So we have a I don't have the calendar. What's the date of the incident on the calendar?
October 28th, 2022.
Okay, so on the GCIC, there is an arrest from August the 23rd, 2018, for aggravated assault, and that was null pros. There is a 2008 battery family violence that was dismissed.
Okay, that's plenty. That just, thank you. That helps provide some context. Thank you. Ms. Rios.
Yes, Your Honor. Ms. Sweeney is 46 years old. She's from Atlanta. She was working for MARTA for the last 15 years. She has 3 children that she takes care of and a disabled mother that she takes care of. In regards to this case, Your Honor, it was 5 a.m. She was on a MARTA working. A man got on the bus, was threatening her, refused to get off. She did pull out a weapon and self-defense. She was scared. A man, she's a woman, 5 a.m. in a ski mask comes on and is threatening her. So she acted appropriately. That's why we have the NOLO plea now. We did discuss and we understand that there's always a chance at trial. She just wanted, was more comfortable guaranteeing that she wouldn't have a felony and wouldn't face jail time. But she did feel strongly. She even had an arbitration hearing in regards to this case when they initially fired her from MARTA. They rehired her and found that she was not in the wrong. But just given the uncertainty of trial, she's entering a NOLO plea today.
Okay.
So we just ask that you accept the plea as negotiated.
Got it. Thank you. Ms. Sweeney, how old are your 3 kids?
My oldest is 28, 18, and 16.
So the 28-year-old, maybe you don't have to take care of so much?
I still do.
Okay. Got it. Ms. Nix, you mentioned surveillance footage from the bus. Do you see a ski mask on this guy who's trying to get on the bus without paying?
The angle of the videos, it was difficult to see him.
Okay. It was easier to see the driver.
Yes, it was directly at her.
Okay. All right. Ms. Sweeney, is there anything you want to add? I don't mean forget about the mask. I just was curious what Ms. Nix saw and recalled from it as well. Anything you want to add about your situation, this case, anything else?
I mean, they already reduced it, so I don't think it needs to go into the facts.
Just that the allegation wasn't true. Like she said, I'm back at my job because we went to arbitration and they found that I was not, I didn't do the things that they indicted me on.
Okay. Well, that's why it's a NOLO plea.
Mm-hmm.
Got it.
Other than that, no.
And it allows you to control the risk level of how this resolves. Okay. Well, I think it's a pretty reasonable sentence, given some of these other arrests that you've had. I know they're a little while ago, but an ag assault arrest, a family violence, battery arrest, this, It may be, and maybe it was more so in the past when you got in a certain situation, you'd get angry, and it seems like it's a little more than a coincidence that there were those things as well. So I'm hopeful that anger management might help. I'm glad you got your job back. I don't think I'm gonna try to get on your bus without paying, because I don't want to face whatever happens. But I do find there's a factual basis for your plea. That doesn't mean I'm taking one side or the other. It's sort of up in the air. I understand why going to trial could be attractive, but it could also be risky. If it didn't go well, that might undo the success you enjoyed with the arbitration. So I do find that the state could, if they track down Mr. Howard and he testified consistently with what the state's version of events is, a jury could credit him rather than you. Who knows? And you don't want to take that risk. I also find that your plea is knowing and voluntary. Knowing means you've understood all the things we discussed. You agree with that?
Yes.
Voluntary, you know what that means. No one's forcing you to enter this plea.
No.
All right. And it is the one charge is being reduced to disorderly conduct, which is a misdemeanor. I will accept this as a nolo plea. That will still be on your record, but it's not a conviction in the same way. I don't want to give you the wrong information about the impact of a nolo plea. I'm accepting it as a nolo plea. More importantly, it's a misdemeanor. I'm going to sentence you to 10 months of probation. And the two conditions of probation, other than obey the law, are one, complete an anger management course. And if you have trouble figuring out where there would be one, misdemeanor probation has a whole host of them. They could say, go here for the class or go there for the class. You also need to have no contact with Mr. Howard. That should be easy. Sounds like he's a stranger to you. Don't go online looking for Christopher Howard saying, if I see you again, next time I'll run you over with a bus. That would be a bad choice. And I will suspend, I'm willing to suspend if you pursue it, your probation upon completion of your coursework. So if you document that you completed the coursework, you can then, through Ms. Rios, petition misdemeanor probation to say, can I be done now? And I need to sign something, and I will. If they tell me, JCS, that's the name of the probation company, say, hey, Sweeney's done what she was supposed to do, then there's really not a point in having them looking over your shoulder. Okay? Ms. Rios, anything else on behalf of your client?
No, Your Honor. Thank you.
May we sign, someone from my office sign the indictment on your behalf, Ms. Rios?
Yes, Your Honor.
Ms. Nix?
Yes, sir.
And Ms. Sweeney, is it okay if someone signs the indictment for you?
Yes.
Okay. Now you had some questions.
I was just asking about the class. How long is it and how do I get the information?
Misdemeanor probation will tell you. Yeah, you can contact them.
You gonna give me that information?
Yeah, we're gonna fill out a form.
Okay.
Yeah, there's a form. I don't know exactly how it works. I can tell you misdemeanor probation is about half a block from here. But most of all, you stay in touch with Ms. Rios. You don't want to not show up because we're letting them know, hey, you've got inbound Ms. Sweeney. And they're going to reach out to me saying, it's been 2 weeks, we've not seen this lady. So you, either through Ms. Rios or directly from JCS, should be contacted in the next couple of days saying, we need you to come in, or we'll take all the info or go online, however that works. Okay?
Okay.
Anything else?
No.
All right. Ms. Nix, anything else?
No, sir.
That's it.
But I have some online.
Yeah, email.
Ms. Willingham and Ms. Wood, remind me what we're doing with Jermaine Stanley.
Judge, it will be a plea. I just need to speak to him once more. I didn't know if you wanted me to handle. I have one case on the final plea calendar this afternoon.
The afternoon one. Great. Let's turn to that because we've got folks online for that, et cetera. We even got a chat. Okay, that's all good. You wanted us to jump straight to yours?
If possible.
Okay, who is it?
Miss Hill, April Hill.
Number 3.
Yes.
That's not jumping too far. Okay. Is Ms. Hill here?
Yes, she's here, Judge.
Okay. Oh, this is why Mr. Jordan's here. His sprawling case with however many defendants are on it. Okay. There should be a bunch of people here for this case. we'll start with your client.
Thank you, Judge.
So we should get on the record. This is 24 SC 000053. We have Ms. Hill, April Michelle Hill, who's one of the several defendants in this case. I think we've taken at least one plea in this case. Ms. Wood, do you have all the discovery you think is out there in Ms. Hill's case?
I hope there's not more, Judge, because it's a lot. So
Okay.
yes.
You feel fully informed?
Yes.
All right, Mr. Jordan, if Ms. Hill wanted to resolve her case, looks like it's a couple counts of cruelty to children in the first degree, what would the state be recommending?
Your Honor, as to counts 1 and count 2 in this indictment, the state's recommendation is 10 to serve 3, with the balance being probated. These special conditions of probation being that Ms. Hill have no contact with the victim listed in the indictment, that she also attend anger management courses. Your Honor, we are willing to leave this offer open until the jury is selected.
Okay. Ms. Hill, do you understand what the state would be recommending if you entered a plea?
Yes.
Okay, that doesn't bind Ms. Wood. Ms. Wood could argue for something less. If today you entered a plea and I sentenced you to more than what Ms. Wood asked for, you could withdraw your plea. You could say, you know what? My lawyer told you what I'm willing to take in this case, and you've given me something more, so I'm going to say no, thank you. You could do that today. You understand that?
Yes.
You are on the May 30th trial calendar, so I'm going to be seeing you in just a couple weeks. If you say no, thank you today, as in I don't want to pursue it this way, I'll see you in a couple weeks, and we may put it up for trial. You understand that?
Yes.
Okay. Tell me what your choice is. Are you interested in entering a plea today, or do you want this to move to the trial calendar?
I want to move to the trial calendar.
Okay, well, that's what's going to happen. I will see you in a couple weeks. I may be talking with your lawyer just later this afternoon about what that trial calendar is going to look like. But we will definitely get you in here for that. Do you have good contact information, Ms. Wood, for Ms. Hill?
I do, Judge.
Okay. You understand, Ms. Hill, the state's keeping that offer open. It may not be something that interests you at all, but they're keeping it open for a while. What changes from today is that if you do decide you want to enter a plea, either because Ms. Wood tells you this information is that the state's case is pretty strong, or you don't want to put the kids through the stress of going to trial, whatever motivates you to enter a plea, I'll take the plea. What will change is your ability to say no, thank you, if you don't like the sentence I give you. Okay, you understand that?
Yes, sir.
Great. Any questions about anything we discussed?
No.
Did you get something in the mail telling you to be here today?
No, I spoke with her last week, and my probation officer, we communicate like twice every 2 weeks, so she keeps me upfront about everything.
Okay, that's good. I'm glad probation does that. That's not 100% their responsibility.
I think she might be thinking of a pretrial officer.
Pretrial officer. Okay, but either way, someone is reaching out to you.
I have a probation officer.
You may have both. Who knows? You could be popular. We've got an address in the system. It's an apartment at 855 Mount Zion. Do you not live there anymore?
C1. I had a house fire. I had an apartment fire in November, so I'm now in C1.
You're not in C2?
No.
You move one over?
Yes.
Okay. If you could fill out the magic form, please, Ms. Wood.
I will, Judge.
That way I also know we're getting something in the mail to you as well. But stay in touch with your lawyer. She's going to bug you about the trial calendar, and probation will also. Okay? Thank you.
Thank you, Judge. You're free to go.
Okay.
Okay.
Ms. Wood, you will,
Okay.
sorry, I didn't mean to interrupt. You'll be back virtually or otherwise at 4 for or do you not have anything on the trial calendar?
I do, and Judge, I was gonna see if the deputies would let me back to talk to Mr. Stanley.
Great.
Phillips.
That's fine. Because you said you just had one on this calendar. But, okay, you're sticking around. All right. Back to this calendar. Position 1 is Jamel Miller.
Afternoon, Judge. Judy Kim for Jamel Miller. He's on line.
All right, let's add you to the spotlight. Let's take this off the spotlight. And poor Mr. Miller's been on, I think, since this morning. But he needs to turn his camera and his audio on. Mr. Miller, There he is. How are you, sir?
I'm doing okay. How about yourself, sir?
All right. If you could just like stand still for a minute, I'm gonna get seats. There you go. Perfect. All right. Ms. Kim, is Mr. Miller resolving his case today, or are we moving it to a trial calendar?
Judge, we have a negotiated plea for your consideration.
Oh, well, boom. Did you know that, Ms. Willingham? Let's do it. Okay. Well, you're ready.
I'm ready.
Okay, wow. Let's get on the record. Mr. Miller's been ready since this morning. This is 24 SC 000-384, State versus Jamel Miller. Mr. Miller, I have to ask you a couple questions before I hand it over to your lawyer and to the prosecutor. You are not here in court, which is A-okay, but I need you to tell me on the record that you are comfortable waiving your right to be here in open court. Is that correct?
Yes, sir.
Okay. Number two, you are not with Ms. Kim. She is in her office. You are in the back of a car, and that's okay. Also, you just need to tell me you're all right moving forward without your lawyer right by your side. Are you okay with that?
Yes, sir. I'm fine with it.
Good. Now, if at any point during our conversation you want to speak with Ms. Kim privately, just tell me that. I'll dump you guys right into a breakout room. You can speak freely. No one else can hear it. And then we'll get you right out of that breakout room. Would you do that?
Yes, sir. No problem.
Sounds like a plan. Ms. Willingham, when you're ready. Let me add you. Oh, I can't.
Should I move to the podium?
Wherever you're most comfortable, but you can't be right there.
Okay. Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Please state your name and your age.
Jamel Rashawn Miller, age 35.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am. Just ibuprofen 800. I got a toothache.
Okay, and is that medication that's been prescribed to you by a doctor?
No, ma'am.
Does anything about the medicine inhibit your ability to understand the proceedings today?
No, ma'am, it doesn't.
How far did you go in school?
Some college.
Can you read and write in the English language?
Yes.
Have you had the opportunity to review the document that charges you in this case?
Yes, ma'am.
Fully understand the nature of the charges pending against you?
Yes, ma'am.
By pleading guilty today, you're giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, I do.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes.
The negotiation in this case is that you would be entering a plea to counts 1 and 4 of the indictment. Count 1 would have a 3-year probation sentence. Count 4 would have a 12-month probation sentence, and that would run concurrent with count 1. You would be required to have no violent contact with the victim, complete family violence intervention program, complete a substance abuse evaluation, and follow the recommendations, complete 40 hours of community service, have no weapons, no drugs, and no alcohol. And counts 2 and 3 of this indictment would be null pros. Is that what was explained to you by your attorney?
Yes.
I gotta get you to repeat some of that. What happened to count 4?
Count 4 is a plea. It's 12, that's So count 1 is 3 years probation.
Okay,
Count 2 and 3 are non-pros.
yeah,
And count 4 is 12 months probation.
concurrent with the
Concurrent
three.
with count
So,
1.
okay, so
Yes.
overall 3
3
years
years,
probation.
correct.
Got it. Thank you.
Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No, I am not.
And you're entering a plea to aggravated assault, strangulation, family violence with a minimum of 3 years and a maximum of 20, and to cruelty to children in the 3rd degree with a minimum of 1 day and a maximum of 12 months, for a total possible sentence of 21 years. Do you understand? I'm sorry, you heard me tell the court what the negotiation is in this case, which is 3 years probation. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 21 years?
Yes.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. Under the special conditions, as previously discussed, you would be required to have no violent contact with the victim, complete family violence intervention program, complete a substance abuse evaluation and follow the recommendations, complete 40 hours of community service, have no weapons, no drugs, and no alcohol. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, I understand.
I'm sorry, can you repeat that, Mr. Miller?
Hold on 1 sec. Was he fussing at you or at the kids? You? Me? He's fussing at me? What's his beef?
I guess because he's still
No,
here.
he said the judge didn't say anything.
Oh, that's what he said. I know you said the judge.
Okay, I'm not taking it personally. I just, okay, we're good. I just want to make sure he wasn't fussing at you. You're just trying to keep the courtroom quiet. And it's fine having little kids here, but if they need to be noisy, they should just be right outside. It's all good. All right.
Start back at probation.
Yeah, all right. I'm sorry about that, Mr. Miller. There were a couple of kids in here and one of them needed to step outside and it became hard to hear everyone. So we're going to rewind a couple words.
Okay, no problem.
You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. And under the special conditions, as previously discussed, you would be required to have no violent contact with the victim, complete family violence intervention program, complete a substance abuse evaluation and follow the recommendations, complete 40 hours of community service, have no weapons, no drugs, or no alcohol. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, I do understand.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No.
Are you satisfied with what your lawyer has done for you in this case?
Yes.
Do you have any more questions for your lawyer before we go on?
No, I don't.
Have you understood everything I've asked you so far?
Yes, I have.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes.
Is your decision to plead guilty made freely and voluntarily?
Yes.
Did you in fact commit the offenses to which you are pleading guilty?
Yes.
Are you a United States citizen?
Yes, I am.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 4 years from the date the sentence is entered for the felony offense and 12 months from the date the sentence is entered for the misdemeanor offense to file this petition. Do you understand these time limits?
Yes, I do.
Do you understand that you are not allowed to possess firearms during the course of your probation?
Yes, ma'am.
Do you understand that if you are found in possession of a firearm, you could be charged with another felony, which carries up to 10 years in confinement?
Yes, ma'am.
Your Honor, if the state were to proceed forward with this case, the state would prove beyond a reasonable doubt that on October 11th, 2022, officers were dispatched to 2800 Camp Creek Parkway, apartment Q2, College Park, regarding a domestic dispute here in Fulton County. Upon arrival, officers met with a 911 caller and victim, Ms. Toussaint, who was sitting in her vehicle with her children. She stated she was inside the incident location with the defendant and got into a verbal dispute over the conversation of him obtaining a job. The victim then went upstairs and the defendant followed her. He then punched her in the face, head, and nose. He also strangled her. Ms. Toussaint fought back but was unable to get the defendant off of her. When the defendant let her go, he went to his gun safe and chambered a round. The defendant did not point the gun at Ms. Toussaint, but told her that he would shoot her in the face if she didn't shut up. Ms. Toussaint's son, AB, observed her being choked and threatened. Your Honor, I've had several conversations over the phone with Ms. Toussaint, but more communication via email as recently as yesterday, when Ms. Kim and I were finalizing the plea negotiations. Ms. Toussaint was still asking me to reduce the case down to a misdemeanor. She has been very limited in our phone conversations, contingent upon what my responses are in emails. But based on our conversations with Ms. Toussaint, I know that she wants it to be no violent contact. They are actually expecting, so much so that she wanted us to continue the case because she thought that she could deliver any day now based on my last conversation with her. So for that reason, the state has entered this negotiated resolution.
Okay, thank you. Ms. Hardy, can you share any criminal history information you have for Mr. Miller?
This defendant has 10 arrest cycles, no felony convictions, 1 FTA in 2022, and 2 probation violations. Nothing further to report.
Can you tell me what the last cycle was, please?
Okay, so the last cycle before this arrest, there was an FTA out of Doherty. And then before that, the date of that one is October the 11th, 2022. And then before that, there was a June 4th, 2022 possession of Schedule 1 out of East Point, and that was dismissed.
Okay, thank you.
You're welcome.
All right, Ms. Kim. You're on mute.
Talking to myself. Judge, my client is 35 years old, as mentioned earlier. He works as a mover. He has a total of 5 children, one with Ms. Toussaint, and I'm hearing another one on the way. He regrets his actions. He takes complete responsibility for this. He understands sometimes it's better just to walk away, diffuse the situation, instead of just trying to win an argument where everybody's upset with everybody. So I think they're on a good path. I've spoken to Ms. Toussaint, and she did, again, as Ms. Willingham said, that she did want this to be a misdemeanor, but in light of his, the facts of this case, he understands that this is the right resolution. We would ask that you would accept the pleas negotiated.
All right. Mr. Miller, do you live with Ms. Toussaint right now, or because of your bond, you're not allowed to, or tell me what your plan is?
Right now, Ms. Toussaint, they actually just had an eviction. So I'm actually making sure they're taken care of by putting them in a room. It's kind of pricey, but I'm doing my best I can, just to make sure they have somewhere to lay their head.
Do you work?
Yes, sir. I
What
work
do you
with
do?
Moving, etc. It's a moving company in Waleska, Georgia. It's called Moving ETC. It's like an hour away from where I am now, so I've been working there for the last couple months.
Okay. What'd you do before that?
Before then, it was forklift driving at CJ Logistics.
How long did you do that?
About 3 years. I've been doing warehouse work for the last 10 years, but as far as with CJ Logistics, it's actually been about 3 years. I've been at CJ Logistics for about 3 years.
Okay. Got it.
And I'm actually have a job interview for a forklift position, but depending on my background, that depends on if I get it or not.
Okay. Understood. And you're about to have kid number 6?
Yes, sir.
Do any of the kids stay with you?
No, sir.
How many of them stay with Ms. Toussaint?
Just one. A legacy. She's 2.
Got it. And it's about to be 2.
Yes, sir.
Okay. All right. Do you have any questions about anything we've discussed?
No questions, but if I could have some type of leniency, I've learned my lesson. I would really appreciate that. Being that it's affecting my career and the type of jobs that I'm able to get for my qualifications. I would ask that you all just have some leniency or help me the best way you all could.
Okay. And what does leniency mean to you? Like when you're thinking, man, if the judge would just do X, what would that be?
I can get that reduced to a misdemeanor because it's so hard to, it's hard trying to get a job with the felony, and I don't have any, so it's gonna be harder now with that.
Did you and Ms. Kim talk about taking this plea as a first offender?
No, she doesn't qualify.
Oh,
I think he's already
okay.
under. I think the judge in part he's asking also if you could waive some of the probation fees because they are at this point for the most part homeless, and he is trying his best to keep it together for the family.
Got it. Okay. All right. Well, Mr. Miller, I do find there's a factual basis for your plea based on what Ms. Toussaint told the police at the time, which is probably on body cam and thus preserved, even though her recollection or version of events may have changed a little bit as time passed. A jury could find you guilty of what you're pleading to. So I will accept your plea. I also find that your plea is knowing and voluntary. And that just means you have understood what we've talked about and no one's forcing you to enter the plea. You may not be real enthusiastic about it, but that's not the test. It's just as long as you understand it and no one has threatened you or promised you something other than what you and your lawyer have been talking about. Do you agree with me that it's a voluntary plea?
Yes, sir, I do.
Okay. And you've told me you don't have any other questions. I'm sentencing you under the Probation Options Management Act, which means that while you're on probation, which you won't be for all that long, if you have a small violation, you and probation will work through that. If it is more significant, in particular, if you get arrested again, that'll come back to me. Ms. Kim, do you authorize someone from my office to sign the indictment on your behalf?
Yes, Judge.
And Ms. Willingham, can we sign for you?
Yes, Judge.
Mr. Miller, is it okay if someone who works with me signs the indictment indicating your plea?
Yes, sir, it is.
Great, we'll do that. So I'm going to follow the negotiated resolution. On count 1, I'm sentencing you to 3 years. On count 4, I'm sentencing you to 12 months. Those will both be probated and they'll run concurrently, meaning at the same time. So it's a total sentence of only 3 years. Special condition number 1 is no violent contact with Ms. Toussaint. You're welcome to be around her. You ought to be around her because she has one of your kids and is about to have another one of your kids. You'll need to complete a family violence intervention program, which is a series of classes that will help you work through family stress in a different way than you did in October of 2022. Tell me what the basis for the drug and alcohol evaluation is.
I'm trying to make sure this wasn't one where I just kind of left it in my.
Okay.
Hold on one second. Let me look in Odyssey to see if she said that at all.
And Mr. Miller, while Ms. Willingham is looking that up, just so you're not left hanging there, I don't want to impose a condition that doesn't have a real good basis for it. And sometimes it's clear from the police report, they show up and say, you know, Miller was wobbly and he smelled the alcohol or something. Then it makes sense for you to have that kind of evaluation. But if that had nothing to do with it, then we'll skip that. I will add another condition of probation, be that you complete the 40 hours of community service. I will waive your probation supervision fees for the first 3 months while you get readjusted to being on probation, and it may be you're starting a new job, et cetera. Anything, Ms. Willingham, on the?
Yes, it looks like I have a note, Judge, from March 28th, 2024, where Ms. Toussaint actually emailed and stated that so long as the defendant remains sober, they do not have any issues.
Okay. So all it is an evaluation, Mr. Miller. Probation is going to help you connect with a professional who will talk with you about what you drink and what else you put in your body. And if that person has any concerns, then that person is going to recommend some treatment, and that treatment will be part of your probation. It will also be part of your life, hopefully a helpful part of your life. And that is it. Do you have anything else, Ms. Willingham?
No, Your Honor.
Ms. Kim?
Judge, if I could push the envelope and ask if you would consider, once Mr. Miller gets everything done, would you allow the probation to go non-reporting? I'm just concerned with all the children he has, a new baby on the way. And unfortunately, we all know that criminal background will factor into his ability to get a good paying job. So he'll be on probation. We're not asking for termination. We're just asking if you would make it non-reporting.
So I'm happy to consider that. Let's get through these first few requirements. But if Mr. Miller, you take care of the coursework you're supposed to do and you've done your community service and everything is going smoothly, I encourage you to ask your probation officer, hey, could we make this non-reporting? And if the probation officer says yes, or I'm not so sure, just reach out to Ms. Kim, and she can always petition me to say, hey, Judge, you should take a look at it, and I can order that it be non-reporting. You can make that a real easy decision for your probation officer by being easy to find and taking care of the things you're supposed to take care of. And then it's a no-brainer for probation. They don't want to bother with you if you're low maintenance. They have to deal with the folks who are high maintenance. All right. So what I'm going to do now is ask Ms. Toussaint, who is with probation. She's not going to be your officer, but she's with probation. She's going to need to ask you a few questions about your address and give you reporting instructions. Okay?
Okay.
Ms. Toussaint?
Hi. Where do you live, Mr. Miller?
Currently we're at the Wyndham Days Inn off of Old National.
Is that in Fulton County or Clayton?
It's Fulton County. But if I would have any documents mailed, I would like to have a mailing address. You know, because I don't know where we'll be like the next couple of days. We've been going to different roads.
It'll be a physical address. What's your phone number so I can give you a call directly?
Okay, my phone number is 404-437-1320.
404-437-1320?
1320.
Okay, and what's the address there at that Wyndham Days Inn?
I can get it. Hold on just a second.
You said it was Old Man.
It's actually the Wyndham Travel Lodge. Hold on.
How about this? Why don't you got it? Okay. Go ahead.
2471 Old National Parkway.
And which suite number?
The room is 203.
All right. I'm gonna call you just to confirm reporting instructions, but at all times you have to let probation know where you are, or they will give you a warrant for your arrest, okay? Especially after you do your
Yes, ma'am.
intake. Okay?
Okay. Yes, ma'am.
So she'll be in touch with you, Mr. Miller, and take it from there, okay?
All right. Thank you, Your Honor.
Good luck with the new kid.
All right. Thanks.
Thank you, Ms. Kim.
Thank you. May I be excused?
Yep.
Thank you.
We are going to jump to position 10, Mr. Thurman.
Thank you, Judge.
Yes, Your Honor. Let me get you on the screen here. All right, Ms. Nix, this is your case?
Yes, sir.
All right, let me add you as well. I guess I just have to do that through the podium. There we go. You're on there. Okay, great. Mr. Spisman, tell me, I got your text, but I'm not interested in, let me see where this is going. This isn't on until our July trial calendar, so that's its next destination. I don't know if the back and forth is that the state hasn't made a firm offer yet, but what we do today for final plea is get that offer on the record unless there's a reason why it's not firm yet. And then I preserve your client's final plea rights and we move this to the trial calendar. But the fact that you all haven't had a meeting of the minds to me is just, all right, there's not a meeting of the minds. He's not going to enter a plea today and we move it to the trial calendar. But let me start with the basics. Let's get on the record. It's 23 SC 190-854, State versus Cordell Thurman. You're charged, Mr. Thurman, with aggravated assault, hit and run, and fleeing or attempting to elude an officer. Does the defense have the discovery in this case?
Yes, Judge, we do. Discovery is satisfied.
Okay. Ms. Nix, are you two still negotiating or you've made the same offer and the defense attorney is just wishing that it would be a different offer?
I've made an offer and I think he's wishing it was a different offer. Your Honor, I did file a 404B motion last week, I think, maybe 2 weeks ago. That has not been addressed yet, but otherwise we're happy to have the final plea hearing today.
Well, but that changes the dynamic a little bit because if they don't know if something's coming in or not, then we may need to hold off on that. I'm looking at your 404B while we talk. Oh, okay. All right. Why don't we do this? We're going to need to have a hearing on the 404B. I would like to try to fit it in before the trial calendar, but I will preserve Mr. Thurman's final plea rights. We'll move this to a trial calendar. We'll actually see each other before then for the 404B hearing. And Mr. Thurman, I don't mean to use code. 404B is just the name of the statutory provision that allows the state, if they're successful, to get in information about other things you may have done that don't necessarily put you in a good light. What the state is alleging is that in December of 2016, you committed another fleeing and attempting to elude in Coweta County, and you were convicted in August of 2017. And the state has a theory that the jury ought to get to hear about that if you decide to go to trial in this case. I don't know if that's a winning theory or not. Your lawyer needs to digest it and argue his perspective on it. We need to have a hearing on that, and we will. And once I rule on that, that could change the landscape a little bit. If that's coming in, that may make your lawyer say, dang, Mr. Thurman, we really need to work this out. I know you don't like the state's offer, but that's as good as it's going to get. If it's not coming in, there are good reasons why your lawyer is still pushing for the state to look at this case in a different way, and he's entitled to pursue that. But that's sort of where we are. Do you have any questions about anything I just said?
No, sir.
Okay. Then we'll get a date set for a hearing on the 404B. We're going to keep your case on the July trial calendar. I may have to move it if something comes up. We can't get that hearing in time, but I'll also preserve your final plea rights. Ms. Nix, anything else for the state?
No, sir.
All right. Anything from the defense?
Nothing, Judge. Just quickly, I do have a pretty substantial leave in the middle of that trial calendar, so it should have already been filed, but it's the court to the 20th, so just on the court now.
Yeah, I think I see it. There's an amended notice of leave. Yeah, you're doing a lot of traveling. So we'll see if we can fit something in and around that, but obviously you've got certain things protected through the amended leave. It may make the trial calendar a little moot, but that doesn't mean we don't need to have the 404B hearing.
We'll be ready to prepare that and handle it.
All right, sounds good. Thank you. Mr. Thurman, any questions?
No, sir. Thank you, sir.
All right, you all are free to go.
Thank you, Judge. I appreciate it.
All right, Brian Burnett was next. Is Mr. Burnett here?
When I spoke with someone from Mr. Francis's office, they informed me that there was a conflict letter that I had not seen yet, but there may have been a spelling error which kept it from being filed. I have communicated with Attorney Francis and extended an offer to him, but I have not received any notice on whether Mr. Burnett is going to accept that offer or not.
Okay. There is a conflict letter, but that wouldn't be for the defendant. That would be for the lawyer. In theory, Mr. Francis, could be in trial in Gwinnett, but again, that doesn't excuse his client.
Also, I'm sorry.
No, go ahead.
We received notice late yesterday that he was actually released from that Gwinnett matter, and that defendant is actually representing himself.
So Mr. Francis should be here. Okay. Well, why don't I have Ms. Nelson reach out to Mr. Francis? More importantly, Mr. Burnett's not here. Could you say again something about his name was misspelled? I don't understand why he wouldn't get notice. I mean, the letters go where the letters go.
Your Honor, this was particularly in regards to Mr. Francis. I received an email from someone using the email for his office saying that they misspelled Fulton apparently, and it didn't get filed correctly, the conflict letter.
Got it. Okay, that I get. But Mr. Burnett, actually, we put in his new email address, not his new residence address earlier. So I'll issue a bench warrant for him and we'll take it from there. Ms. Nix, before we go on to the next position, we're never going to know that you filed a 404B. You need to email a copy of it to Ms. Nelson. I mean, it's in the docket, so it's there, but we don't scour the docket to see, hey, what has Ms. Nix done for us lately? So if you're filing something in any case, meaning a motion, not a, I've got a leave of absence, or even a leave of absence, shoot a courtesy copy to Ms. Nelson.
Yes, sir. I apologize. I'll do that.
It's okay. That's just that way we'd know about it, and that way she would have told me, and that would have been part of the conversation. You made it part of the conversation, which is good, but better that because we might have told Thurman to come on down here to do the 404B today. All right, so that's Burnett. How about I'm not going to pronounce the first. How do you pronounce the first name of position 4? Chame? Chame. Chame Jackson. That's you? Great. Where's Mr. Luemba? That's probably part of the problem. All right, Chame Jackson. Let's see what we got here. Oh, that's just going to be hard to find. Let's do it this way. Chame Jackson. What about some of the others like Marquise Hill? He's not on. Oh, he's here. He's April Hill, we just did. Travin Walton, he's not on the calendar.
I believe he's already in bench warrant status, Your Honor.
He's on a bench warrant status. Okay, Mr. Luemba is listed as the attorney. Mr. Luemba is listed as the attorney for a couple folks. Let's see what we got here. He just filed a leave of absence. Oh, Miss Cabrera is, how about Miss Cabrera? Does that name ring a bell? That's not good. Okay. Well, she is your lawyer. Her leave of absence does not cover today. So I'll ask Ms. Nelson to look for both Mr. Francis and Ms. Cabrera. It might be that it's Cabrera Damore, but she might be able to hop onto Zoom, and then we could at least have a basic conversation so that you have a face and a name and a phone number of someone to talk to. Mr. Jordan, have you had a chance to speak with anyone claiming or purporting to represent Ms. Jackson?
I have not, Your Honor. I sent all discovery to Attorney Luemba for Ms. Jackson.
Okay, and he is listed as the lawyer of record, and yet Ms. Cabrera filed the leave of absence. It's a mystery. Hold on a second. All right, you don't have to stay standing. We're going to see if we can reach Ms. Cabrera. If she says, look, I'm stuck in court, I'm going to let you get out of here. And then we'll just have to reset this and make sure you two connect. She also may say, no, it's Mr. Luemba, in which case he needs to appear in your life and let you know what's going on. You are not, it's great that you're here. That's the important part. You're not at any disadvantage because we couldn't work on your case today. How about Marquise Hill? That is Ms. Paul. Ms. Paul had to do something in magistrate court and then was going to come back. I don't see her on the Zoom, so let's hold for Mr. Hill. Vincent Moore.
Yes, sir.
All right, we're getting some traction here. Ms. Rios, have you inherited that?
Yes, Your Honor, and we want to go forward on a non-negotiated plea.
Well, why don't we do that? Mr. Moore, come on up to the podium. Ms. Nix, you ready for that?
Yes, sir.
Okay. Is Mr. Carter here?
No, Judge, he was excused, I believe.
Well, that's interesting. Mr. Willis was excused, and it may be that people told Mr. Carter he didn't need to be here. I didn't. So I'm curious. Ms. Nelson, did you let Mr. Willis know that his client didn't need to be here? We'll wait to hear from her.
Correct.
Okay. All right. I've written the order that we still have to do immunity on the assault case, but on the drug case, I've written, I just need to proofread it one more time on the drug case, but that case is alive and well. I just need to sign it and enter it. So at a minimum, we could go forward with that one. We need to do, as I said, the immunity hearing. My plan was to just keep it on the trial calendar. And if if that's the case, I don't know which one you'd want to try first, the drug case or the assault case. But if it's the assault case, on Monday, we do the immunity hearing. I would let everyone know right there, it's going forward or it's not. As in other words, I'm granting immunity, choose to appeal it or not, or I'm denying immunity. And then we could pick a jury, because that couldn't be a very long trial. I just didn't know which one you'd want to do first. We'll talk about it when we talk about the trial calendar. All right. Is Mackenzie Prevalon here? Great. And is that your case?
Yes.
All right. I'm just making sure we know who's here. We took care of Thurman. And then how about there's another Carter. You're the other Carter. We've had a problem with your ankle monitor. When we talk, you're still wearing an ankle monitor? Is it charged? Okay. We're going to talk about that.
Yes, sir.
And who is your lawyer now? Ms. Rios. Okay, great. All right, then we got everyone we need. Let's do this plea. All right, you're Mr. Moore.
Yes,
this is 23 SC 189726. And Mr. Moore, you're represented by Ms. Rios. You're both here. Ms. Nix is handling this for the state. Today, because it's your final plea day, if I accept your plea and I sentence you to a sentence that is more severe than what Ms. Rios asks for, you can withdraw your plea. So we're gonna get through this whole process, and I may say, oh, here's your sentence, and that may be something you don't like. I want you to panic. I'm gonna give you and Ms. Rios a chance to talk about it, and you could say, you know what? No, thanks. I will see you guys for the trial calendar, and you are on the trial calendar coming up. So I would see you at the end of May for that. You may decide, if the sentence I give you is a little worse than you asked for, like, I'll still deal with that. I also may go along with exactly what Ms. Rios said. She's going to advocate for whatever, because it's non-negotiated, whatever you and she thinks is the better fit. But I just wanted you to know that you'll have a chance to talk with your lawyer after I pronounce sentence, if it's something that is more severe than what Ms. Rios asked for. And maybe you guys are separated only by like hours of community service, in which case it's not a big deal. But if Ms. Nix is going to be saying he needs to serve 20 years, and Ms. Rios is going to be saying he needs a gold medal, that's a big gulf. I just want you to know you can withdraw your plea if I land somewhere in that gulf. Does that make sense?
yes, sir, it does. Thank you.
All right. Ms. Nix is going to put you under oath. Once you're under oath, make sure you answer all her questions truthfully, okay?
Yes, sir.
Ms. Nix?
Mr. Moore, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your true, correct, and legal name.
Vincent Moore.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, I'm not.
Is there a medication that you normally take that you have not taken or been given today?
No, it isn't.
How old are you?
61,
How far have you gone in school?
complete 12 years.
Is English your native or dominant language?
Yes, it is.
You understand that you've been charged with the following offenses. Count 1, possession of methamphetamine with intent to distribute. Count 2, possession of a firearm by convicted felon. And count 3, possession of drug objects.
Yes, I do understand that.
You understand that you have the right to plead either guilty or not guilty to these charges.
Yes, ma'am, I do.
You understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial.
Yes, I understand.
Have you had the opportunity to review your rights with your attorney?
Yes, I have.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes.
Do you need more time to discuss the case with your lawyer, Ms. Rios?
No, I don't think we do.
Are you satisfied with her services?
Yes, I am.
Ms. Rios, do you waive a formal reading of the indictment for purposes of the plea?
Yes.
And do you waive any and all defects in the indictment for purposes of the plea?
I'm unaware of any defects in the indictment, but I do waive for the purposes of the plea.
Mr. Moore, do you remember having been arrested on these charges?
Yes, I do.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, she have.
For the record, the possession of meth with intent to distribute is 1 to 8 years. And the possession of firearm by convicted felon is 1 to 10 years. And the possession of drug objects is up to 12 months.
Yes,
You understand that your plea of guilty today is a non-negotiated plea and the state may recommend a sentence to the court even without you having agreed to it in advance?
yes, I do.
Are you aware that the state's offer is 5 years probation?
Yes, I am.
Have you discussed this offer with your attorney?
Yes, I did.
You understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes, I do understand.
You understand that if you enter a non-negotiated plea, you will have the right to withdraw your plea of guilty once the court enters its sentence.
Yes.
Are you currently on probation or parole anywhere?
No, I'm not.
You understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit.
I am aware.
You understand that while you're on probation, you must follow all the special conditions of your probation.
Yes.
You understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence.
Yes.
You understand that you are not allowed to possess or use a firearm while on probation?
Yes, I do understand that.
Are you a United States citizen?
Yes, I am.
You understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes.
You understand that doing so could result in new criminal charges for which you face a sentence of up to 10 years?
Yes.
You understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes.
You understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes.
You understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Excuse me?
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes.
You understand that by entering a plea of guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial.
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of possession of meth with intent to distribute, possession of a firearm by convicted felon, and possession of drug objects in indictment number 23 SC 189726?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
You understand that for the felonies, you have only 4 years from today to do so, and for the misdemeanors, you have only 12 months from today to do so?
Yes.
But had this case gone to trial, the state would expect the evidence to show that on or about September 13th of 2022, the defendant Vincent Moore sold marijuana to an undercover officer and then left on a moped and marked units, conducted an investigatory stop. Officers found marijuana, MDMA, or methamphetamine, a scale, and a firearm in the defendant's possession. And that occurred in Fulton County. The defendant has 6 prior felonies. Most are drugs. The most
So I have 5 listed on the repeat offender notice that Mr. Malkin entered. 09, 08, 05, something out of Ohio, and a Z. What was the 6th that you have?
I don't have anything from Ohio. I have 2 dangerous drugs from Fulton, a controlled substance and forgery from Clayton County.
That's the one that, when is that?
That is 1990.
90. Okay, thank you.
The most recent is a 2009 conviction. It's a 2008 indictment for possession of a firearm by convicted felon.
Yep. Got it. Okay.
And because of the amount of methamphetamine, it was 4.67 grams. That makes the range of punishment for the meth with possession of meth with intent to distribute 1 to 8 years.
Got it. And your recommendation is 5 years probation. Any conditions on that probation?
State recommends 80 hours of community service, forfeit the firearm, and submit to random drug screens and a drug evaluation and treatment.
All right. Got it. Thank you so much. Ms. Hardy, how many cycles do you have for Mr. Moore?
I'm showing 49 total arrest cycles.
Wow. Now, did this round it off at 50 or this was number 49?
This was number 49.
All right. I don't know that you want to achieve 50. That's not real impressive, Mr. Moore. It's almost one for every year you've been alive. All right. Thank you. Ms. Rios.
Yes, Your Honor. Mr. Moore is 61 years old. He has 3 children, ages 17, 15, and 13, and he has joint custody of those children. He actually showed me pictures just now of all his kids. He's been working really hard. He has 2 jobs. So he works the Marriott AAA parking cars. He does that from 11 p.m. to 7 a.m. And then he works the Run Shop Discount Mall from 10 a.m. to 8 p.m. And whatever time he has between that, he's spending with his kids. I did want to, just for proof, he did show me his work schedule. Would you like to see how?
Sure.
Much? So this.
Wondering when he sleeps.
Yeah, this is the Marriott, and this is the discount mall that he runs the shop out of. And so, and the reason why you'll hear that we're gonna ask for him not to have community service, just because he just works so much. He works that hard because, you know, teenagers are expensive, and he's trying to make sure he's a good father and providing whatever they need. And so, with the given that he's working this much, and his age, 61 years old, Your Honor. And he hasn't, during the time that he was arrested and now, he hasn't picked up any charges. He hasn't had anything. He did ask if those 2 years that he's not been in trouble can be used as credit. I explained that it doesn't really work like that.
It's a creative request.
Yes. And so we're asking for 5 years probation, but suspend after 1 year. Just because he's been doing well. Most of those charges, I understand his history, but they were pretty old. It doesn't seem like he's had much in the last like 10 years. He's been doing well, he's working, and he just doesn't want anything to disrupt that or mess that up. So we think that, 1 year after probation and the remaining 4 years being a suspended sentence without any community, he's fine with, drug screens and all that stuff. But he's been doing well, Your Honor. So we're asking for count 1, 5 years probation suspended after 1 year, count 2, 5 years suspended after 1 year, and then for the misdemeanor, 12 months probation.
Okay. Mr. Moore, I don't see your name on this Marriott list.
Yes, sir, Your Honor. I'm on Suleiman.
He has a Muslim name.
Suleiman.
Got it.
One on the bottom.
I see the one you circled.
And then
someone circled.
I mean, I can show you my email, my Facebook. You'll see all this me. You'll see my picture, my face. I'm Suleiman Sadiq. That's my Islamic name. They allow us to use that on the job.
Okay.
Where we identify with best.
That would be why your timesheet for the mall lists Suleiman Sadiq as the name, because that would be my next question. This is someone else's timesheet, but it's yours.
Yes, sir.
You, through your faith, have adopted a different name. It sounds like your legal name remains Vincent Moore. What does your driver's license say?
Vincent Moore.
Okay, so you haven't taken the additional step to change that to Suleiman Sadiq?
No, sir, not yet.
All right, but you're not saying I'm not Vincent Moore. You're just saying, look, I tell my friends and family Suleiman Sadiq.
Everyone addresses me as Suleiman Sadiq, but I am born and raised Vincent Moore.
Got it. Well, I didn't mean to refer to you by the wrong name. I'm gonna call you Mr. Sadiq, but just know that your conviction and all your government paperwork is going to say Vincent Moore.
Yes, sir.
And that's you, but you have another name that's important in your life, and you may, to avoid confusion, may want to change your name legally, which you can do in this very courthouse. We do name changes so that there's less confusion. I don't know, does your paycheck say Moore or Sadiq, or you don't get paid in a check?
I don't get paid in a check. It goes to my direct deposit, which is Vincent Moore.
Okay, got it. Okay. Well, it doesn't sound like your employers are confused.
No.
Anything you want to add to what Ms. Rios was sharing with me about your situation? You do have a whole lot of arrests, but it sounds like they are clustered more so in your past.
Yes, sir.
And that you have been doing your best, maybe with the exception of a couple Septembers ago, to move in a different way.
Right. So, Your Honor, first of all, thank you for hearing my case, and thank you for representation, Ms. Rios. I caught a bad situation back 2 Septembers ago, where I just needed some money, and it was a matter of having a roof over my head for me and my family, me and my children. And I tried to take a shortcut way, which I had learned my lessons in the past, but I just thought maybe I could just get by. I have learned that, the easy way, the shortcut way is not the way. I ask that you have leniency upon me, as well as Mr. Miller did, and show me some mercy, because the way that I work and the time I spend working, it only leaves me time for my children. I did ask to see if we could get a 3-year probation, seeing that I have already shown I can be out here and gain lawful employment for the last 2 years. I'm willing to pay my fines. I ask for, if I do have to do 5, that it'll be non-reporting. And I pay my fine through the phone. I have done that before and completed my probation. And I will submit to drug and alcohol screening. But I don't do drugs. I don't drink. I don't smoke. And I feel like I don't need to go to a rehab or whatever they were saying about.
It wasn't rehab. It was just to have an evaluation to see if there is a drug problem behind the drug selling.
Okay.
Sometimes there is, sometimes it's pure business. I need some money and I know a hustle. And I know, you know what, dang, I sold to the wrong guy because I made some good money and then I sold to a cop and then it's bad money.
Okay. And with that being said, I don't want to be forced by the state into a situation to fall back into a poverty situation where I need money, because I only make $13 an hour.
In both those jobs?
On that on one other job. On the other job, it goes by sales.
Okay, that's at the mall.
That's at the mall.
What do you do there?
I sell sneakers, tennis shoes.
Okay. You have a booth? You have
I got
a cart?
a booth there.
Okay.
And it goes, if I don't make sales, I have to pay rent. I have to pay rent home. I have to help my children's mother to pay rent, where she has primary custody, even though we have joint custody.
Sure. Does she work also?
No, she doesn't.
Okay.
So I'm just asking that the court be lenient with me as far as no community services, and let me just pay my fines and get through this.
Okay. You're still a young man, but you are a little older than I would expect to have a 13-year-old. Did you just start? Do you have other kids who are grown, or the only 3 kids you've got on this great green earth are those 3, and you just got started late?
I had a late start, Your Honor.
Okay.
I had a late start.
But it sounds like you want very much to be there for them now.
And I try to be there. Like Ms. Rios was telling you, I show her the pictures out there. She'll see, the fair was here. I take them to the fair, circus. I take them, I spend time with them. I got a daughter, she's 17, and I'm trying to get her to see the ways of Islam, because, I don't want her being out there. But she's getting ready to graduate, turn into a young woman. I want to be there in her life, and I want to set a good example for all my kids, So I spend as much time with them as I can. Right. I stay working because I try to show them a positive role.
Good. Those are all good things. What you did a couple Septembers ago, bad example of what to do as an adult. And I hope you don't hide that from them, that people make mistakes and they learn from the mistakes. But that is a parenting decision, not mine to make. But I hope that you're learning from that. You've got much more at stake than, if we rewind 18 years and you're running wild in the streets, you didn't have kids back then. And so the consequences just fell on your shoulders, but now they fall onto your kids as well.
Exactly.
Okay. Well, Mr. Sadiq, I appreciate you sharing all that. When did you convert?
I converted to Islam. Well, actually, my father was Muslim, but he was up on the Nation of Islam. He didn't really teach me anything. But as I grew older and I started going in jail, catching these cases, back about 10 years ago, I just said, I want to, just live the right way. My children growing up, I don't want to spend in and out of jail doing their life. So I started 10 years ago, just started learning. I'm still learning. I'm still growing, and I still have a long ways to go.
Well, we all do.
I'm thankful that God chose me to be a Muslim now.
Okay. All right. Well, Mr. Sadiq, I'm accepting your plea. I find there's a factual basis for this. This would be a pretty easy one for the state to prove, given to whom you sold the meth. I also find that your plea is knowing and voluntary. Knowing means you've understood all the things we talked about. Do you agree with that?
Yes.
Any questions about anything?
No, sir.
Okay, voluntary, you know what that means. No one's forcing you to enter this plea. You're coming in eyes wide open. I'm sentencing you pursuant to the Probation Options Management Act. All that means is that for the time you are on probation, if you have a minor issue with probation, I don't need to get in the middle of that. You and probation will sort it out. But if it's a bigger issue, you get arrested for something, that comes to me and I'll work through the consequences. Ms. Rios, is it okay if someone from my staff signs the indictment on your behalf?
Yes, Your Honor.
Ms. Nix?
Yes, sir.
And Mr. Sadiq, we're going to sign it as Vincent Moore, not as Mr. Sadiq, but is it okay if we put your signature on there indicating your guilty plea?
Yes, sir.
All right. Here's what I'm going to do. I see both sides to this. Your criminal history is such that I would understand if the state said, man, send this guy to prison. This is his 7th conviction, 49th arrest, but that's not what Ms. Nix is saying. And she pointed out, most of your stuff is old and you did something different, which is great. You had this relapse is the wrong word because I don't get the sense that you were using and that was it. It was, you explained it. You hit financial hard times and you knew a way to make some money that you could make it quick. It was risky and the dice didn't roll well for you. And you got caught doing what you were doing. Just got to find amidst all this stuff. I'm going to give you your paperwork back so it doesn't get lost. On count 1, I am sentencing you to, how long did you go to jail for this? I forgot to ask that.
I think I was in there for 2 days, Sean.
But pretty quick. You bonded out pretty quickly?
Yes, sir.
Despite having no money?
Well, I have a wife that has her own business and she came through for me.
Got it.
Then she borrowed against the business. So
3 days, not much. Okay. Anyway, on count 1, I'm going to sentence you to 2 years. Count 2 is 2 years, and count 3 is 12 months. 1 and 3 run concurrently, meaning at the same time. Count 2 is consecutive to count 1. That was a complicated way of saying I'm sentencing you to 4 years. All probation. None of this is you going back into the system. A special condition of your probation is that you forfeit the firearm. Whatever gun they seize, don't try to get it back. That they're going to bend it into artwork or melt it or do whatever. It's not you can't have a gun anyway. You are so many times a felon is radioactive for you to have a gun. Don't have one in your household. Don't be around them. It's just going to get you in trouble. If you're driving a car and you get pulled over and there's a gun in that car, that could be 5 years. So you and guns don't need to mix.
Okay.
But you knew that. I'm not telling you something you didn't know.
Well, the truth to this matter is that I didn't have a gun on me.
Okay.
The gun was in the house though.
Okay. Whatever way it was, they scooped up a gun. Don't have it in the house. Don't have it in the yard. Don't have it in the garage. If it's your property, your wife's property, the mother of your kid's property, no guns around, because they could attribute it to you. And then you're just gonna come back here, and I'll remember our conversation, Mr. Sadiq, I told you no guns here, you got a gun. And then you're gonna be away from your kids for a while. So you're gonna forfeit the gun, and I'm gonna have you do 40 hours of community service.
Your Honor.
Hear me out. But those can be spread across the first year of probation. So you don't need to do them day one, month one. You figure out a time when you're going to give back to the community. But this is giving back to the community. I don't mean that you got to go pick up trash on the side of the road. You can find ways that are meaningful for you, and maybe it's something you're doing with your kids that's giving back to the community. And as long as it's documented and your probation officer said, hey, great, you go do 4 hours of that this weekend with your kids, that's 4 hours of community service. So it is a way for you to give back to the community that you say that you care about. So that's 40 hours of community service over the course of an entire year. If after the end of your first year of probation, there have been 0 issues, you've done your community service and there have been no hiccups, you haven't missed any meetings or anything like that, I'm gonna have you do at least 1 random drug and alcohol screen a month. So probation will say, hey, come on in, it's a meeting. And sometimes it's just a meeting. And other times they're going to say, hey, you need to give us a specimen. But if you have been clean the whole year, which shouldn't be an issue, especially alcohol, given your transformation, then I will recommend that probation become non-reporting for you. Okay?
Yes, sir.
I'm also setting a behavioral incentive date it would be May 15th, 2027. If there are no issues with anything that's going on that date, probation can say, let's close the case out. So that would shave off a whole year. You can make it non-reporting if for a year you've done what you claim you're able and willing and intend to do. And then I'll shave off that last year if, it'll happen automatically. If you have become someone that probation, like, we don't even remember Mr. Sadiq, we don't see the guy, that's good. Then that last year can just go away. All right?
Thank you, Your Honor.
Questions about that?
No, sir.
That's a little different than what Ms. Rios asked for on your behalf. It's also a little different from what the state petitioned for. Are you comfortable going forward with that?
Yes, I am.
All right, then that's what we'll do. I'm going to ask Ms. Tucson, before we do that, Ms. Nix, anything else in the Moore/Sadiq case?
No, sir.
Ms. Rios?
No, Your Honor.
All right, Ms. Tucson, can you please share with Mr. Moore, also known as Mr. Sadiq, his reporting instructions?
Sure, no problem. Mr. Moore, where do you live?
2909 Campbellton Road, Atlanta, Georgia, 30311, apartment 1H.
Okay, I didn't hear the numerical part. I heard you say Campbellton Road 1H.
It is 2909 Campbellton Road.
Number 1H. What's your phone number so I can give you reporting instructions?
678-891-7963.
And do you know where probation is here in Atlanta?
No, ma'am, I do not.
276 Memorial Drive. But I'm gonna have you reporting on May 30th. Okay. So I'm gonna call you with those instructions. Okay.
Yes, ma'am.
All right.
Is that it?
Unless you've got anything else?
No, I'm done. Thank you, sir.
Be well.
Thank you.
Thank you, Judge.
Thank you, Ms. Wheeler.
All right, we have some surprise guests on the Zoom call. I'd like to start with Ms. Cabrera de Moore. Can you surface, please? Oh, it says you're on the call. I'll take Mr. Luemba, whoever surfaces first, Mr. Luemba or Ms. Cabrera. There's Mr. Luemba. Whoa, he's like in a tracksuit.
I'm sorry, Judge. I really apologize about my appearance. I saw the email just now, but I didn't realize it was sent in April. And so I didn't think I had court today.
You're good. Don't worry about it. Where are you?
I'm at home. I literally just drove up when I got the email and I haven't even walked into the house. I just logged on. Yeah.
Well, I appreciate you jumping on. So here's the question. You are listed twice. We have a case involving 5 or 6 defendants. And so, of course, your firm and then the folks who have associated with you through GPDC got brought in to help out. And you are listed as the attorney for a gentleman who I think is in bench warrant status. You're also listed for a co-defendant, Ms. Jackson, who is here as the attorney, but Ms. Cabrera filed she's here too. Let's add her to the screen.
I am, Judge. I have Mr. Walton on the same case.
Okay, so that's the confusion I've got. Let me go back into the case.
Yeah, I think I got one first, and then I got another email that gave me the other one, and so I may have done an entry in that. But then Deidre had actually emailed the both of us, and then Mr. Luemba let her know, well, I have Jackson, and Ms. Cabrera has Walton.
Okay, hold on.
I'm physically at the Douglas County Jail right now.
Excellent. Hopefully you're in a space where you're allowed to leave too.
Yes, I can leave, but I have a client waiting on me on a phone.
All right, so we'll get there in a minute. So you're saying, Ms. Cabrera, you have Travin Walton.
Correct.
Okay, well, for whatever reason, you filed a leave of absence in Ms. Jackson's case, but you lucked out because—
I think what happened was I had an assistant do it, and it was one of the cases on my case list. And so she just pulled that case list. And so that's how the number shows up on that leave.
Got it. Okay. But you've got Walton. He is in bench warrant status. So you are free to go. You should go talk to your client. And I appreciate you dialing in. Okay. Mr. Luemba, you then have Ms. Jackson as your client.
Yes, Shane Jackson, Judge.
Great. She is here, and she hasn't had an opportunity to connect with you yet. So I want to hear you two exchange a phone number. So she's got a number to call. We'll reset this. I'm not going to make anyone go through a final plea colloquy because Ms. Jackson needs to be able to spend some time with you and then be in a better position to talk about what she's going to do in this case. We've had one plea or 2 pleas in this case already?
One plea so far.
One plea. We've had someone who I think has the most serious set of charges say, I'll see you in court. She's going to go to trial. That's her right. I don't know where Ms. Jackson falls in that hierarchy. But what is the best way for Ms. Jackson to be able to speak with you today?
I can say my number now. If she has a pen and she's ready.
Okay, she's ready.
404 721 5080.
Okay.
You got it? Please give Mr. Luemba your phone number when you guys are talking, and we'll reset this. We'll get another date to get you here to talk more about the case. Okay?
All right. Thank you, Judge.
All right. Thank you, Mr. Luemba, for jumping in.
Your Honor.
Oh, and hold on. Mr. Walton has appeared. I don't know how we get Ms. Cabrera back. That's fascinating.
I'll shoot her a text real quick, Judge.
Okay, tell her client just surfaced. Thank you.
Your Honor, if I may, very briefly, while Mr. Luemba is still on the call, Mr. Francis sent me an email while we were sitting here that it's 3 separate evidence.com links. If you have any issues, it's a large number of files. I can put it on a jump drive and leave it on the 3rd floor for you, Mr. Luemba, so we won't have any issues with discovery.
Okay, thank you so much.
All right, Mr. Luemba, thank you for parachuting in. Expect a call from Ms. Jackson momentarily, okay?
Okay,
and Ms. Jackson, okay, you're free. You don't need to call. Obviously, you can't call in here, but you're free to go now. But please do call him, whether you're doing it wherever you're going next, but in the next few minutes, because he's holding for that.
Okay.
Thank you so much.
All right, thank you.
Thank you.
All right, I'll remove him and then see if we can get Ms. Cabrera back. Hey, Mr. Walton, can you surface? Hey, how are you doing?
I'm good.
How did you know to be on the call?
My cousin notified me, said I had court today.
Okay.
I'm back, Judge.
Hey, sorry
The
to do
one
that to
told me
you.
that she just showed up.
Yeah, check that out. Here is Mr. Walton. I think what would be best is if you two exchange contact information, because Mr. Walton would need to walk in, probably with you at his side, since I've already signed a warrant for him because he didn't come to court before. I'm happy to set that aside if you and he work with Ms. Nelson to figure out a date in the very near future when he would come on into court.
Okay, I can do that. Mr. Walton, give me your phone number, please.
832
832
506
506
0456.
0456. I can call Mr. Walton once I get finished here at the Douglas County Jail. And I will send Ms. Nelson an email before I even drive away from the jail so that we can coordinate
Perfect.
Me coming in. Maybe I can come in next week. I don't know what Your Honor has on the calendar. I think I'm before Your Honor at some point. I'm before Your Honor this week.
Great. Well, you work with, where's 832? Where are you, Mr. Walton?
I'm currently in Oregon right now.
You're what?
I'm currently in Oregon.
Oregon. So he's probably not coming in this week. Are you in Oregon because you're on vacation, or that's where you live, or that's where you're hiding out from us?
No, that's where I currently work. I didn't even know I had court the last time. They called me last minute.
Yeah. Well, that's why these charges are pretty old. That's why I'm pretty flexible about how we sort this out. So it may be Ms. Cabrera, after you talk with Mr. Walton, rather than make him fly across the country, we just have another Zoom after you've had a chance to connect with him. And then you can connect with Mr. Jordan. Discovery in this case is ginormous. But you don't necessarily need to wade through everything. Mr. Jordan's been real good about giving folks guidance as to what to read and what not.
What's Mr. Jordan's first name?
Julian?
Julian? Okay. I'll send an email too. What I'll do is I'll send an email to Ms. Nelson and Mr. Jordan after I've had a chance to speak to Mr. Walton, so we can kind of coordinate getting him back on a calendar virtually.
Great.
And then I can talk to Mr. Jordan about collecting that discovery.
All right. So, Mr. Walton, you live in Oregon now, or you're just out there for a minute?
No, I currently live out here. I work out here, actually.
You work out there. So where's home? Like, if you got laid off today, where would you go?
I'll be out here pretty much.
How long have you been in Oregon?
For about a couple of months to a year almost.
Well, a couple of months and a year are different. What is area code 832?
That's a Houston area code. That's why I used to say it.
It's a what area code?
Houston, Texas.
Oh, Houston, Texas. Did you ever live in Georgia?
Yeah, that's where I'm born. That's where I'm originally from. I'm born from Atlanta, Georgia.
All right. Well, Ms. Cabrera is going to earn a lot of frequent flyer miles. She's going to call you. Take her call. Is your phone 40467? What area code should he be expecting?
So he's going to expect a 201 area code. It's a Jersey area code 201.
Dang. So no one's from Georgia. All right. So don't screen a 201 call. That's your lawyer calling you. Okay.
Yeah.
Right.
And give me about 30 minutes or so. I'm doing a interview with a client at the jail. Once I get done here, I'll be able to call.
All right. We will not bother you again today, Ms. Cabrera. Thank you.
That's okay, Judge. That's okay.
All right. Bye-bye.
Thank you.
All right, Mr. Walton, look for a call from a 201 area code and you guys will talk shop.
All right. Appreciate it.
All right.
Thank you, Judge.
You bet. Mr. Jordan, does it make sense to reset Ms. Jackson to final plea or inquiry, or I guess final plea once Mr. Luemba has had a chance to get through discovery?
Yes, Your Honor. And that's Ms. Jackson's case is the only case so far where the state has extended a probated offer other than Ms. Heflin. So I believe that's one that might resolve.
Will work out. And more importantly, if we get to Ms. Hill, and we're going to talk to Mr. Hill in just a minute, and is trial time severing, you don't envision it being multiple trials?
No, Your Honor.
Okay. I didn't ask that very well. If Ms. April Hill is ready for trial and Ms. Jackson hasn't caught up because Luemba just got the discovery. And I said, we're going to go forward anyway with April Hill. You don't envision there being a second trial of just Ms. Jackson?
No, Your Honor.
Okay. All right. Thank you. Okay. Ms. Paul, you are on the call.
Yes, Judge. Let me put my camera on. Sorry.
No problem.
Okay, I'm here. Thank you. Did you get my message?
You had to go to magistrate court, so we were fine holding for your report. Your client is here in custody. If you were listening in, we've been talking all about this same case. Mr. Jordan indicted about 9 people in this case. Have you and Mr. Hill had a chance to connect, and are we able to do the final plea colloquy?
Yes, Your Honor. I did. I visited him yesterday and we were able to discuss the plea offer.
Okay, and is that something he's interested in doing, or is he going to say no thank you and we can move the case to a trial calendar?
He's going to say no thank you and move the case to a trial calendar. Your Honor, if I may, did any of the co-defendants accept the plea today?
One pled a while ago, and Ms. Hill, April Hill, said no thank you. Pretty emphatically no thank you. And then Ms. Jackson, her lawyer, is just now plugging into the case, and those have been the only ones that we dealt with. Mr. Burnett didn't show up, so he's got a bench warrant.
Okay, thank you, Judge.
You bet. Let's bring Mr. Hill out, please.
Would you like me to stand at the witness stand?
You can stand wherever. It's a brief conversation, just because you're going to probably not want to be right next to Mr. Hill. Is he in custody just for this?
I believe that.
No, Your Honor. He has a hold in Clinton County.
Got it. Mr. Hill, how are you?
How you doing?
I'm all right. Your lawyer, Ms. Paul, is on the screen there. She had to be in court elsewhere, but knew she needed to plug in for this, and virtual is okay for what we're doing today. I'm gonna get on the record in your case, 24 SC 000053. You're Marquise Hill. Mr. Jordan is the prosecutor. Your lawyer, Ms. Paul, is on the call. Ms. Paul, do you feel like you've got all the discovery in the case?
Yes, Your Honor.
Okay, I know it's a lot, but it sounds like you got it. Mr. Jordan, what is the state's offer? If Mr. Hill wanted to resolve the case today by way of a plea, what would you be recommending?
Your Honor, as to Mr. Hill, who is listed as count 5 in this indictment, the state's recommendation is 10 to serve 1, with the balance being probated. The special conditions of probation being that he have no contact with the victim and that he attend and complete approved anger management course.
Got it.
And Your Honor,
go ahead.
I believe I'm missing the forensics. Actually, that's the only thing if I recall correctly, I'm missing.
Okay, as in an interview at the Georgia Children Center for Children.
Yeah, I believe so. There's 3 minor children involved. I believe I don't have any of those interviews.
I'll make sure, Ms. Paul, to go ahead and I believe it's multiple interviews for this particular child, but I'll make sure to send them to you separately. I believe that they're included within the 201 items.
Okay, thank you.
All right, Mr. Hill, the question of the day is, are you interested in going forward with that recommendation, or is it your preference to go to trial so the state has to prove up its case?
Go to trial.
Okay, and that's what Ms. Paul mentioned when we got her on before we brought you out here. You are on our trial calendar at the end of the month, so I will see you soon on that. How are you related to April Hill?
It's my mother.
Okay, your mother also wants a trial. So you and your mother are gearing up for trial towards the end of the month, early next month, and we can make that happen. Ms. Paul mentioned that you're also being held because you've got something in Clayton County. Is that right?
Yes.
Do you know what that is? I'm not quizzing you. I don't know. I just wondered if you know what the Clayton charges are.
Oh, yes.
Okay, all right, good. All right, well, that's it. I will see you soon. Mr. Jordan will make sure that Ms. Paul is able to get her hands on those forensic interviews, and we'll take it from there. Before you go, Ms. Paul, anything else on behalf of Mr. Hill?
No, Your Honor.
All right, thank you for rejoining us. Appreciate your time, and we'll see you at the end of the month.
Thank you, Your Honor. That concludes my business.
All right, bye-bye.
What's the court
Bye.
date? The 30th?
It's the 30th.
Okay.
Yep.
Thank you.
All right, bye-bye.
Have a good one.
You too. All right, Jonathan Carter, we already talked about. Prevalon, let's do that. And who, is it Prevalon or Previon? Either or?
That's fine. Prevalon is fine.
Okay. And Ms. Clark, this is your other case.
Yes, Your Honor.
All right.
My apologies, Your Honor. My business is concluded, man. Please excuse me.
Yeah, you don't have anything on the upcoming trial calendar?
I'll just go back to my office and get on Zoom.
However you want to do it.
Thank you.
We only have 2 things left here. Three. As many as you guys want.
Gotta go back to the morning's calendar.
Okay.
Mr. Stanley.
Cool. We'll do that too. We got 2 left on this calendar. You're Mr. Prevalon. Let me look up one thing.
I'm trying to find some time to take time off. It's just announcements.
Sorry about that. You've got something in the system that I need someone to check on. This is 23 SC 19839, State versus Previon. Mr. Previon is here with his lawyer, Ms. Rios. Ms. Clark has this case for the state. Ms. Rios, have you had a chance to pour over discovery that may have been provided to your predecessor on the case to see where we are?
Yes, I looked at majority of it. I think I did go to the office to meet with Ms. Clark, and they did a BOCO swab. So we're in agreement. We're trying to ask for a reset date to another final plea because the chance for those results to come back, and that just gives me more time since it's a pretty detailed case to get up to speed on everything.
So the nature of this case is one where the buccal swab will reveal something that is surprising to you. I don't know how to, I mean, I guess some of these cases where the defense is it was consensual, in which case the buccal swab is not a particularly profound, it's necessary because you'll make a big deal out of it, as you should at trial if the state didn't do it. But it doesn't, if the state comes back and says, it shows that it's got your client's DNA, you say, of course, because it was a consensual act.
That's correct, Your Honor.
Okay, so then it doesn't strike me that the results of that will change a whole lot.
No, I would guess I'm saying if it, for some reason, nothing showed that, would make a difference, but yes.
Okay, it's not on until the July calendar.
Okay.
And so I am okay saying, let's preserve the final plea rights. In other words, not cross the final plea bridge right now. Unless the state has made some super offer, the penalties for rape are so high, it doesn't seem like the results of that is going to change it for the state. But either way, I don't mind preserving your client's final plea rights. I would prefer to keep it on that July trial calendar.
That's fine, Your Honor. Yes. That's 60 days from now anyway, I think.
Yeah, so that should be enough time. This is an old incident, though. That was the other thing I wanted to check. It looks like it's Christmas Day 2020. Okay,
Yes, Your Honor.
all right. For some reason, your warrant hasn't cleared up.
I called them and that case has been closed in February. The warrant was already stopped in December.
Okay.
So
I'm not taking you back into custody, but it's still showing up. That's what with me typing, making you stand there, type. I'm like, this guy's warrant is still here, but my staff says you've already arrested him once on the warrant. So I won't a second time, but maybe between the two of you, you can figure, and if I need to sign something, I mean, it really needs to come from Cobb County.
I've reached out to the sheriff department. They say it's not in our system, so.
Okay. Maybe it needs to be fixed on our end of things. But either way, false alarm from here.
Out to if it's on our end that we need to.
I don't know. I'd ask Miss Feely.
Okay.
But it pops up in Odyssey at least. And if that's the only place it's popping up, that's an easy fix.
Okay.
Because it could be as easy as my team could do it. It may have to come from the sheriff where someone in their warrant division would call Cobb and Cobb would say, no, that thing's dead.
Okay.
Because this is not GCIC saying it, it's Odyssey saying it.
Yes.
So, but it would be helpful to get that out of there. So here's what we're going to do. We don't need to talk about this case anymore. There is a little bit more evidence to be developed in terms of what does the DNA show. Doesn't sound like it's going to be earth shattering there. We'll keep this case on the July trial calendar. We'll preserve your final plea rights. All that means is if you enter a plea and you don't like the sentence I give you, you can back out of the plea. After that deadline, if you don't like the sentence, like if you go to trial and you're found guilty, you don't get to say, I don't like your sentence. You can say, I don't like your sentence, but you're stuck with that sentence. But just hypothetically today, if the state had recommended X and your lawyer recommended Y, if I did anything more than Y, you could say, nope, I'll go to trial. You're going to have that right until we get to the trial calendar. And then that'll be the last time I'll say, this is it. What's the offer? State's going to say whatever it is. You may put up what we call a blind plea, if that even works, given your charge. The state may reduce it so that a blind plea would work. And then you could still withdraw your plea if my sentence was more than what Ms. Rios asked for. Okay. Otherwise, you know the routine, stick to the conditions of your bond. We need to resolve this. We're fast approaching year 4 of this. It's not fair to the alleged victim. It's not fair to you. And so that's why I'm keeping my pressure on you all to say, hey, we've got a July trial calendar. Let's try to either do the trial or come up with some resolution. Ms. Clark, anything you want to add to the mix in this case?
No, Your Honor, other than that I've requested an expedited return on the GBI results. And they've assured me, I let them know that it was on the July trial calendar, so I needed it. So they'd said that they could have it done by July.
How long ago? We did one today. How long ago did we do Mr. Previon's?
That was last week.
Okay. Is this something you guys worked out?
Yeah.
Great. Okay. Well, at least it's ahead in line with the one we did today, Mr. McGriff. Okay. Do you have any questions?
I don't.
All right. Good luck with this Cobb warrant.
Thank you.
All right.
That reminds me, Judge, Miss Sweeney, she had a warrant. She took the plea. Does that clears everything out? It was in this case.
It should. It was the warrant for this case. And so we say something in the final disposition that says make the warrants go away.
Okay.
And yeah, and do check. If not, tell me what I need to do. All right, Ms. Carter.
That was weird because it was like her arrested.
Yeah, the warrants. I think it's just maybe just an issue in the.
But it was an electronic warrant. And those happened. It's for the day of the incident because the police call it in and say this, hey, we need a warrant for this person, and the magistrate signs it. That's how I figured it was this case. It was the same date as the allegation, so it had to be this case. All right. What are we doing with Ms. Carter?
Still going through discovery, but we can leave it. It's on the July calendar date.
I don't know. It doesn't say. Oh, you just filed an immunity motion.
Oh, yes, that's what I did. Good.
Yeah.
I would like to have an immunity motion. I
Okay.
just got on the case and I was looking at everything, and I believe it's a good immunity motion, Your Honor.
Okay. We need to sort out the ankle monitor today. And then we'll set this down for an immunity motion. How long have you had an ankle monitor?
Since I was bonded out, which is December 2021.
So I've been on it for about 3 years.
All right, Ms. Nix, I'm gonna give you as much time as you need, that is 10 days or less, to contact the alleged victim to see if there's any heartburn. The ankle monitor's coming off, unless in talking with the victim, you learn, dang, Ms. Carter is emailing this person, drives by slowly in a car and waves at her, that kind of stuff. Otherwise, this is one of our lost ankle monitors. Not your fault, but it's been on way too long.
I will contact the victim about that issue specifically. She did tell me that she has been being contacted by third parties on behalf of Miss Carter. I don't know that we have enough to show that Miss Carter is directing these third parties to contact her, but she did tell me that that is something that has been ongoing since this incident.
Okay.
So
what would be helpful would be maybe just to learn a little bit about one or two, not today, but one or two, if this is something that you want to pursue or on behalf of the alleged victim, you're doing that. And we can see, Ms. Carter, I'll make real plain to you, ankle monitor or not, if any of that is connected to you, you just sit in jail till we resolve your case. I know that's not what you want, but this whole, you have no contact with the other person. I'm not remembering her name, but I looked at Ms. Bell, that you have no I believe that you're honoring
I
it.
don't even have social media.
Okay.
My last.
But now I'm not saying you're in any bad space at all. You may have friends who feel a certain way about how this has played out. Maybe they feel like Ms. Bell put some charges on you that she shouldn't have because of things she said.
Right.
You need to encourage those friends to just knock it off.
Yes, sir.
Now, I don't want you to do anything right now, because if you haven't had them do this, they're doing it on their own. But if Ms. Nix is concerned about it, she can get those names to Ms. Rios, and then Ms. Rios and you can have a conversation. Hey, do you know, I don't even know these people. Oh, that's my play cousin, and I bet she's doing that. I'm gonna tell her to knock it off.
Yes, sir.
And you may choose to do that, or Ms. Rios may do that, because I don't want it to be a trap for you, where you reach out to one of your friends saying, hey, I need you to leave Belle alone. And then that person says, I just talked to Ms. Carter and I'm really mad at you, Ms. Bell, because my goal is for you not to go back into jail unless and until that's an appropriate thing. I also think we need to get that ankle monitor off you. So, do you need more time you haven't had a chance to talk with Ms. Bell about the ankle monitor?
not about the ankle monitor, but I
Okay.
do have a good contact information for her, and we've discussed this case. So
Great. I'm going to send an email in a few days to both of you saying, what's the deal with the ankle monitor? And you can say, Ms. Bell feels real strongly about it, and we may need to have a hearing. It could be she'd prefer it not come off. You should let her know my inclination is, after almost 3 years, we are probably 2 years and 6 months late in removing the ankle monitor. That doesn't mean that we should ignore the concerns Ms. Bell has. If she wants to give you names or online handles or whatnot, then you could share those with Ms. Rios and we could see if we could tamp that down. But otherwise, that's a misuse of our ankle monitor resources. So that's the plan. We need to have the immunity hearing. I asked Ms. Nelson to see if Judge Dempsey has remaining capacity. Our ability to fund the whole ORCA thing ends soon. And so I'll handle it if Judge Dempsey can't handle it. I don't want, also if he says I can't do it for 3 months, I'll do it before then, because I'm anxious to move this along. If you've had the ankle monitor that long, that means that whatever you're charged with happened that long ago, and we need to move this forward. So I think that's our next stop, is the immunity hearing. Anything else, Ms. Rios?
No, Your Honor.
Ms. Nix?
No, sir.
Okay. That's the deal. Thanks for your patience.
Oh, thank you. I'll call you. Yes, ma'am. Thank you so much. You guys have a good day.
You too. Immunity. How long do you think that is? That just your client testifying, or is it some immunity hearings are 3 days, and you're basically doing the entire trial. Others are your client testifies, the state calls the victim, and kind of know how the trial is going to go after all that. But it's a half day kind of thing.
I've never done one, but I do plan on subpoenaing a few people. So
Okay.
I'm not sure.
All right.
There's a lot of moving parts to this case.
Okay.
I think it would involve playing some videos. So they might.
Videos as in who made like body cam videos or
Instagram live videos
of what happened?
of what led up to it.
Oh, well, all right. It's not going to be a half-hour hearing.
Yeah, I don't think
Okay.
so.
All right.
I think a full day.
Probably.
I hope Judge Dempsey's available. All right. Fair enough. Thank you all. I thought we were done. Let's go back to our morning calendars. You guys did great, by the way. This is what happens when I take a week off for a civil trial, all this pent up demand. The 9 a.m., we got all the way through one of them, 9 a.m. We still have Kevin Phillips and, I didn't write down what we did with Kevin Phillips and Jermaine Stanley. Those are the two I'm aware of. I don't mean to make you stand up all the time.
Oh, no, that Kevin Phillips is not.
And what is it?
It's a plea.
Oh, it's a plea. Okay. And then what about Jermaine Stanley?
Also a plea as well.
All right. You want to come back, Mr. Abate, or this is your safe space to do work?
I may come back.
Okay.
What time?
4:35. I'm hungry. I haven't eaten yet today.
If it makes you feel better, this was like the one time I actually put in a leave.
Today?
Yeah,
Oh, I thought it was like we weren't supposed to.
yesterday and today,
Oh.
but I saw how many cases I had on the
Okay.
calendar.
Well, what happened yesterday?
Yesterday, I actually did stay home.
Then where's the pity factor?
I worked, because
Okay.
I worked on,
All these cases?
Yes, and it was the one with, that we're gonna try and do the families first thing.
Oh,
That was it.
that's a great development, by the way. This Families First.
It is, I'm excited for it now that I know they can actually.
You can do diversion.
Yeah.
Yeah.
'Cause before it was, well, you get a misdemeanor, and they were like, well, if the diversion, I can get dismissed, then I want the misdemeanor.
So who are we doing first?
Phillips.
Phillips, done. Okay. Good seeing you, Miss Feely.
I'm back.
Oh, you keeping some of the trial calendar cases? Oh, well, you guys go do your thing why don't you go settle the case? Who is it? Marquez Wilson, whatever. It would seem like those would have settled a while ago if they were settled.
I didn't even put together that was not a dog.
All right, you're Mr. Phillips?
Yes, sir.
Okay, do you want to be at the podium or you can be right there?
I see where I am.
Okay, you'd rather sit. I think IT finally came through. Look at that. There's Mr. Phillips and Ms. Clark is right there. Perfect. Ms. Rivers, you okay to keep going?
Still here, Judge.
Great. We got two more pleas, and then folks who are not on here for the trial calendar are free to go. So let's push through these. This is position 5 from our plea calendar, 24 SC 000954, State versus Kevin Phillips. Mr. Phillips is here in court with Ms. Wood. Ms. Clark has the case for the state. She is here, and Mr. Phillips wants to enter a plea or is going to enter a plea. Mr. Phillips, Ms. Clark will put you under oath. You'll answer a bunch of questions from her. You need to be sure to let me know if you've got any questions, okay?
Yes, sir.
Let's do this.
Please raise your right hand. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Do you put your hand down? Please state and spell your correct legal name.
Kevin McGee Phillips. KEVIN. MCGEE.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there a medication that you normally take that you have not taken or been given today?
No.
How old are you?
44.
What is the highest level of education or the last grade you completed?
I got a GED, ma'am.
Are you able to read, write, and understand the English language?
Yes, ma'am, a little bit.
Do you understand that you've been charged with one count of state sex offender registry violation?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to this charge?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, then the state is required to prove the charge against you at a jury trial?
Yes, ma'am.
Have you had an opportunity to review the indictment with your attorney?
Oh, yes, I did.
And did you understand the indictment as explained to you by your attorney?
Yes, ma'am.
And did you have an opportunity to review your waiver of rights with your attorney?
Yes.
And did you understand the rights that you would be waiving as explained to you by your attorney?
Yes, ma'am, I did.
Is it your decision to waive your rights today?
Yes.
Do you understand that you're entering what is called a negotiated plea of guilty, which means that the state and defense jointly will recommend the following sentence to the court?
Yes, ma'am.
3 years probation, no further violations. Defendant will report to the sheriff's office with his residence within 72 hours after release from custody.
Yes, yes, yes.
And your attorney provided your address is 1940 Fisher Road, apartment 29D.
Yes, ma'am.
Atlanta, Georgia 30315. Is that correct?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on this charge?
Yes.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you do have the right to withdraw your guilty plea?
Yes.
Are you currently on probation or parole?
No, ma'am.
Do you understand that if you are on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence? The only special condition of your probation is you must register within 72 hours of your release from custody.
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena witnesses on your behalf, the right to testify or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial? Is it your decision to waive these rights, Defendant Phillips, which means not to use them and to enter a guilty plea today?
Yes.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
As to indictment number, excuse me, Your Honor, as to indictment number 24 SC 000954, how do you plead to the sole count of state sex offender registry violation?
I plead guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing what is called a habeas corpus petition?
Yes, ma'am.
Do you understand that for a felony charge, you have only 4 years from today's date to file that petition?
Yes.
Your Honor, at this time, the state will provide a factual basis for the felony plea in this case. If this matter would have went to trial, the state would have been able to prove beyond a reasonable doubt that on November 18th of 1998 in the Superior Court of Crisp County, indictment number 98R 068 and 98R-205. Kevin Phillips, the defendant in this case, was convicted of the crime of statutory rape and child molestation, respectively. Defendant is registered with the Fulton County Sheriff's Office Sex Offender Unit as residing at the location of 185 Central Avenue, Atlanta, Georgia. While conducting address verification during Operation Watchful Eye, deputies from Fulton County learned the address provided by Phillips was a rooming house, and after speaking with one of the residents, deputies also learned that the defendant had not been seen at that location. Defendant Phillips, at the time of the warrant being sworn out, had not contacted the Fulton County Sheriff's Office in order to provide his new updated address. Therefore, the defendant was charged because he was listed as an absconder. The criminal history for the defendant, Your Honor, is as follows. He has 6 cycles of arrest. Previously stated the 1998 conviction for child molestation out of Crisp County Superior Court. The statutory rape conviction out of the same year. Under cycle 4 in December 2023, the defendant was convicted of theft by taking in Fulton County on probation for 2 years. Nothing further from the state, Your Honor.
All right. Ms. Hardy, do you have anything in addition to that?
No, Your Honor, nothing to add.
All right, thank you. Ms. Wood.
Thank you, Judge. Mr. Phillips is 44 years old. He's originally from South Georgia. He's been here for a number of years. He does have a GED. He's also a long haul trucker. I did let him know that he will need to work that out with probation for him to leave the state of Georgia. And I provided his contact information to Ms. Tucson. We would just ask that you accept the state's recommendation. He sat in custody for about a month before getting released, Judge.
Okay. Mr. Phillips, you have a place to stay now? There was this whole discussion about Fisher.
Yeah, right now, I really don't know, Your Honor, as of right now, I'll be honest with you.
Okay.
Yeah.
So I'm confused. Like when you get out, you're going to get out in the next few days. Where are you planning on going?
That's what I'm about to find out, be honest with you. I really don't know as of right now.
What's at that address we heard about? The Fisher, is it Fisher Road?
Yes, sir. Yes, sir. But you know, I got to go there first. I got to go.
Right, but if you knock on the door of 29D, at Fisher Road, who's going to answer the door?
My roommate.
Your roommate?
Yes, sir.
Okay. How long have you known your roommate?
About a year.
Okay. Any reason why? Is your roommate male or female?
Male.
Any reason why he would not let you stay there?
No, ain't no reason.
Okay. So when you say you don't know where you're going to go, why would you not go to Fisher Road?
I ain't got into a little incident out there, but not at the apartment.
Okay.
Yeah, that's what I'm saying.
Okay.
Yeah.
If you don't go to Fisher Road, where are you going to go? I mean, here's what I'm asking. I'm not trying to get up in your business. I don't want you to get another failure to register. And if you're bouncing around, you run the risk of the sheriff saying, I can't find Phillips.
Yeah.
So what's plan B if you don't go to Fisher Road?
Find somewhere to stay, you know.
Okay.
Yeah.
All right. Well, you know that's complicated. You can't just stay anywhere.
Yeah,
that's the burden you bear.
Yeah.
How long have you been a trucker?
About 2.5 years.
Do you have your CDL?
No, I drive over the road straight trucks.
I don't know.
Box truck.
Oh, box truck.
Yes, sir.
Okay. Got it. And Crisp County, what's a big city, if there is one, in Crisp County?
Albany, Georgia. It's close to it.
Okay. Is it Albany in Crisp or it's near Crisp?
Near Crisp.
Near Crisp. No big cities in Crisp? All right. Any questions about anything we discussed?
No, sir.
Well, I find there's a factual basis for your plea. This is one where it's just going to keep scooping you up. If you, I get it that it's hard to find a place to stay, but if you are scarce, it's just going to keep happening. And eventually the state's not going to say, hey, how about probation? They're going to say, because we can't know where Mr. Phillips is, I know how to guarantee where he is, Department of Corrections, and that's not what you need. You're 44. So do your best. It's not easy, but do your best to keep the sheriff's office apprised of where you're living. I do find there's a factual basis. Your plea is knowing and voluntary. I'm sentencing you pursuant to the Probation Options Management Act, which means during your 3 years of probation, if you have a technical violation, you and probation can solve that. You don't need to come see me. But if you get arrested for something, that'll come back to me. Ms. Wood, can we sign the indictment on your behalf?
Yes, please.
And Ms. Clark?
Yes, Your Honor.
Mr. Phillips, is it okay if someone from my office signs your name to the indictment indicating your guilty plea?
It don't make a difference.
Pardon me?
I don't care.
Okay. Well, I'm going to take that as a yes. I'm going to sentence you exactly as negotiated, 3 years probation. You will need to report within 72 hours of your release to the sheriff's office. You know where to go?
Yes, sir.
Good.
What's the earliest I can come off probation?
Pardon me?
What's the earliest I can come off probation?
Well, if you're doing well on probation.
I just completed probation in about 2 months ago.
Yeah. For the theft by taking?
Yes, sir.
All right. Well, now you have another one. But if you are doing well, probation will want to make it non-reporting. And if you're doing particularly well, there's no reason why Ms. Wood couldn't reach out to me saying, hey, can we suspend the balance of his probation? But it's one of those where you got to demonstrate things are going well. And that would be your reporting. It's not hard for folks to find you, that kind of stuff. I'm not interested in having you be on probation for 1,000,000 years. I just want to see some stability. And once you demonstrate that, then we should have that conversation. Ms. Tucson, it sounds like you've already received some information. Do you need anything else from Mr. Phillips? I'm going to assume she doesn't need anything else from you. And we will just make sure you plug in. You know where the probation office is on Memorial, right around the corner?
Yes, sir.
Yes. Okay. Sounds good.
One
Yes.
thing I wanted to say, if I've talked with Captain Lewis at the sheriff's office for the reporting purposes, if it's determined that he's homeless, then he'll need to let them know that, but he still needs to report. And if he's homeless, the only requirement will be that he'll have to report to probation once a week to let them know. But he doesn't not to need to report just because he doesn't have a place to stay.
Right. Okay. Sounds good. Thank you. I appreciate you wrestling all the way over here, Ms. Clark. Hope that you heal soon. And last but never least is Mr. Stanley. I'm gonna go grab something and we'll do that.
He went to grab something, but he's coming right back. Don't take Mr. Stanley back.
It's Ania's fault.
What?
Yeah, nothing's changed.
Okay. Hello.
Well, everyone's ready. Mr. Stanley, how are you?
I'm fine, thank you, sir.
You're welcome. Last plea of the day. This is 24 SC 000594, State versus Jermaine Stanley. Mr. Stanley's in court with Ms. Wood. And Ms. Willingham is here for another plea. It's good you didn't take the day off. It would have gone poorly.
That's actually why I didn't take it off. When I
Yeah.
saw how many cases I had, I came back.
You would have owed Ms. Nix like 9 birthday cakes or whatever you pay people who cover for lots of pleas. Mr. Stanley, Ms. Wood told me that you are prepared to enter a plea in your case. Is that right?
Yes.
Okay. The way that works is that Ms. Willingham is going to put you under oath in just a moment. And then she's going to ask you a bunch of questions. You need to answer her questions, and you need to let me know, or Ms. Wood, if you have any questions. If something confuses you or it's not going the way you thought it was, I need you to pipe up. Will you do that?
Yes, I will.
Great. Then this will work out. When you're ready, Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Please state your name and your age.
Jermaine Stanley, I'm 24 years old.
Are you now under the influence of any medicine, drugs, or alcohol?
No, but I take medication.
Did you take any medicine today?
Yes.
Is it medication that's prescribed by a doctor?
Yes.
And does anything about that medicine inhibit your ability to understand the proceedings today?
No, ma'am.
How far did you go in school?
11th grade.
Can you read and write in the English language?
Yes.
Have you had the opportunity to review the document that charges you in this case?
Yes, I have.
Do you fully understand the nature of the charges pending against you?
Yes, I do.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, I do.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes.
The recommendation in this case is that you would be entering a plea to count 1 with a sentence of 3 years to serve 1 year, count 2 with a sentence of 5 years probation to run consecutive to count 1 by operation of law, count 3 years to serve 1 year concurrent to count 1, counts 4 and 5 would be null pros, and count 6 you would also enter a plea and the sentence would be served 12 months concurrent to count 1. The state would be requesting special conditions of no contact with the victim, complete family violence intervention program, complete 80 hours of community service, have no weapons, no drugs, no alcohol, and the state would be requesting to reserve restitution, Your Honor. I have spoken with the victim multiple times, and the victim has stated there are some medical bills, but they have yet to get them to me. And I told Ms. Wood that once I get those, then we can talk, and if needed, we'll ask for a hearing.
Okay.
Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No, ma'am.
You heard me tell the court what the negotiation is in this case. which is an overall sentence of 8 years to serve 1 year.
And Judge, I'm gonna just intervene. This is
I'm sorry.
non-negotiated at the very
Correct.
end. You're fine. It's just a little bit of.
Okay, well, we had a plea like that where, I mean, it wasn't a meeting of the minds, but it wasn't 10 to serve versus probation. So we'll fine tune that.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you're not to violate the criminal laws of any governmental unit. Under the special conditions, as previously discussed, the state would be requesting no contact with the victim, complete family violence intervention program, complete 80 hours of community service, have no weapons, no drugs, no alcohol, and the state is requesting to reserve restitution in this case. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes.
Do you have any more questions for your lawyer before we go on?
No.
Have you understood everything I have asked you so far?
Yes, ma'am.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes.
Is your decision to plead guilty made freely and voluntarily?
Yes.
Did you in fact commit the offenses to which you are pleading guilty?
Yes.
Are you a United States citizen?
Yes.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 4 years from the date the sentence is entered for the felony offenses, and you will have 12 months from the date the sentence is entered for the misdemeanor offense to file this petition. Do you understand these time limits?
Yes.
Do you understand that you are not allowed to possess firearms during the course of your probation?
Yes, ma'am.
Do you understand if you are found in possession of a firearm, you could be charged with another felony, which carries up to 10 years in confinement?
Yes.
Your Honor, if the state were to proceed with this case, the state would prove beyond a reasonable doubt that and this is two separate incidents, Your Honor, so I'll read two separate set of facts.
Okay.
That on September 13th, 2022, at approximately 8:35 p.m., Officer Andre Franklin responded to an assault call at 808 North Elizabeth Place, Northwest. Upon arrival, Officer Franklin spoke with victim Anthony Lee, who stated that that Jermaine Stanley, later identified as the defendant, was a former intimate partner who spent the night at Mr. Lee's home. The next morning, when Mr. Lee was getting ready for work, he told the defendant that it was time for the defendant to go. The defendant and Mr. Lee started to argue. The argument then turned physical. The defendant went and grabbed bleach and threw it on some of Mr. Lee's clothes. Mr. Lee grabbed the defendant's hands, at which point the defendant pushed Mr. Lee and pulled out a pocket knife and cut Mr. Lee about his hands and face. Mr. Lee sustained lacerations to his hands and forehead. The defendant was not on scene when Officer Franklin arrived. Officer Franklin took Mr. Lee's statement and a warrant was issued for the defendant's arrest. Mr. Lee refused medical attention. On September 18th, 2022, at approximately 2:13 a.m., officers received a wanted person call at 808 North Elizabeth Place, Northwest. Upon arrival, officers spoke with Mr. Lee, who identified Jermaine Stanley, the defendant, who was at the location. The defendant was detained while officers ran a ACIC check, which confirmed an active warrant for the incident that took place on September 13th, 2022. Officers recovered from the defendant's book bag a pocket knife with blood on it. The defendant was placed under arrest. Also, on October 10th, 2022, at approximately 8:35 a.m., Officer Aaron Swan responded to a fight call at 808 North Elizabeth Place, Northwest. Upon arrival, Officer Swan spoke with the victim, Anthony Lee, who stated that Jermaine Stanley, later identified as the defendant, who was not on scene when Officer Swan arrived, had been at the location for 2 days and spent the night. While Mr. Lee was on the phone with a friend, Mr. Lee's friend stated to Mr. Lee, "Is that crazy dude still over there?" referencing the defendant. The defendant overheard Mr. Lee's friend make the statement, and the defendant got upset. Mr. Lee hung up the phone with his friend, and a verbal altercation ensued between the defendant and Mr. Lee. Mr. Lee then went outside of the location with his dog to get space from the defendant, and the defendant followed Mr. Lee outside. While outside, the defendant struck Mr. Lee 2 times on the head with a branch. Mr. Lee then fell to the ground and blacked out briefly. Mr. Lee's head started to bleed and his ear started to ring. The defendant then apologized to Mr. Lee and felt bad, so the defendant then helped Mr. Lee back inside the house to Mr. Lee's bedroom. Mr. Lee told the defendant he could not do this anymore and that the defendant should go home. Mr. Lee and the defendant continued to argue. The defendant and Mr. Lee started to tussle, at which point the defendant held Mr. Lee down and bit Mr. Lee's ear. Mr. Lee tried to call 911 and leave the location, but the defendant took Mr. Lee's cell phone, preventing him from calling 911. Mr. Lee was able to leave the location to go to a gas station and call 911. Mr. Lee sustained bruising to the top of his head, lacerations to his arm, and a piece of Mr. Lee's ear was hanging. Officer Swan took Mr. Lee's statement and a warrant was issued for the defendant's arrest. Your Honor, I've had an opportunity to speak with Mr. Lee, and although Mr. Lee wants the defendant to be held accountable, he does not want to go to trial. When we discussed a higher offer, I was very candid with him and acknowledged that based on my communication with Ms. Wood, I did not expect the defendant would accept that and that I would prepare this case to go to trial. And when he asked, does that mean he has to testify? He said, well, I don't really want to do that, but he did want him actually held accountable to some capacity. So we discussed reducing the offer, we discussed restitution and what that would look like, and he felt more comfortable with that than he did with having to possibly testify.
Okay.
And if I recall, I don't have his GCIC in front of me at the moment, but I did check his criminal history, and I believe these are the only 2 cycles. The defendant might have had one other ag assault, but it was dismissed.
Okay. Good afternoon, Ms. Hardy. Your last case of the day. Do you have, what do you have from your run of criminal history?
I showed the 2 arrest cycles. That other one that she was just referencing, September of 2022, that aggravated assault arrest. But that's all I'm showing.
2 cycles?
Yes.
All right. Thank you. I appreciate your help today. You are free to go.
Thank you. Have a good evening.
You too. Ms. Wood.
Thank you, Judge. I do want to add that, as is often the case with so many of our intimate partner violence cases, that there's both sides are involved in the combat in some form or fashion, and then one party usually gets arrested. And so in this instance, Mr. Stanley, it's his position that there was some mutual combat, and so he's just eager to get this behind him, Judge, and is accepting responsibility. He's been in custody since December 3rd, so he's almost got 6 months built up. I'm asking for 5 served 6 months. His mother was here earlier today. She had to leave. He's 24 years old. He will be returning to live with her. She has a stable address here in Atlanta. He's got an 11th grade education. He was working at McDonald's and UPS prior to incarceration. The only other things I would ask, so that he can complete FVIP, I would ask for probation fees to be waived for the first 4 months. And then also I went over the pros and cons of first offender. I do believe he qualifies and he would like to be treated as a first offender, Judge.
All right. Mr. Stanley, how long has Mr. Lee been out of your life? I know in October of 2022, you were still around because that's when you bit a chunk out of his ear. Since then, have you seen him?
I didn't bite his ear, but I know I haven't seen him after that. I really haven't been around him because he told me he didn't want me around.
Okay, but it sounds like he told you that before, but you haven't seen him since October of 2022.
I haven't seen him since the last incident.
are receiving medication at the jail, or when you were not in jail, you were
That's
receiving?
at the jail. I only received medication with jail, but I was going to follow up with my medications after I got out.
Got it. And what are those medications?
I take Zyprexa.
More importantly, I don't need the names because they're hard for the court reporter to
Oh,
spell. What do they help you? What do they help treat?
Well, I have some sexual diseases.
Okay.
Right now.
Do you have anything like depression or?
Depression, yeah, I take Zyprexa for depression. And for my mental health, that's what I take Zyprexa, and I have trouble sleeping. I take Benadryl.
Okay, but the main diagnosis you've received in terms of mental health is depression or anything else?
Depression and no, that's about it for that.
Okay, all right. Do you have anything you want to share with me about your case or anything else, or you're comfortable with what Ms. Wood had to say?
I'm comfortable with Ms. Woods had to say. I just have, I didn't never get my statement across about what happened, but.
Well, and I appreciate from Ms. Wood's observation that there are two sides to the story. It is uncommon, especially when it's intimate partners, that it's just one person unprovoked doing something to the other person.
Right.
But it sounds like on now a couple of occasions, something happened to Mr. Lee that got a little too dangerous, whether he instigated it or not. Clearly, that was a toxic relationship.
It was very toxic.
Okay. Were you working before you got arrested on this case?
Yes, I was working. I was working at McDonald's.
Doing what?
I was in the grill station. I also fried products.
Okay. How long had you been at McDonald's?
I worked at McDonald's. That was my first job ever. I've been working for McDonald's since I was 16.
Oh.
I got that job at my birthday. It was like my birthday gift to myself, a job.
Okay. And then you had stayed at McDonald's, or you were there on and off?
I was there on and off. I had worked at UPS through a temp service, but they wanted me to follow up back with them. I was going to do that. And yeah, I've been working for McDonald's for about 5 or 6 years.
Okay.
It was my first job.
Did Mr. Lee work?
Oh yeah, he worked, but he did temp service jobs like downtown somewhere by North Avenue.
Okay.
It was a temp service job.
But wherever he was doing, you and he have parted ways, gone in different
we have
directions.
parted ways for sure.
All right, good. Well, Mr. Stanley, I find there's a factual basis for your plea. That's not me taking sides. It probably would be a complicated trial, and Ms. Wood would do a good job of drawing out of Mr. Lee, hey, but then you did this, right? Not Mr. Stanley, but a jury could find you guilty, which is why you may want to get out ahead of this and enter a guilty plea. I also find that your plea is knowing and voluntary. Knowing means you've understood what we talked about. Is that fair?
That's fair.
And voluntary means that no one's forcing you to do this. It's not a happy moment, but no one said you better plea or else.
Right.
Also true?
Yes, true.
Okay, then I'm accepting your plea. I'm sentencing you pursuant to the Probation Options Management Act, and that means that while you're on probation, if you have a minor violation, you and probation will resolve that. But if it's a bigger one, you get arrested again, anything serious like that, that comes back to me. First offender is an opportunity for this not to be a major issue on your record. If I sentence you as a first offender, it's not actually a conviction. So when you get out and you're looking for work, you don't have to check the box, I'm a convicted felon.
Okay.
If people run your criminal history, it doesn't show that it's a felony. That's the good part. And if you successfully complete your sentence, then you can get it all expunged.
Okay.
The downside is you're young, and if you actually haven't figured out entirely yet how to control your passions, and you get in trouble again while you're on first offender probation, not only do you have the new charges, but we'd have a hearing, and if the state proved without a trial, with a lower burden of proof, if they proved that you had done this new thing, then I could take away your first offender status and re-sentence you as a felon to a pretty healthy amount. Aggravated assault is 1 to 20. Aggravated battery is 1 to 20. So that's a lot of time to work with.
Yeah.
And so I just need to make sure you understand the downside. If you're pretty sure you're not going to get in trouble again.
Get in trouble. I'm gonna stay working. I'm gonna be a working man.
All right.
Yeah, my mom.
Okay, well, I am hoping that's what you do. But you're telling me you understand the benefit of first offender, doesn't mess up your record, easier to get work, go back to school. You also understand the risk. If 2 years from now you get arrested because you broke a bottle over someone's head because you got mad at him, not only are you gonna have that new charge, but I will tell you, if the state shows you broke a bottle over someone's head.
Funny, because that's what happened to me. That was the injury that I had got.
Okay, well, that is ironic. I didn't know that happened to you. But if you do that to someone else, then this could all come tumbling down. And I could say, you know what, you told me you were gonna be hardworking, stay with your mom, stay out of trouble, and yet here we are, 10 years. I'm making that number up. I don't know that would be 10 years, but I've got a lot to work with. You understand that?
Right, I understand.
Okay. Understanding all that, do you still want to be sentenced as a first offender?
Yes.
Okay, I will do that. So your sentence on count 1 is 1 year to serve 10 months with the balance probated. Count 2 has to be consecutive to count 1. The way I'm structuring your sentence has to be 5 years. And I'm going to probate that. Count 3 is 1 year to serve 10 months. Count 6 is 10 months to serve. 3 and 6 run concurrently with count 1. And as I said, 2 runs consecutive. So the total sentence is 6 years to serve 10 months. You get credit for the time you've served. You've served a little under 6 months. So you're going to stay in custody a while longer, a little less than what the state recommended, more than what your lawyer asked for. You'll be on probation for a little less time, but plenty of time for us to figure out, are you making better choices?
Right, right.
Special condition of probation number 1, no contact with Mr. Lee. Okay. Don't look him up. If you know the bar he likes to go to, don't go to that bar because you know you're going to be looking for him there. Okay. You cannot be around him. You can't write him. You can't text him. If you guys have a shared friend named Dave, you can't ask Dave to reach out to Mr. Lee. Hey, tell Mr. Lee I miss him, or I'm sorry, or I'm going to break his head. Nothing. No contact with Mr. Lee.
I got you, sir.
You'll have to complete the Family Violence Intervention Program, 80 hours of community service. I will waive your probation supervision fees for the first 4 months. I will ask the Department of Community Supervision to assign you to a mental health probation officer, one who is more attuned to working with someone who's taking medications, things like that. We'll table the question of restitution until later. And I think I covered all the conditions. Ms. Willingham, anything else in Mr. Stanley's case?
Nothing from the state.
Ms. Wood?
No, Your Honor, thank you.
All right, Ms. Tucson, you still with us?
I am still here.
Great. Mr. Stanley will be out in a few months at the latest. Do you want to give him reporting instructions, or because it will be a few months, he'll just get that as he approaches his release date?
Yes, and he'll need to report to 276 Memorial. Miss Wood did send me his address. Is it 3018 Middleton Road, Mr. Stanley?
Yes, ma'am.
Apartment 255?
Yes, ma'am.
Okay, just make sure you ask them for probation's address. It's 276 Memorial Drive. And just report within 48 hours of your release. Everything will be in the system, okay?
Okay, thank you.
You're welcome.
All right, that is it. Thank you.
All right. Can I wrote my number down for you?
You may. Thanks for the off day. We owe you one.
Okay, thank
Okay.
you. Thank
You're
you so
welcome.
much.
Good luck
You've
to you,
been
Mr.
great.
Stanley. You're great.
Thank you, Ms. Rivers. We're done for the day. Thank you, Ms. Tucson.
Thank you.
I will see a lot of you tomorrow. I think we've got more stuff. But we're going to talk about the trial calendar now. Where's Feely and Abate?
I have their announcements, Judge.
Abate's?
Yes, I have an email that he's on the thread, so yes, but I think he's coming, but I do have Ms. Feely's announcements on that.
Okay. Because some of them aren't, like Muckle isn't, that's not a Feely case.
Oh, you're right. Sorry. It's been a long day.
Yeah. In fact, let me see. I've got a kid sitting at home. Make sure the house is not on fire. Do you know if Mr. Abate is coming back?
Ms. Nix, can you reach out to Adam?
Yes.
Thank you.
Is that his weird missile beverage right there? So he'll be back. All right, well, we'll jump over his cases. I don't mean to make you all, Ms. Rios is never gonna come back. Tell her it's not normally like this. It is not, it is not. It is so unfair. Normally final plea, like there are 2 pleas and then a bunch of things are gonna go to trial and they end up resolving, but, and we just, the Cozart and Mayberry thing threw us out because those should have been Emerson pleas, but anyway, it was a productive day. It's not always like that. Thank you for contributing to the productivity. Let's jump to, gosh darn, the first 5 are all, there he is. He's in his after hours gear. Woo!
No air in the DA's office.
There's a lot of air in the DA's office. It's just not conditioned air. Yeah, we were just asked to, oh, let me do this. Hold on one second.